Yeah, you know what time it is. It's time for the Darrell Brooks trial. Darrell Brooks, he's going to jail. Darrell Brooks trial. Yeah. Darrell Brooks trial. He's going to jail. He's going to jail. Darrell Brooks trial. Yeah. Today is going to be a crazy day. We're going to hear like 6 hours of jury instructions followed by closing arguments where Darrell Brooks speak. Who knows? I have no idea, but you know who's really waiting for Darrell Brooks to be sentenced? His name is...
Yo, what's up? How you guys doing? You like my morning song? That was I thought that was very impressive. I mean, the skill and artistry that I exhibit every time I open my mouth is something. Open my mouth to sing. So, I can't fucking deal with today. Already, today has just been one of those days. I decided that I needed to get a new wedding ring because I can't wear my wedding band. I keep it on my keys, but I can't wear my wedding band because it's too small for my fingers now. So I need to get a new one. However, I don't know what size I take. I don't even know what size this band is, and they don't write it on the band. So I have to go get it sized. Can you believe this shit? I have to go get it sized to figure out what size. What is going on here? Why is that all moving all around? Why is it moving? So yeah, I'm going to get a new wedding. Well, I'm going to go get sized, and then I'm going to get silicone rings instead because I can wear those when I powerlift. Because with powerlifting, we have these little things. The reason why I took it off is I don't want to deglove my finger because if it gets caught on the bar, it'll pull all the skin and muscle off my finger. So typically I don't wear it there, but there's no sound yet. Eventually the sound will come on. I am in a good mood because of, I was watching bloopers this morning, and I like bloopers. Many of you guys who have been watching my show for a long time, you know that. But yeah, today is going to be an interesting day. We're going to hear 6 or 7 hours of jury instruction. How come it appears that he's speaking, but there's no audio? We're going to hear about, they're estimating anywhere between 4 to 6 hours of jury instructions with several breaks in between. And then we're going to hear closing arguments. The state's going to go first. Darrell Brooks he stated yesterday he's not going to make a closing argument, but we don't know whether that's true. He did say that he was going to talk about jury nullification, to which the judge completely lost her shit.
14th Amendment due process rights.
So now he's talking, so I'll shut up. You're
make
welcome.
A reservation for those rights, especially, but all rights at this time.
The record to reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is appearing today in street clothes. He has a dress shirt and a tie on. He's also wearing a mask.
And I don't consent to being called that name for the record. As this paperwork I accept for value in return for value, as it does not state the correct name. It states the name of my client, the straw man. I am not this name in all capital letters. I do not identify by that name, nor do I know that individual.
Your objection is noted. It's baseless in law and fact, and that is simply a caption on a pleading on
is not my
the
name.
final jury instructions.
That is not my name.
Oh, that should be a song.
All right, the record
That's
to
not his
reflect,
name. Yo.
Mr. Brooks, I'm talking.
That's not his
The record to reflect that at 3:23
His name
p.m.
is Darrell Brooks.
All of the verdict forms were printed off and provided to Mr. Brooks. I also provided him with an excerpt from the bench book on closing arguments. I left a copy on the state's table as well, and a second copy on the defense table today as well, so that I thought that would be helpful information as we are about that time in the proceeding for the parties to give their closing arguments. Of course, prior to that, the court will be reading through the final jury instructions. The parties were also given the updated version following the jury instruction conference yesterday as well. The total number of pages for that is 107. The court will be reading from the first 73 pages this morning. I do anticipate having to
Insane
take
in the no name.
one or two
Insane
breaks
in the
before
brain.
I complete all of that. My plan is to do that and then take the lunch break. And then when we come back from lunch to have the parties provide they're not opening, they're closing arguments. And then following the closing arguments, the court has the final jury instructions.
Patricia,
which go
you were
through,
there.
the
You should have
closing
held up a sign
instruction,
that said Citizen Stringer.
Instructions 460,
You're awesome.
484, and all of the verdicts. And then the instruction to the jury 515 about their verdicts needing to be unanimous, and then selection of a presiding juror. The very last page, 107, actually is not read until the close of the case and only following receipt of verdicts or some other type of disposition that would result in the conclusion of the case. It's the instruction after the
You know, that's the thing that pisses me off too. Those jurors are only getting like $25 a day to be there. A day, which is bullshit. That should be updated. And I understand, civic duty and all that shit. Duty. I said duty. But yeah, that's fucked.
instructions.
It's fucked.
And the parties have an opportunity to give their closing
All YouTubes are on.
arguments.
It's probably
Your Honor, accept for value and return for value any documents that you just alluded to. I have not seen them.
Mr. Brooks, if you haven't seen them, that is by your choice. They were provided to you. I know on multiple occasions yesterday you threw items into the garbage can. The court retrieved the final jury instructions. I personally didn't. I had someone do it, had them placed on the table this morning, and any other items you threw in the garbage.
So is that the paperwork that I had to stay here for over an hour for?
Sir, I'm not going to discuss any further what we did during the jury instruction conference. The jury's going to be brought
Jury
out a
instruction
little
conference?
bit later.
There was a conference. We talking about the proceedings from yesterday, or after you had told us we recessed
Mr.
for
Brooks?
I'm referring to after you called recess for the night yesterday. That's what I'm referring to.
Those
I was put in
documents.
the holding cell for over an hour because they said it was some paperwork that needed to
That
be.
is correct, sir. You were kept there in order for my clerk, who had to finalize 76 verdicts, 2 each, 1 not guilty, 1 guilty, and provide those to the parties.
Is that
And so
the-
that's why you were kept there, so those could be handed to you. My understanding is they were. I would need a bailiff to confirm for me whether he took those back to his cell or if they were put on his desk because he left them in the holding cell.
Left them in what holding cell? In here?
this fucking shit never
There's
ends.
paperwork to see if they're on here.
The judge
What
doesn't
holding
have
cell
any
are you
patience
referring to,
anymore.
Your Honor?
Behind the door.
I didn't leave anything in that holding cell. I was just trying to figure out why I was in there so long.
Are those the verdicts?
Yeah.
All right, he has those then. Thank you.
Is this the paperwork that was just put on my? It was paperwork on the desk when I came in. That was on top of my folders.
You got it last night, fucker.
Mr. Brooks, I know that you were given the opportunity to take them to your cell because that is what I was advised. Whether you did that or not, I don't know.
That's
But they
not what
are
I'm.
also on your desk now.
I accept for value and return for value any documents.
We did discuss all of the jury instructions and the verdicts yesterday.
So what was discussed when I was in the cell for over
There
an
was
hour?
no discussion, sir. The court was in recess. Madam Clerk was simply finalizing the paperwork based upon the discussion that was held on the record in open court yesterday.
I was told that I had to stay there per you.
Yes, so that we could provide them to you and you would have an opportunity to take them back to your cell
But
should you wish
can
to
they have
review
been
them.
delivered to the jail?
All right. I don't believe there's any other preliminary issues we
There are.
need to address other than an advisement I will have for Mr. Brooks. But let me turn to the parties and ask if there's anything preliminary to this phase of the trial, which is the jury instructions, the verdicts, and closing arguments from the state.
No, Your Honor, thank you.
All right, anything else from you, sir?
Yes, there is. Yesterday,
Subject matter
stressed to the court
jurisdiction.
numerous times about me not understanding the proceedings, and essentially how decisions are being made on my behalf without my understanding or giving consent.
You
Court
guys
made
better hit
various
that.
rulings.
Whoa. Do I only have one like on YouTube? That's some bullshit. Hit that like button. Do it now. Now.
Bubba said do it now. Darrell. Pick up that soap, Darrell.
The record will indicate when those were made and where you were.
I can't see the record though. How am I supposed to know what the record will reflect?
I can't see the record that way.
Sir, the decisions were made yesterday. I'm not revisiting them today.
Get him,
They
Judge.
need to be revisited, and it also needs to be talked about. Subject matter jurisdiction that has yet to be proven for the record.
It's already been proven.
I'm still
to the
trying to
record.
understand, Your Honor, how
I'm trying to understand
you made a judicial determination
Mary Evans, no,
on
I
my
will
behalf,
not.
which I did not give consent to, as you say, I forfeited my right to testify, which I never did.
No,
I never
Mary.
said I wanted to. I never said I didn't want to, but that decision was made for me. Also, the decision for the defense to rest its case was made for me, which I did not consent to, nor did I say I was ready to rest, or nor did I say I was ready to rest. I'm trying to understand how all these decisions are being made without my consent, without me waiving any rights. I'm not understanding how, because none of my answers were unresponsive. I just didn't answer the way that Your Honor wanted me to answer. But I stressed yesterday, if I don't understand something, how am I supposed to answer a question that I don't understand fundamentally? It's not me saying yes or no, and it's not me saying, okay, I want to waive this or that right. And I'm not trying to make an argument with you in any way. I'm just seeking to understand how these decisions are made. If I'm letting the court know and I'm putting the court on notice, hey, I don't understand this or I don't understand that.
Any other things? Otherwise, I'm prepared to address each one of those.
Yeah. There was a mention of if there is a conviction in this matter, there is a mention of sentencing, which I'm assuming there'll be some type of people may want to speak. I know if there is a conviction on my half, people would definitely want to address the court. There'll be a lot of affairs that need to be put in order, obviously on my side. If it pleases the court, if there is a conviction in this matter, I would like the sentencing to not be so quick. I'm asking if it pleases the court for the sentencing to be held off into a later time, not a day or two or a week, just so that
Fuck
affairs
that.
can be put in order properly, and so that the people that
Fuck
want to come
that.
and speak will have the opportunity
I
to
wanna
address
speak.
the court.
I want to
If
speak.
that
Fair
pleases-
request, sir.
If
Okay.
that pleases.
Ooh, can I
That's a
speak?
fair request. I thought about that some more overnight, that in the event there is a conviction, that I would like to give the parties an opportunity to do that. I have no idea how many people would want to speak. My inclination would be, again, and this is not set in stone, if there is a conviction on any of these counts, I may ask the parties to just come back in on Monday, October 31st, with kind of a proposed plan of how many people do you think will speak on your behalf? How long do you think it will take? So that I can look at my calendar and then set aside the appropriate amount of time. I certainly don't want to rush anything, and I think that's a fair request that you're making.
Thank you.
All right. So with all of that then, sir, subject matter jurisdiction, I decline to address that further. I stand by the written decision that I've made previously. As far as the rulings made yesterday regarding your ability or inability to present further testimony and witnesses and to testify yourself, the court did make various rulings and findings that you had forfeited your right to do so by conduct. I'm not going to further explain the law or these prior rulings to you. I stand behind them, and I believe I made a very, very clear record. So to the extent that you are asking me to reconsider any of that, that's how I would interpret your statements here today. I decline to do so.
So, Your Honor, would that be, that's still not, I have no understanding to why I wasn't given the opportunity to place certain things into evidence. I have virtually nothing, zero evidence that I was able to place into evidence, nothing.
I disagree with that, sir. You called, I think, 9 witnesses on your behalf on various issues, including the honking of the horn, the window tinting. You cross-examined many of the state's witnesses about police barricades and the presence of police. So you did present evidence.
I'm speaking to the terms of everything that Your Honor asked me to do. You told me to put everything that I needed to present to the courts in writing. You made that ruling. You told me that's what I needed to do.
She said there's not going to be a sentencing determination until at least Monday.
You may have interpreted that. I did not require you to do that. As far as evidence in the case, I very expressly told you there are rules of procedure and rules of evidence that govern exhibits, testimony, witnesses, etc. What I told you is that any requests that you have related to the case, if it's a motion, be put in writing. I specifically referenced the statute 80201 regarding how a motion is made and what it should contain, meaning it has a very express request for relief and states the law and the facts upon which the request is being made. Again, I'm not going to revisit the prior rulings. I stand behind them, and to the extent that the record does not have, meaning the record before the jury and the evidence does not have certain pieces of information, evidence, or testimony that you wanted to present, you forfeited that opportunity yesterday based upon your conduct.
How did I forfeit the opportunity?
Again, I'm not going to revisit that, sir. What I will tell you is this.
How did I forfeit
This
the
jury is
opportunity
here.
to be able to place into evidence?
Mr. Brooks, I'm
things that
not
need
going to
be-
debate this further.
I'm not trying to debate, I'm trying to understand.
To respect the fact that I've made rulings.
Your Honor, that's you
It's
made
not
a
my
judicial
job to
determination.
explain them
You made
to
it.
you.
I'm not asking you to explain anything. You're misinterpreting what I'm trying to ask you and trying to tell you. You're misinterpreting it. With all due respect, Your Honor. When you tell me this is what you need to do, I'm going to take it by what you're telling me that I need to do. If I needed to make anything request-wise or anything that I needed to present to the court, it has to be in writing. You told me to do that. I did it. You also brought up when I asked numerous times before when would I have a chance to present things into evidence, you told me we were not at the evidentiary phase of the trial yet. So I took that as saying, okay, well, at some point I will have the opportunity to place things into evidence that need to be put in evidence for the record. So I'm not understanding how a decision can be made for me to actually forfeit being able to put things into the record that need to be placed into the record. All these things are things that, quite frankly, allow me to put on a defense, things that need to be known, things that should be in the record, as far as filings, as far as ICFs that I was told to by you to address certain ICFs either to you or to the clerk of courts, which I did, and received copies for all of them except until last week. It was a few of them that I didn't receive copies for that I'm still wondering why I haven't received those copies when I received the copies of all the ones before that. But in terms of that, I did what Your Honor asked me to do. And these are things that were part of my defense that needed to be placed into the record. So where my confusion comes in is not being able to place those things into the record. Things
Mr.
that
Brooks,
things
I'm gonna
that
cut you off
clearly help my
because
defense.
I stand by my ruling. I'm not revisiting it. To the extent that you claim lack of understanding or your lack of consent, it's been made abundantly clear on this record your position on that. I'm not revisiting it. I'm further advising you that when this jury comes out, I expect that you will honor the decisions that were made, not agree, but you will honor them and not interrupt the court or these proceedings as I instruct the jury.
So how am I supposed to put these things in the record that need to be in the record?
Mr. Brooks, I'm well aware of the effect my ruling had, and I'm not going to debate it with you further.
I just want to know, how am I supposed to get these things on the record? How am I supposed to, because the filings that I gave, you actually filed and gave me the copies back. So are those in the record?
Mr. Brooks,
I'm
no longer going to talk about this.
I'm just seeking to understand.
Mr. Brooks, I cannot explain procedure or evidence
The filings that
or
I
the
filed.
rulings or
I'm
the
asking
law
a question,
to
Your Honor.
you.
I'm merely asking a question. The filings that I presented to Your Honor.
Any filings
For
with
the
this
court.
court are in the court record. That does not mean they're evidence, sir. And I've told you
That's
that
not what I'm
previously.
asking. I'm asking, are the filings part of the record? The filings that were filed and timestamped, that were notarized, that I presented to the court, all the filings, the appearance bonds, the statement of particulars, the notice of special appearance, the court docket sheet, your oath of office, everything that I tried to present into the record. How am I not able to make them part of the record?
Sir, they were filed because you presented them to the court during the course of this case. Anything that was not offered as an exhibit and received during the evidentiary phase is not evidence in this trial.
That's what I attempted to do, and you told me that I couldn't. You told me,
Mr. Brooks, I am bringing this jury
Your Honor,
out.
with
Listen
all
to me.
respect, you told me that we were not at the evidence. When I said I have exhibits as well, I have stuff that I want to put into the record. I even asked, I said,
Mr.
may I
Brooks,
give an offer into evidence?
I'm going to stop
these
you
things?
once again. I'm not going to have this discussion and debate. The evidentiary phase of this trial is closed.
It should
we are
not
now
be, though,
at the
Your
jury.
Honor.
I understand your lack of consent. Your objection
So when would I
is
be able to
noted
put?
for the
When would
record.
I be able to put vital information into the record, which I haven't had the opportunity to
That
do?
opportunity has closed for you, sir.
So you saying basically you're prejudicing my defense by me not being able to present things into evidence, offer into evidence, filings and important paperwork and documents.
Mr. Brooks, and you
How am I
forfeited
not-
your right to do that by your conduct yesterday, and I stand behind that decision.
I asked-
I'm
I
going
asked
to do the
before
following,
yesterday,
sir.
Your Honor.
I am
I
going to
asked
do the
this
following.
before yesterday.
You have not honored my request to you that you cease debating me on prior rulings
I'm not trying
of
to
the
debate.
court.
I'm trying to understand why my due process is being violated.
Mr. Brooks, the record speaks for itself.
No, the record
I am
does
going
not.
to take
it
a
does not.
5-minute recess. When I come back out, the jury will also be coming out. I'm advising you there will be no multiple opportunities where I give you to conform your conduct to the rules of decorum
Well, then
and courtesy.
just hold me in contempt, then, Your Honor.
You are
Hold me in
hereby
contempt,
advised
'cause I didn't even. I'm trying to
that
seek
if
to
you
understand.
start talking about subject matter jurisdiction or any of these other
It
issues,
needs to be addressed,
or
Your Honor.
in any way
We're not talking
interrupt
about subject matter jurisdiction.
the
We're
reading of
talking
the jury
about
instructions.
why my due process
I
has
will
been violated.
excuse the jury and you will be removed
Your
to
Honor,
the other courtroom.
We're talking about the 14th Amendment Section
I am
1.
taking a 5-minute break. We are
Your
in
Honor, I
recess.
don't
When
agree
come
to a
back out, the
estoppel.
jury
I
will
don't
be
agree
coming
to a
as well.
estoppel. Your Honor, as a
What the fuck?
I'm not ready for this to happen like this early in the morning, like his mouth running. You know, he's like, Your Honor, I'm not ready for a stopple. I'm not ready for a stopple. She's going to end up. Okay. Do you want to know what's going to happen? I'll tell you. The jury's going to come back in the room. Well, she's going to come back. He's going to be running it. She's going to tell him like 17 times to stop. She'll call in the jury. The jury will come in. He'll still be running his mouth. She'll then excuse the jury, send him to the other room. He'll sit there. He'll make a box fort. And then she will go through hours and hours of which he'll object. They'll stop it several times. They'll call him back in, shit like that. I got a phone call. I got to take it. Anywho. Oh, I got to update this thing too. Boom, boom, boom. Yeah, it's interesting. Interesting stuff. Someone said, oh no, the troll is back. Trolls are more than welcome here. I don't know how you could troll on this court case, though. I mean, technically, isn't that kind of what I'm doing? But outside of trolling the way I'm doing with the skill and excellence that I provide, I'm not quite sure how anyone... I just saw an email that I need to reply to, but where the fuck did it go? Where is this email? Isn't 5 minutes up yet? I thought 5 minutes was already up. Should have been up. Evelyn said, you clearly understand as much as Brooks. In regards to what? That's not very nice. Am I going to be streaming the whole case? Yeah, I've been streaming the whole case, and I will continue to do so. That is correct, Amundo. Where was this? Was this the Shopify? It's this one. That was a bit rude. I know. My gosh. Oh, you said the comment you replied to. Okay, she wasn't talking to me. It still was rude. Man, oh man. What order is that? This is 6 a.m. I was watching Steve's live stream when this happened. Yes, there were live streams. Oh, I should just put all these calls right on the thing. Anyway, I'll be right back. That was Progressive Insurance. They're like, we're calling about a change in your motorhome policy. Yeah, we canceled the insurance. We're not going to be using it for the next 6 months. I'm not going to pay to have it insured. It's just a waste of money sitting in a parking lot or my driveway. Where was that email? Why isn't he in jail? Doesn't he care when sentencing and does it change anything? No, I think because he'll go to prison. He's probably in a county jail right now. He doesn't want to go to prison. And while he's being sentenced, I'm assuming he'll stay in protective custody as well. You know what I mean? You betcha. You betcha. Anyway, guys, if you want to support the show, the links are over there to do it, or you can send super chats. We have a daily streaming goal, which you can see up there. It is an ambitious goal, $400 a day. The reason it's so high is because we have the studios that we rent, all of the streaming infrastructure, all of that stuff. But if you like our coverage of these things and you want us to cover more, please consider contributing up above. Make sure you like, share, and subscribe if you're watching on YouTube and Facebook. You can hit the thumbs up button, I think, or the like button on Facebook. I don't know how that works on Facebook. But you can also send stars on Facebook. However, I can't see them. The easiest ways to do it are send super chats or any of those links over on the side, and then I can update that up there. Twitch bits too, I can't update that. Unless it updates automatically. It should with Twitch and Facebook. Someone want to send a $5 super chat and see if that thing updates automatically? I don't know. It should, but I don't know. Anyway, here's the court, so I'll shut up.
It has yet to be proven.
I told you he was going to keep going.
And upon your refusal, that would be looked at as dishonor.
I'm not addressing it. The jury's coming out.
So is that a tacit agreement that you don't have to answer any questions as a public servant, Your Honor? Therefore, that's dishonor. Are you going to honor your oath of office?
Stand. I'm not addressing it further.
Are you going to honor your oath of office?
All rise.
So I'll take that as a tacit agreement that you're not going to honor your oath of office.
All right, I'm going to have to excuse the jury.
Oh, fuck. Didn't I call this shit? I called this. I told you this was going to happen. She's excusing the jury. She's going to remand him to the room off to the side where he's going to remain for the entirety of the jury instructions.
I warned you that if you made any interruptions when they came out, you would be removed to the courtroom. That's what I'm doing right now. You're forfeiting your right to be present in this courtroom unless you can promise me right now you'll respect prior rulings of this court and not interrupt this next phase of the trial, which is the court reading the jury instructions without interruption from you. Can you do that?
Have I acted in dishonor, Your Honor?
Mr. Brooks, I very
It didn't
expressly
update, so
warned you.
update it.
Have I acted in dishonor?
You have disobeyed a direct order from this court.
Have I acted in dishonor?
You have disrupted these proceedings.
I have not disrupted these proceedings.
Sir, can you
this
pledge
morning.
to me that when this jury comes back out, that you will remain silent and not reference things like subject matter jurisdiction, the court's oath of office, tacit agreements, or anything? Can you pledge that you will respect these proceedings and this jury by not interrupting?
Have I acted in dishonor, Your Honor?
I will ask you one more time. Can you pledge to be quiet, sir?
Why should I have to make a pledge, Your Honor? Have I acted in dishonor?
Because under Illinois versus Allen, I believe you've already forfeited your right to be here, but you can reclaim that as soon as you are willing to conduct yourself consistently with the decorum and respect inherent in these proceedings, which at this point in the proceedings, sir, all I am doing is reading through the final jury instructions. I do not want that process interrupted by statements by you that are frankly misstatements of the law.
If they're misstatements of the law, Your Honor, how come they haven't been proven for the record? And I'm asking, have
All
I
right,
acted
he
in
refuses
dishonor?
to answer the
Have I
questions.
acted in
I
dishonor,
have given
Your
him
Honor?
an ample opportunity to do so. He has forfeited his right to be present for the reading of the jury instructions, and he is to be removed to the neighboring courtroom. We will be in recess until that takes place.
Your Honor,
Thank you.
have I acted in dishonor?
I told you it was going to happen. I knew it. I knew it was gonna happen. I knew it was gonna
happen. I knew it. I knew it was gonna happen. He's going to jail. Do not collect $200. Oh. Darrell Brooks is a shithead. He keeps constantly annoying us and the judge, but we don't matter, she does, and she's the boss. She puts on that robe in the morning and she says, fuck Darrell Brooks, 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 fuck Darrell Brooks. He's going to serve 6 life sentences in jail. Yeah. Shout out to Michael and Kathy and Michael again. And he said, love the show, big dog. Shout out to you, Michael and Kathy and Michael and Kathy. Michael and Kathy and Michael. Michael actually takes the top spot because I'm adding them together. Look at that. Oops, I typed in the wrong one. Michael L. Michael W. He takes the top spot. Top don't know. Don't know what you don't know when you know what you don't know, yo. You know? Top dono, yo. I gotta update this too. Technically, we're not at 60. I started with 25 because I was feeling generous. So technically, we're at 45, but whatever. Whatever. Who fucking cares, right? This shit is gonna be a long fucking day. At least we won't have to hear Darrell Brooks chiming in the middle, you know, pissing off the world. What do you think's gonna happen? Do you think Darrell Brooks is going to request to come back in the courtroom right away? Because she kind of has to, based on Illinois versus Allen. She has to permit him to come back to the courtroom. Couldn't he just like say, fuck you, judge, and then she kicks him out, and then he's like, I want to come back, I'll act accordingly, and then she brings him back, and then he's like, fuck you, judge, right? Is that his game plan? I bet it is. Oh yeah, let's talk about Darrell's game plan. Yo, yeah. Don't drop the soap, Darrell. Don't drop the soap, but that's his game plan, to not drop the soap because he doesn't want.
Bubba. Hey, Darrell. Do you like being... I can't do this voice. It fucks me up.
What? Don't do it, Bubba, no!
Darrell, pick up the soap.
No, don't do it!
Bubba said, hey, Darrell, pick up the soap.
Was that too much? I think it may have been too much. Whatever. 3 FUs, you're out. Yeah. Too many energy drinks and coffee this morning? No, I'm only on my second cup. Second cup. That's the #1 hit right there. Looks like a big camera. Yeah, that's called a PTZ optic camera. It's fucking expensive. That camera right there is like an $8,000 camera. I would love to have one of those because they're trackable. So for example, like if I had a different studio, like if I ever made it big, I could take the warehouse section and just make it into a big like production studio, all green rooms. I thought about doing that, to be honest. If I made like stupid amount of money, that's what I would do is I would paint the walls and the floor and the ceiling green in the warehouse, and then I could just like do a whole live stream right there, and I could be like virtual set extraordinaire. But yeah, no, I'm not gonna do that. Someone said, why would it be a mistrial? It wouldn't. There was a part in time where I thought there was gonna be a mistrial, but it's not. Any of you guys looking for great coffee, go over to gratiscafe.com, gratiscafe.com. We have some of the best fucking coffee you've ever had. True
Record
story.
to reflect that Mr. Brooks has been placed in the other courtroom. He is presently on mute so that I can make a record. I do need to confirm that the audio and visual equipment and system is working. I am getting a thumbs up from the bailiff. I'll just ask Madam Clerk to confirm with the clerk that's over there as well. I would note Mr. Brooks has the headphones on. This court certainly doesn't take pleasure in removing Mr. Brooks from this courtroom once again. We are at an important stage of this proceeding where the court needs to instruct the jury concerning all of the law that will guide them in their deliberations. As I've put on the record previously, the total pages comes to 107. I will be reading this morning through page 73 prior to the parties given the opportunity to make closing arguments, and then reading from pages 74 to 106 following that. It is very important that the court do this without interruption. Yesterday, this court held a jury instruction conference where both parties had a full and fair opportunity to raise objections regarding any of the proposed jury instructions, to make requests regarding inclusion of any jury instructions that the court did not include, as well as review all of the verdict forms. There's absolutely no reason for there to be an interruption or an objection to this process at this time. The court spent the better part of 25 minutes this morning with Mr. Brooks raising issues and prior rulings that this court has spent an abundant amount of time on, including subject matter jurisdiction. He continues to claim he did not consent. That's been noted for the record. He continues to claim that he has a limited or no understanding of prior rulings and decisions of this court. I repeatedly advised him I would not be revisiting these issues, that I wanted to go forward with the jury instructions, and repeatedly warned him that any interruption once the jury came out would result in his removal from the courtroom. Again, I take no pleasure in doing that. I prefer that he be here, but frankly, the decision I made here today, with the speed at which I made the decision here today, is not only to preserve the dignity of these proceedings, but to do so in a way that avoided the court admonishing Mr. Brooks in front of the jury. This, of course, comes on the history in this case with the repeated removals that this court has had to undertake with Mr. Brooks, given his conduct and his behavior in this case. I am currently being advised that he would like to come back. That, of course, is
I fucking told you.
Something that I will give him. As soon as I make my full findings, I will pause, and he will be brought back into this courtroom so that he can be in attendance when the jury is brought out. Of course, my decision that I made this morning to remove him is based on the authority from Illinois versus Allen. I'd also note that State versus Anthony talks about the Allen decision along with State versus Vaughn. Those are two state court decisions. Clearly, even though Mr. Brooks was using a mild-mannered tone of voice, he directly disobeyed the court order that he not interrupt once the jury was brought out. He did that immediately upon the first juror walking in. I believe only a few of the jurors even walked in. He was continuing to talk. I immediately removed them from the courtroom to minimize the impact of his disruption. It was clearly disruptive, but again, he is asking to come back, and I will honor that request. I will further advise him, though, that should he interrupt during the jury instruction phase of this trial by either objecting or raising issues that have no bearing on the advisement to the jury by this court of all of the jury instructions, I will consider admonishing him in the presence of the jury or simply removing the jury so that then I can admonish him and then making the appropriate record. All right, with that, since he's asking to come back, we will take a pause. We'll recess. We'll come back in when he is set up in this courtroom. Thank you, everyone.
I told you this shit was gonna happen. Yeah. You know it. Well, let's talk about it. Well, Darrell Brooks, he's a shithead. Darrell Brooks, he's a shithead. He's gonna delay this trial as long as he can, but maybe he will get admonished in court. That's a hard one to rhyme. Oh yeah. Oh yeah. Oh yeah, Darrell Brooks is a shithead. Oh yeah. Oh yeah. Oh yeah. Darrell Brooks is a shithead. Yeah. Darrell Brooks is a shithead. Don't you know? I bet you did know. And if you didn't know, now you know. You know? I wrote that. It's shit's copywritten, so don't fucking copy it. Alright? Playa? Yeah. All day. Earth. Steve Oatley, will you accept my Cash App, please? I think you probably did it to the wrong person. Hold on, I'll check. Nope, I don't have anything pending. You probably sent it to the wrong person. All right, so let me say what's going to happen next. So they're going to bring Darrell Brooks back into the courtroom. He's going to start arguing back and forth with the judge again. The jury is going to come in. He's going to get admonished in front of the jury where she's going to yell at him. And it's not going to actually do anything because he's going to keep doing it. And then she's going to kick him out to the courtroom. And then as soon as he get all set up in there, then he's going to be like, Judge, I want to come back. And then she has to bring him back. And then he's going to do it again. And these 4 hours of jury instructions are going to spread out to be 17 days. Yeah. But they can gag him in the courtroom. Doesn't she have the power to, like, appoint a public defender, gag him, ball and gag him right in the courtroom? And, you know, I'm sure, you know.
I'll help ball and gag. Darrell Brooks, drop the soap, bitch.
But yeah, Bubba said he's willing to help gag Darrell Brooks. Yeah, which is not something I want to see. You like my song? It's very good. How many coffee drinkers do we have in the chat right now? How many coffee drinkers? Type 1 if you drink coffee every day. Type 2 if you suck and do not drink coffee every day. Ready? Go. 1 and 2. Let's go. Let's go. Do it now. 1 for coffee drinkers, 2 for not coffee drinkers.
Thank you, everyone. Please be seated.
Lots of ones.
We'll have the jury brought out then.
Okay,
Record
so
will reflect we are...
here's what I'll do. At the end of this show, at the end of this live stream today, I will give away a 32-inch flat screen Roku TV to one lucky person who makes a purchase of coffee from gratiscafe.com. Whole bean or ground, available on every single flavor. Do it now. Your orders will also ship super quick. Gratiscafe.com. I will pick one person and you'll win a 32-inch flat screen television today. Free shipping on all orders. Yeah. And if you order a sweatshirt, you have 2 entries into the giveaway.
Have I acted in dishonor, Your Honor? You held me in contempt without me being in dishonor. How have I dishonored the court? Have I acted in dishonor? Have I rose my voice or argued with Your Honor? Have I disrupted the
Mr.
courtroom
Brooks,
in any
you're
way?
back in this courtroom at your request. The jury is coming out.
I never should have
Please
been.
be respectful of their time.
I
and this
have
process
been. They weren't even
and the
out
dignity
before.
of the proceedings.
They weren't even out before when I was trying to address what needed to be
Mr.
addressed
Brooks,
before they came out.
You're just
Am I
attempting
acting
to
in
disrupt the
dishonor?
proceedings.
Am I acting in dishonor? So that's a tacit
All
agreement
rise
that you
for the
don't.
jury, please.
It's a tacit agreement that you don't have to answer questions as a public servant, right?
All right, the jury
No
is
jury's
not
out.
Mr. Brooks,
No jury's
move the
out.
door.
I was trying to
Mr.
address
Brooks,
this
they
before
are
they
right
came
outside
out.
this door. I am not going to do this with you this morning. You either
I'm not
abide by
doing-
these rules
Am I
and
acting in
stay
dishonor?
quiet,
Am
or
I
you will
acting
be
in
in the other
dishonor?
courtroom.
Am I acting in dishonor?
Yes, you are acting
How?
in dishonor.
How?
You are disobeying the direct order of this court to respect the decorum and the dignity of these proceedings. You are merely attempting to delay.
I don't care what you think. That's not accurate.
Mr. Brooks, I am having this jury out. And
And-
if you
and you're
say
making-
one word when that door opens,
You're making a tacit agreement.
then you will forfeit your right to be present.
So you're acting in dishonor, then, Your Honor.
All right, the jury may come in.
You're acting in dishonor by making a tacit agreement that you don't have to answer any questions as a public servant. You're not holding up to your oath to protect the
All right, the
Constitution.
door is open and he's talking.
Okay, so you're gonna hold me in
All right,
contempt?
the jury cannot come in.
Are you gonna hold
All
me in
right,
contempt?
Mr. Brooks is going to be removed. We're in recess until that
How
can
am
be
I
accomplished.
acting in dishonor?
Unbelievable. I told you this shit was gonna happen. I told you. Why did I know? Because I'm a fucking genius. Yeah. Yeah, I gotta get different music. Ready? This is a song about how fucking smart I am. Ready? It goes a little something like this. I'm so smart. I'm so smart. Okay. Yeah, that's enough. Anyway, so
What I'm doing today, just for everyone. So, if in case you didn't know, we're opening the world's first free coffee shops across America. We have a coffee company, gratiscafe.com, gratiscafe.com. If you order any bag of coffee today, or a sweatshirt or a t-shirt, but if you order any bag of coffee today, plus you'll see about the what we're doing and how we're giving away coffee. It's amazing. But if you order any bag of coffee, $17.99 for a 12-ounce bag, that includes shipping. I'll choose one person who places an order today at the end of this live stream, so right around 4 or 5 o'clock, and we will give away a 32-inch flat screen Roku television, like straight up. So do it, and yeah. And if you want to be awesome like Jake, you can use Cash App, Venmo, or PayPal, which are on the side. Jake said with a $30 dono, he said, P.S. My blood type is caffeinated. So is mine. So is mine. Look, we already have our first coffee orders today. French roast and breakfast blend. Hell yeah. Fucking phone, dude. Today it won't stop ringing. See, they hang up. They know they're doing wrong. Uh-oh. What is this? I have to accept a Cash App. That's weird. Accept confirm. I wonder why it does that. So that's another one, another $10 one. Do. So what do you think? You think he's going to be kicked out to the courtroom and then he's going to come back in the courtroom and then he's going to be kicked out of the courtroom again and then he's going to come back into the courtroom and then he's going to come back into the courtroom again and then he's going to be kicked out and then he's going to want to come back and then he's going to be kicked out, and this should have already started. They should have already started reading to the jury, but they're not going to get to because he's going to keep doing this over and over and over. I don't know if she can legally keep him in the courtroom. That's what I'm unsure of. Boop, 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 boom, boop, 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 boo. You know what I'm saying? I don't know. So far, if you want a chance, and all of our coffee, like if you like extremely dark roast, we have a new roast there, Italian. Oh my gosh, the beans are as dark as this hat. It's the darkest. And we have whole bean and ground. Even the ground is still very dark, but we have whole bean and ground in every single blend that we have. You know what I should have done? Can I bulk edit? Edit products? Can I do it here? I want to change the... it's not going to let me do it. Fuckers. Columns, quantity. Yeah. See, it's not. I'll just go into each one. But because I don't want to sell if I'm out of stock. And we're not really close to out of stock for anything. So, but I'm just going to adjust these each one by one. All right.
Thank you,
She's
everyone.
back
Please
again.
be seated. We are back on. The record appearances are as they were before. The record to reflect that Mr. Brooks is now in the other courtroom. I currently have him muted so that I can add to the record. I have confirmed he can hear and see as well. I would note he does have the headphones on while in that courtroom. He just lifted them up as well, or at least part of them.
He wants to come back
this
now.
This court has previously relied upon the U.S. Supreme Court case of Illinois versus Allen, wherein the United States Supreme Court indicated it is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. We believe trial judges confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. We think there are at least three constitutionally permissible ways for a trial judge to handle such a defendant, including one, bind and gag him, thereby keeping him present, two, cite him for contempt, or three, take him out of the courtroom until he promises to conduct himself properly. I understand Mr. Brooks is waving to the court. I'll address that momentarily. But the bottom line is there is a history of repeated disruptive behavior by Mr. Brooks. I warned him after he came back in. The first thing he wanted to do was address subject matter jurisdiction. That is, from my perspective, simply a tactic on his part to delay these proceedings, to disrupt these proceedings. I've issued a written decision. He has yet to appeal that written decision. He has that right to file an interlocutory appeal. I would also note at no time during this case has jurisdiction ever been challenged when he was represented by an attorney. So I warned him. Given the importance of the proceedings and the need for the court to advise this jury without interruption, he was removed once again. I will not bring him back into this courtroom unless he is willing and pledges to conform his conduct and pledge to not interrupt by making any statements when this jury is present and during the court reading all of the jury instructions. I will unmute him so that he can indicate what he would like to say to the court. You are unmuted, sir. Go ahead.
Can y'all hear me?
We can.
First of all, at 9:25, I would like the record to reflect that the prosecution was making disparative remarks and gestures in pursuant to what just happened. I don't appreciate it, and I think that that is very disrespectful. For the record. And again, I'm trying to figure out how did I act in dishonor to be removed from the courtroom? How have I acted in dishonor? This is a whole nother. How have I acted in dishonor?
All right, I'm going to mute Mr. Brooks. I'm not going to answer that question. I've made my ruling as far as anything that was done by the prosecution. I was not in the courtroom. The jury was not present. Whatever happened, if anything at all, was done outside the presence of the jury. If there is anything the state wants to put on the record right now, I'll give you that opportunity. Otherwise, I am going to bring the jury out, Mr. Brooks. If you want to come back into this courtroom, you need to write your request down on a piece of paper, and when you do that, pledge to this court that you will not interrupt these proceedings. Without that, I will not bring you back into this courtroom. Anything the state wants to put on the record?
I have a question, Your Honor. I don't have anything directly in response to Mr. Brooks' last statement.
All right, go ahead.
Yesterday afternoon, when we had the 4-screen up, there was a wider view of the courtroom so that the jury box could be seen. Is that possible to do again?
Yes, it is. We can take the witness stand camera and pull it out so that he has a view of the jury box as well. I can't angle it, but I can do that.
And for the record, when you do that, then he can see the jury box. So I would ask that that be done before
Right.
we.
Please do that, Madam Clerk. Well, it's not on Zoom, and so the Court TV would be able to fix the camera on me and not on the screen so that they don't capture any of the jurors, and they're directed to honor that and do that. Same thing, obviously, with our still photographer. If there are any images captured of Mr. Brooks, as you can see the camera is being zoomed out, you would need to avoid capturing members of the jury.
Thank you, Your Honor. The record should reflect you have zoomed out the camera, and it looks
Right.
like about 90% of the jury box can now be seen in the view if Mr. Brooks chooses to
Right.
do that.
Mr. Brooks, I'll unmute. What is it you would like the court to address?
How can you rule that I don't have the right to be present in the courtroom?
All right. I've answered that previously. I've made my findings under Illinois versus Allen. He continues to interrupt, even if it is by asking questions. I've made my ruling. The record stands. It speaks for itself. And I intend to have the jury brought out. I need one moment before I do that. And so I'm going to just take about a 2-minute recess.
She's got to go powder her nose. Yo, yeah. Shit is getting crazy up in her today, huh? Crazy. Now, what's stopping him from just writing down on a piece of paper that he'll conduct himself with decorum and then not conducting himself with decorum? You know? I don't know. It's very peculiar. I have no idea. Haven't the faintest. Ay. We're going to have to wait and see what's going to transpire. Send fulfillment request. Yeah, we got some Italian roast going out. I haven't tried the Italian yet. pumpkin spice. All of these orders will go out tomorrow morning as well. Just so you know, anyone who's placed a coffee order today, and there's been a lot of you, they'll all go out tomorrow. And it's still coming in. So for anyone that doesn't know, I'm doing a TV giveaway. If you place an order on gratiscafe.com for ground or whole bean coffee or a sweatshirt, I'm going to choose one person at random. So this is not a raffle, but I'm going to choose one person at random at the end of this live show today. And that person will win a 32-inch flat screen Roku television that I just give to them for free. No purchase is necessary. It's just like, call it, they're like mystery coffees today. Whatever, it's fine. The IRS may get a little ticked off, but whatever. It's under a certain amount. I know what I'm doing. But yeah. Someone said Kona coffee is one of your faves. You want to get banned, don't you? No, I'm just kidding. Any new updates from the Penn State situation last night? No. No, like I said, I don't care about the news anymore, so I don't really follow the news. So I'm not seeking out to get more information of stuff. I don't want to anymore. And I tell you what, I'm so much happier. I'm so much happier now. So no, I didn't follow up on the Penn State stuff other than my video last night. And that YouTube video that I put out where I was talking about it, and it's also available as a podcast. You can download it on your podcast player of choice, the Rational American podcast. Matter of fact, I don't know. With this link, does it take you guys to an app? Like, can you download this podcast on Google Podcasts, the link that I just put in the chat? Holy shit, my phone will not stop. Oh my goodness. What a day. How long is the recess? It was only supposed to be 2 minutes, but they are taking their sweet ass time, right? Right now, you have a 1 in 15 chance at that 42-inch Roku television. Someone asked what brand TV it's going to be. Well, I just ordered one for somebody else, so I could tell you. A TCL probably. And TCL is a good brand. That's who we have at home. We've got a 70-inch, 49-inch, I think, and then two 32 inches for the boys. Actually, is the one maybe the one in our room's a 43, which is part of the problem. I need a bigger TV. You know what I'm saying? You know what I'm saying? Heck yeah. Supreme Dark is victory or death. Yes. Yes. So our old coffee. So if you want to know what the types of coffee are, I'll tell you. The medium house roast is the Awake Not Woke. The breakfast blend, obviously, Wake Up America. French roast is Pardon My French Roast. French vanilla is the same. Harlem's Finest is the same. Italian blend is brand new. That's a very dark coffee. Supreme Dark is victory or death. And again, medium house roast is Awake Not Woke. So that's our best seller. And then, of course, we have the pumpkin spice, which was Trumpkin. You know? So questions for you, Steve. People that ordered the September boxes, there's still a chance for win a TV as those as well. Yes, there are. And those boxes are coming out this week. I have everything else that I'm putting in them except for the mugs and the T-shirts. The T-shirts have apparently been shipped. The mugs, they were supposed to ship by today, but I haven't got a notice yet because I didn't even print them myself. I just had them printed. So I'm hoping that I get all of those boxes printed or all of those boxes put together, the September and October boxes, and shipped out by Friday. And then I'm going to be revamping the entire what is Pure Truth Coffee's website now, revamping that. It'll have a new domain that just goes with this show. And then the Rational American is going to be a clothing line that's affiliated with this show. So, and then like I'll total all of that total up there will also include anything that's purchased there. So like the goofy political shirts and sweatshirts and shit that I used to make, they'll all be on that site. So just bear with me a day or two, to try to get everything going. But yeah, can you remember when TVs were stupid expensive? They're much cheaper now. It's nice. It's nice. My favorite coffee blend right now, I'm drinking the Wake Up America breakfast blend, which is breakfast blend on the new site. But I alternate between the breakfast blend, the French roast, and then the medium house roast, which is the Awake Not Woke. Those are my three favorites out of all of it. I don't like flavored coffee, but the French vanilla is the best smelling coffee that we have completely. It smells delicious. And the pumpkin spice smells really good too. Yep. Flying High is like high caffeine, obviously. So make sure you check on that. You know what I'm saying? Is this a new one or is this the same one? This is the same one. It's weird because Venmo sends notifications late. Oh, you know what? I have to switch this because Jake the Rattlesnake is the top donation now via Venmo. And I wonder if I changed that. I don't think I did. So let me change this too. This is a long 2-minute break. She's probably speaking with other people to make sure that what she's doing is legal. At first, Steve said a 32-inch, then he said a 42-inch. I didn't say I'm sending a 42-inch. I said a 32-inch. I said we have a 42-inch in our home or 43-inch. But like I said, if you place a coffee order today, it'll ship out tomorrow, especially if you order the whole bean. Well, not especially. They'll all ship tomorrow because it shouldn't allow you to buy anything if it's out of stock. And I don't think we're out of stock on anything yet, but it shouldn't allow you. I should have stopped it because we're not doing pre-orders anymore because I just get too far behind with pre-orders. So I'm not doing pre-order orders anymore because we're good like that. But We got a lot of people. And how do you guys like the free shipping? It makes it super easy, right? We make more when people buy more than one bag, obviously, but whatever. This trial should have been over in 10 minutes. They got him dead to rights. Hope he gets a brutal sentence and he never gets out. If there's the death penalty, that works. There is no death penalty in the state of Wisconsin. So he is currently facing, he was offered a deal at six life sentences, and they would have dropped the other 62 reckless endangerments or whatever. But yeah. Someone said, can I turn up the volume? No, you got to turn it up on your phone. Seeing the shipping costs is like sticker shock. Yeah. What I ended up doing is I charged $2 more for each bag of coffee. So even though if you order one bag, first class shipping for it cost me $4.90 or whatever. But the more you order, the cheaper it gets for shipping. So it makes it a little bit easier. You know what I'm saying? The VH player was New Kid on the Block, and that's the original price tag. Really? That's crazy. Do we have decaf? No, we don't have decaf, unfortunately. We didn't sell enough of it. So I don't carry decaf, and I have no intention of ever carrying decaf ever again. MTG swatted for a 6th time, according to Blue Crow on YouTube. That sucks, man. Kako said, my wife worked in a jail and said it was an effing nightmare to deal with sovereign citizens. Yeah, but he's not even a real sovereign citizen. Someone put it in his mind. It was funny because we've talked about it so much. I actually saw an old court TV thing that was dealing with sovereign citizens, and it was like the 6 most outrageous sovereign citizen cases. People are nutty. They're nutty. Smile with a $1.99 super chat asking if I can turn up my volume on my voice. I cannot. You got to turn it up on your phone, buddy. So let me update that so it reflects the accurate amount. And again, if you like the live stream and you just want to see us do more live streams and all that stuff, right there. We have a daily goal. $400 is our daily goal. If we get to $400, we also do a night show called The Rational American, and I'll do that live. Tonight, I may do a call-in show if we make that goal. I don't know if we're going to make that goal, but if we do make that goal tonight, I will do a call-in show, and we'll see from there. Volume is perfect, someone else said. Use your closed captioning. Yeah. Someone said, I'm talking about appellate issues, which is what he's setting up. He knows what he's doing and understands it. Yeah, I mean, they're not going to... Why are people writing other coffee stuff in the chat? I'm confused. Yeah. Someone said, can we do a poll if the judge is hot or not? Nah, that's stupid. A sovereign citizen is someone who believes that the I don't really know. Let's look it up. Let's see what the Google definition for sovereign citizen. They believe that they believe something like the courts are all maritime courts, therefore have no jurisdiction over them. Something like that. So the sovereign citizens movement, they do not believe they are under the jurisdiction of the federal government and consider themselves exempt from U.S. law. They use a variety of conspiracy theories and falsehoods to justify their beliefs and their activities, some of which are illegal and violent. Of course, that's the Southern Poverty Law Center, so not the best group. Here's another one by the FBI. I don't know what the fuck this is. They actually classify it as a form of domestic terrorism. In this date or this blog or something that was released April 13th, 2010. Domestic terrorism, Americans attacking Americans because of U.S.-based extremist ideology comes in many forms post 9/11. They're looking at the sovereign citizen extremist movement. Sovereign citizens are anti-government extremists who believe that even though they physically reside in the country, they are separate or sovereign from the United States. As a result, they believe they don't have to answer to any government authority, including courts, taxing entities, or motor vehicle departments or law enforcement. This causes all sorts of problems and crimes. For example, many sovereign citizens who don't pay their taxes, they hold illegal courts that issue warrants for judges and police officers. They clog up court system with frivolous lawsuits and liens against public officials to harass them, and they use fake money orders, personal checks, and the like at government agencies, banks, and businesses. The FBI goes on to say that's just the beginning. Not every action taken in the name of sovereign citizen ideology is a crime, but there's a list of illegal actions committed by these groups, cells, and individuals. Anyway, this is back, so I'm shutting up now. But there you go.
All right, we are back on the record. Appearances are as they were before at 9:45. Mr. Brooks sent a note that says, under Illinois v. Allen, I request for the second to be present at my trial. I never consented to not being present, nor did I act in dishonor, because he has not made a pledge to conform his conduct as is required under Illinois versus Allen. He has not reclaimed his right to be present, and we will continue with him in the other room. I will also make a finding today, and I didn't do this previously, although he's forfeited his right to be present, given the technology, the audio and visual equipment that we have, the fact that we've also backed out the one camera so he can see the jurors. I'll make a finding, even without that, though, that it's the functional equivalent of being present in this courtroom. All right, with that, then the jury will be brought out. I'll remind Mr. Brooks, while he can reclaim the right to come back into the courtroom and make a request, I am going to be adamant that his request include a statement that he's willing to conduct himself consistently with the decorum and respect inherent in the concept of courts and judicial proceedings, and specifically pledge to not interrupt the reading of the jury instructions. Until such time, he will remain in that courtroom. All right, go ahead.
This is not going to be a 9-minute jury deliberation. They have 70 plus charges to go through. Now he's saying his phone thing isn't working again, or his headphones aren't working, even though, here's the stupid thing, they have speakers going through the room, so he doesn't need the headphones. He's just bullshitting. He's trying to talk. He thinks that they were telling him to talk, but they weren't telling him to talk. It's so annoying. So annoying. Let me tell you what. He's like, I can't hear anything because they're not talking to you, fucker. He claims that he's deaf in one ear. So that's why he's saying he can't hear the loud-ass speakers. They did a decibel read yesterday, in case you missed it. They said that the decibels in that secondary courtroom were 62, which is higher than what they were in the media room as well. So all of when she asked him a question, the bailiffs nod their head so she knows that they're hearing the speakers. So this is just another delay tactic that he's repeatedly done the entirety of this trial, and it's not going to end. So now the jury's coming in, and they're essentially going to proceed without him. So when she gets to starting to read, I'm going to bounce because I have to go home. I have to pay our household bills, and I got to eat lunch because I forgot to bring it with me. I also have Amazon bringing me new shoes, so I'm excited, plus TV mounts for our household TVs because my wife wants them mounted now. And then I'll be back. But we'll be live streaming the whole day. If some of you guys want to nominate yourselves as people to help us reach our streaming goal. I'm not sure how long I'll be gone, probably an hour or two. I'm also going to go and try to have my finger sized so I can get some silicone.
Thank you, everyone. Please be
wedding
seated.
bands, because it's time, right? Instead of just keeping my wedding ring on my keychain. Anywho, I'll see you guys in a little
Members
bit.
of the jury, the court will now instruct you upon the principles of law which you are to follow in considering the evidence and in reaching your verdict. It is your duty to follow all of these instructions. Regardless of any opinion you may have about what the law is or ought to be, you must base your verdict on the law I give you in these instructions. Apply that law to the facts in the case which have been properly proven by the evidence. Consider only the evidence received during this trial and the law as given to you by these instructions, and from these alone, guided by your soundest reason and best judgment, reach your verdict. If any member of the jury has an impression of my opinion as to whether the defendant is guilty or not guilty, disregard that impression entirely and decide the issues of fact solely as you view the evidence. You, the jury, are the sole judges of the facts, and the court is the judge of the law only. The defendant is charged with 6 separate counts of first-degree intentional homicide, use of a dangerous weapon. The first count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Virginia Sorensen with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub b of the Wisconsin statutes. The second count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, to cause the death of Leanna Owen with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub b of the Wisconsin statutes. The third count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, to cause the death of Tamara Durand with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub b of the Wisconsin statutes. The fourth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Jane Coolidge with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub b of the Wisconsin statutes. The fifth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Wilhelm Hospital with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub b of the Wisconsin statutes. The sixth count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did cause the death of Jackson Sparks with intent to kill that person and while using a dangerous weapon, contrary to sections 940.01 sub 1 sub a, 939.50 sub 3 sub a, and 939.63 sub 1 sub b of the Wisconsin statutes. The defendant has entered a plea of not guilty to each of these charges, which means the state must prove every element of each offense charge beyond a reasonable doubt. First-degree intentional homicide, as defined in section 940.01 of the Criminal Code of Wisconsin, is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of any count of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present with respect to that count. 1. As to each count, the defendant caused the death of the victim named in that count. Cause means that the defendant's act was a substantial factor in producing the death. 2, as to each count, the defendant acted with intent to kill the victim named in that count. Intent to kill means that the defendant had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with intent to kill, it does not require that the intent exist for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The information alleges not only that the defendant committed the crimes of first-degree intentional homicide, but also that the defendant did so while using a dangerous weapon. Dangerous weapon means any device or instrumentality which, in the manner it is used or intended to be used, is likely to produce death or great bodily harm. Great bodily harm means serious bodily injury. If you find the defendant guilty of a count of first-degree intentional homicide, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? Before you may answer this question yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime of first-degree intentional homicide while using a dangerous weapon. If you are not so satisfied, you must answer the question no. If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 1, you should find the defendant guilty of first-degree intentional homicide as charged in count 1. If you are not so satisfied, you must find the defendant not guilty as to count 1. If you find the defendant guilty of count 1, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 2, you should find the defendant guilty of first-degree intentional homicide as charged in count 2. If you are not so satisfied, you must find the defendant not guilty as to count 2. If you find the defendant guilty of count 2, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 3, you should find the defendant guilty of first-degree intentional homicide as charged in count 3. If you are not so satisfied, you must find the defendant not guilty as to count 3. If you find the defendant guilty of count 3, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 4, you should find the defendant guilty of first-degree intentional homicide as charged in count 4. If you are not so satisfied, you must find the defendant not guilty as to count 4. If you find the defendant guilty of count 4, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 5, you should find the defendant guilty of first-degree intentional homicide as charged in count 5. If you are not so satisfied, you must find the defendant not guilty as to count 5. If you find the defendant guilty of count 5, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that both elements of first-degree intentional homicide have been proved as to count 6, you should find the defendant guilty of first-degree intentional homicide as charged in count 6. If you are not so satisfied, you must find the defendant not guilty as to count 6. If you find the defendant guilty of count 6, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree intentional homicide while using a dangerous weapon? The defendant is charged with 61 separate counts of first-degree recklessly endangering safety, use of a dangerous weapon. The 7th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Nicole White under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 8th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Eleanor Anders under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 9th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Sasha Catalan Castillo under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 10th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Maura Gilchrist under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 11th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Justin Gullickson under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 12th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Harry Guilfoy under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 13th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Aiden Lofgren under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, 939.63 sub 1 sub B of the Wisconsin statutes. The 14th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Theo Mazza under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 15th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Tyler Pudliner under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 16th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Connor Tank under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 17th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Eric Teagues under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 18th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Adelia Maffioli under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 19th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Kelly Graybow under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 20th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Josh Craner under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 21st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Riley Rogers under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 22nd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Caden Rogers under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 23rd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Tucker Sparks under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 24th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Isabella Bartelt under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 25th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Yaretzi Becerra Montez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 26th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Samantha Coelho under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 27th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Madison Hollingsworth under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 28th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Mackenzie Hollingsworth under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 29th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Mitchell Lampine under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 30th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Kathleen Pielmeyer under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 31st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Julia Schleichow under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 32nd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Olivia Stover under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub B of the Wisconsin statutes. The 33rd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Jennifer Stover under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 34th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Jesselyn Torres under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 35th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Alice Darrell under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 36th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Charlotte Darrell under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 37th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Vivian Darrell under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 38th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Grayson Darrell under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 39th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Lola Hospital under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 40th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street, the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Tamara Rosentrader under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 40th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, the 41st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Betty Strang under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 42nd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Maria Alvarez Dominguez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 43rd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Georgia Romelia Perez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 44th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Elliot Hallmark under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 45th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Benjamin Hallmark under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 46th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Patrick Heppy under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 47th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Lori Loken under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 48th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Marisol Lopez Gutierrez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 49th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Adair Lopez Rebelar under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 50th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Juan Marquez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to section 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 51st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of David Marquez, under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 53rd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Jason Petchloff under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 54th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Margaret Pachulis under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 55th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Yamilet Perales Alvarez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 56th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Alin Perales Alvarez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 56th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Ashley Perales Alvarez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 58th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Jose Perales Alvarez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 59th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Maria Perez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 60th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Camila Perez Gonzalez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub F, and 939.63 sub 1 sub B of the Wisconsin statutes. The 61st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Isaac Foglia under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 62nd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Deborah Ramirez under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 63rd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Charles Green under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 64th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Lily Green under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 65th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Brinley Harris under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 66th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Kelsey Knapp under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The 67th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did recklessly endanger the safety of Owen Ricciati under circumstances which show utter disregard for human life and while using a dangerous weapon, contrary to sections 941.30 sub 1, 939.50 sub 3 sub f, and 939.63 sub 1 sub b of the Wisconsin statutes. The defendant has entered a plea of not guilty to each one of these charges, which means the state must prove every element of each offense charge beyond a reasonable doubt. I'm going to take a quick stand break. Please stand, everyone. All right, thank you. Be seated. First degree recklessly endangering safety, as defined in section 941.30 sub 1 of the Criminal Code of Wisconsin, is committed by one who recklessly endangers the safety of another human being under circumstances that show utter disregard for human life. Before you may find the defendant guilty of any count of first-degree recklessly endangering safety, The state must prove by evidence which satisfies you beyond a reasonable doubt that the following 3 elements were present with respect to that count. 1. As to each count, the defendant endangered the safety of another human being. 2. As to each count, the defendant endangered the safety of another by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and the defendant was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. Great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. 3. As to each count, the circumstances of the defendant's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what the defendant was doing, why the defendant was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. The information alleges not only that the defendant committed the crimes of first-degree recklessly endangering safety, but also that the defendant did so while using a dangerous weapon. Dangerous weapon means any device or instrumentality which, in the manner it is used or intended to be used, is likely to produce death or great bodily harm. Great bodily harm means serious bodily injury. If you find the defendant guilty of a count of first-degree recklessly endangering safety, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? Before you may answer this question yes, you must be satisfied beyond a reasonable doubt that the defendant committed the crime of first-degree recklessly endangering safety while using a dangerous weapon. If you are not so satisfied, you must answer the question no. If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 7, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 7. If you are not so satisfied, you must find the defendant not guilty as to count 7. If you find the defendant guilty of count 7, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 8, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 8. If you are not so satisfied, you must find the defendant not guilty as to count 8. If you find the defendant guilty of count 8, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 9, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 9. If you are not so satisfied, you must find the defendant not guilty as to count 9. If you find the defendant guilty of count 9, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 10, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 10. If you are not so satisfied, you must find the defendant not guilty as to count 10. If you find the defendant guilty of count 10, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 11, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 11. If you are not so satisfied, you must find the defendant not guilty as to count 11. If you find the defendant guilty of count 11, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 12, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 12. If you are not so satisfied, you must find the defendant not guilty as to count 12. If you find the defendant guilty of count 12, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 13, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 13. If you are not so satisfied, you must find the defendant not guilty as to count 13. If you find the defendant guilty of count 13, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 14, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 14. If you are not so satisfied, you must find the defendant not guilty as to count 14. If you find the defendant guilty of count 14, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 15, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 15. If you are not so satisfied, you must find the defendant not guilty as to count 15. If you find the defendant guilty of count 15, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 16, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 16. If you are not so satisfied, you must find the defendant not guilty as to count 16. If you find the defendant guilty of count 16, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 17, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 17. If you are not so satisfied, you must find the defendant not guilty as to count 17. If you find the defendant guilty of count 17, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 18, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 18. If you are not so satisfied, you must find the defendant not guilty as to count 18. If you find the defendant guilty of count 18, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 19, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 19. If you are not so satisfied, you must find the defendant not guilty as to count 19. If you find the defendant guilty of count 19, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 20, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 20. If you are not so satisfied, you must find the defendant not guilty as to count 20. If you find the defendant guilty of count 20, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 21, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 21. If you are not so satisfied, you must find the defendant not guilty as to count 21. If you find the defendant guilty of count 21, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 22, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 22. If you are not so satisfied, you must find the defendant not guilty as to count 22. If you find the defendant guilty of count 22, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 23, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 23. If you are not so satisfied, you must find the defendant not guilty as to count 23. If you find the defendant guilty of count 23, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 24, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 24. If you are not so satisfied, you must find the defendant not guilty as to count 24. If you find the defendant guilty of count 24, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 25, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 25. If you are not so satisfied, you must find the defendant not guilty as to count 25. If you find the defendant guilty of count 25, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 26, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 26. If you are not so satisfied, you must find the defendant not guilty as to count 26. If you find the defendant guilty of count 26, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 27, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 27. If you are not so satisfied, you must find the defendant not guilty as to count 27. If you find the defendant guilty of count 27, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 28, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 28. If you are not so satisfied, you must find the defendant not guilty as to count 28. If you find the defendant guilty of count 28, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first-degree recklessly endangering safety have been proved as to count 29, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 29. If you are not so satisfied, you must find the defendant not guilty as to count 29. If you find the defendant guilty of count 29, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 30, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 30. If you are not so satisfied, you must find the defendant not guilty as to count 30. If you find the defendant guilty of count 30, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 31, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 31. If you are not so satisfied, you must find the defendant not guilty as to count 31. If you find the defendant guilty of count 31, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 32, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 32. If you are not so satisfied, you must find the defendant not guilty as to count 32. If you find the defendant guilty of count 32, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 33, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 33. If you are not so satisfied, you must find the defendant not guilty as to count 33. If you find the defendant guilty of count 33, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 34, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 34. If you are not so satisfied, you must find the defendant not guilty as to count 34. If you find the defendant guilty of count 34, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 35, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 35. If you are not so satisfied, you must find the defendant not guilty as to count 35. If you find the defendant guilty of count 35, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 36, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 36. If you are not so satisfied, you must find the defendant not guilty as to count 36. If you find the defendant guilty of count 36, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 37, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 37. If you are not so satisfied, you must find the defendant not guilty as to count 37. If you find the defendant guilty of count 37, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 38, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 38. If you are not so satisfied, you must find the defendant not guilty as to count 38. If you find the defendant guilty of count 38, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 39, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 39. If you are not so satisfied, you must find the defendant not guilty as to count 39. If you find the defendant guilty of count 39, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 40, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 40. If you are not so satisfied, you must find the defendant not guilty as to count 40. If you find the defendant guilty of count 40, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 41, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 41. If you are not so satisfied, you must find the defendant not guilty as to count 41. If you find the defendant guilty of count 41, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree recklessly endangering safety have been proved as to count 42, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 42. If you are not so satisfied, you must find the defendant not guilty as to count 42. If you find the defendant guilty of count 42, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon?
Holy
read
shit, she's
41
still
pages
going?
thus
Oh
far.
my goodness.
I am going to take a short comfort
Oh,
break.
look at the fucking
And, we'll
timing
come back
there,
in about
boys
10,
and
15
girls.
minutes. This will also give the jurors and the parties a chance to have a comfort break as well.
Hell yeah.
All rise for the jury.
All rise. Motherfuckers, get up on your feet. It's time. Well, what time is it? Break time. It's break time. Break time. It's break time. Yo, break time. Oh, break time. Get up on your feet, motherfuckers. Do the hokey pokey. Turn yourself around. That's all I got. Do the hokey pokey. Turn yourself around. Darrell Brooks is gonna get popped in the butt by Bubba.
Hey, Darrell Brooks, come on over here. Pick up my soap.
No, Bubba, no.
Yes, Darrell, yes.
4 a.m., but I will address that when I get back on the record. We
How
are
about
in recess.
that? They're in recess. You like my song? I wrote that. That shit's copywritten, though. So you better not fucking copy that shit. Shit. Do the Steve. Do the wave. Yeah, that's what I should have did. Do the wave. Hell yeah, do the wave. I saw him waving. I was driving in my car and shit. He was all waving. Hold on. I did get a Venmo when I was gone. And I got a PayPal. Or no. Yeah. So we got Allison. Shout out to Allison. Allison. She sent a Venmo. She's the best. Allison. Oh, fucking A. I don't care who you are right there. That shit is funny. We are a ways away from our goal. I guess you guys don't want a live stream today. Christy McCoy Schmupster said, did I miss closing arguments? Nope, you didn't. They haven't begun yet. Because in Wisconsin, they do everything fucking ass backwards. Closing arguments follow jury instructions, followed by 36 pages of additional jury instructions, to which the jury will be deliberating. Yeah. Idnar said, I wish he wasn't muted. I would like to hear what he's saying and how hard he's pressing down while writing. Yeah. That voice is F-A-F as fuck. I don't even know what that means. F-A-F high? What does that mean? What? I mean, come on, kids. That's some kid lingo I don't understand. Now cut the Wisconsin attack? What? We're done, said, there's something wrong with you, Steve, LOL. Nuh-uh. Nope, perfectly sane here. Robert Wilson said, Steve, are you going to cover the Murdoch murder trial? Actually, he wrote, are you going to cover the Murdoch murder trail in South Carolina? It's in January. I'm unfamiliar with that trail, although I'm not quite an outdoorsy type person. I don't really like walking. I think it's stupid, right? Like, why are you going to go walk through the woods? Fucking dumb. But whatever, people do it. They go for these things called hikes, and they breathe in the fresh air. There's nothing like a little bit of New York City smog in your lungs. That's what we love. Can we get an interview with Bubba? No, I'm not in the mood. Not in the mood. Uh-oh. Shout out to Linda. Linda, she sent a $10 cash app, Linda. Oh, Linda. So let me update this. We're at 169. 169. Well, someone said, what? Hiking is awesome. No, it's not. It's fucking stupid. Like, why are you gonna go walk around aimlessly in the woods smelling trees and horses' butts and shit? Like, if you're gonna ride a horse while you're walking through the woods, then that makes a little bit more sense. But just aimlessly walking around the woods like a hipster waiting to smell patchouli or something? Nope. Not a big fan of it. Not a big fan. Don Riggs said, oh my god, who's this voiceover? Is this live? Shit up. Shit down, son of a bitch. Say shit up. I think you meant to write shut up, but you're like shit up instead because you're full of shit, Don. You're full of shit, Don.
Full of shit.
Yeah, you like that? It's a trial, not a trail. I know. See how we could segue, though? Like, he meant to say trial, but he wrote trail. And so we started a whole conversation about hiking on trails because that's stupid. And you see how I did that? Yeah. Alex said, Steve, you are a funny dude with your voices. Yeah, I know. Isn't it weird how I gave Alex a high-pitched voice? And Idnar says, seemed like everyone is making chili. That's fucking weird. Chili? I don't like chili. Actually, I don't mind chili. Fucking A. Oh, here we go again. Here we go again. Deborah. She sent a cash app to me. People are hoping that we do a night show, and people like Deborah are helping that to become a reality. Ooh, Deborah. Yeah, thank you, Deborah. Yeah. This is a serious voice, not funny. Fuck off. Jesus Christ. Unbelievable. I do like chili. I just don't. Red sauce gives me indigestion. You know what I mean? So I always say I don't like. It's weird because chili's like two things. One, it gives me indigestion, and then it gives me the shits. So I get indigestion and shits. It's really quite awkward. Plus, my wife doesn't eat red meat, so it's like chicken chili and shit, and it's gross. She's not listening, so I could say that. Who likes chicken chili? Not me. I don't like chicken chili because it's fucking gross. Yeah. Chili leaves a trail of fumes. No, I think you actually meant to write chili leaves a trial of fumes. Okay, because today's opposite day. Chicken is not chili. Yeah, but chili chicken. Chili, chicken, chili. Chili with chicken in it is chili chicken or chicken chili. Chicken and dumpling times. No, that's Chinese food. I don't like it. Actually, I take it back. You know what they call beef on the stick from Chinese foods, but you're not really quite certain if it's actually beef or if it's some weird foreign meat like dog or something. Yeah, that's pretty fucking good. Except when it has little hairs on it, and then it really makes you question what the fuck you're eating. But, yep. Someone wrote deer sausage chili. Oh, yeah? Have you ever had moose neck chili? Yeah, me neither. But I did have moose neck once. What's it called? There's a name for it. Moose neck sausage. My dad tricked us all when we were kids. And he's like, hey, try this new sausage. And then we're like, okay. And then we tried it. And he's like, what do you think of it? And we're like, it's pretty good. And he's like, yeah, that's a moose. Your neighborhood friendly moose. Yep. It's fucking dead. It was gross. It was good until we found out it was a moose. And then it was fucking gross. Gross. Heather said, is this a break or lunch? This is a break, not lunch break. Even though I just had lunch. You know what I had? Not fucking moose sausage. Nope, I had a turkey sandwich on white bread because I'm gangster. And I have white bread because isn't that what they say? Like, if I prefer white bread, does that make me a racist to leftists? I bet it does. I bet they'd be like, no, you need to have whole grain and patchouli and soy sauce. They don't like soy sauce. They just like soy. Soy. I tell you what, the offer's still there. I'll do a whole entire show if I do $1,000 in a day. We almost made it yesterday. Or maybe I'll do a call-in show where I just talk with this voice the entire time. Doing call-ins, which I hate. Unknown user said, is Steve still talking? I don't hear anything. Oh no, did they mute us because we're too real for them? Ew. Rabbits are good. Oh, speaking of rabbits, our rabbit died. Nah, and I'm not joking either. Did I tell you guys that? I don't remember if I did. I think it was like Saturday morning or something, or Friday morning. I don't remember what day it was. My son cried. I didn't yell at him either for crying. Because, well, it's sad. His deer, do you know what the rabbit, do you know what the rabbit looked like? It was like, like, that's what the rabbit looked like. It was fucking sad. Yep. We had a feeling it was gonna die, though. We had a feeling because it wasn't really eating. And then it would eat like lettuce, but it would only eat the stalk of the lettuce and not the lettuce. They say the rabbit died, you're having a baby. Oh, that would be cool. I would like another baby. Someone said, doesn't that mean your wife is pregnant? Wow, is that real? I'm going to tell her. That's awesome. I want another kid. I want a baby girl. That's what I want. We have 2 boys. They're fucking awesome, but I would like a girl. You know, my boys are old enough, so now I don't need to go to jail. If anything ever happens to the girl, my boys can do it. You know what I mean? Like, fucking right, bro. I used to want a boy, and then 2 years later a girl, and then 2 years after that a boy. So that way, when my son was like a senior, he could defend his sister. And then when he went off to college, the younger boy could kick the shit out of the girlfriend, the boyfriends and shit. You know what I mean? Yeah, someone said you'll end up with another boy. Yeah, it's annoying because my brothers all have girls, which is bullshit. Bullshit. Brooks is chained at the feet. Why is your voice so high? That doesn't even make any sense, Michelangelo Kowalski. Brooks is chained at the feet with shock bracelets. No, seriously, he's got shock bracelets. Shock bracelets. It's funny when you say it like that. Someone said adopt a girl, done. Yeah, that's what my wife keeps saying. She's like, let's just adopt. Let's just be foster parents. I'm like, we can't be foster parents. She's like, why can't we be foster parents? And I'm like, do you know what foster kids went through? She's like, you turned out okay. And I'm like, yeah, but what about the ones who we gotta give back to the parents who beat them up? I can't fucking do that. You know what I mean? There's no way in hell. Shout out to Vivian. What did she do? Why is she getting a special shout out? Because while we were live, she sent me a $20 Venmo saying, for her baby girl. The voice dropped. Yeah. Let me update this here. 209. Can I do any fucking math today? Probably not. Damn, bro. Now I want to make $1,000 today so I could do a whole call-in show for like 2.5 hours of this. Someone said, Steve, you are the producer of Why You Find Your Girl. Oh my God, killing me. I don't know what the fuck that means. What the fuck? Like, what are you smoking, deplorable chicken hen? What the fuck comment is this? Steve, you are the producer of Why You Get Find Your Girl. Smiley face, crying, teardrops, eyeballs. OM God, killing me. Look at my pecker. That's what the video, look, that's what the picture says. It's not just me being dirty. Yeah. 6 girls, you don't want a girl. Yeah, I mean, like I always said, my if I ever had a girl, they'd be wearing like baggy sweatpants until they're 27. But yeah, as a person who refuses to drink coffee, I sure spend a lot of time around drinkers. Yeah, we'll start drinking coffee. Peer pressure, peer pressure, peer pressure. Does Steve squeeze his balls to get his voice like that? No, my balls are too big to squeeze. It doesn't work. It's called a voice changer, fucker. He's saying you determine the sex of the child. Oh, that's right. You are right. Yes, yes. So even if we had a boy, I could just say you're a girl now, right? Isn't that how it works? Boys can be boys. No, boys can be girls. Cindy said I had 2 boys and 3 grandsons. Yeah, that's crazy. My wife, I'm surprised my wife doesn't want to, try for a girl. Because she's got boys, 2 boys, plus me. I'm like a 3rd boy, like a 3rd child. But then we have two female dogs, and now 1 out of 2 female bunnies, because the other female bunny died this week. It was really sad. My son cried, and he was like looking at me, trying to hide him crying, and I'm like, dude, it's okay to cry. It's okay. And he's like, what do you mean? You always say men don't cry, and I'm like, yeah, but your fucking bunny died, bro. I'm like, you're allowed to cry for exactly 5 seconds. Other than, and if you don't stop crying, I'm gonna give you something to cry about. Sound guy ZN Clark with a $50 super chat said, how long is it gonna be in jail if he gets a full guilty? Well, the first degree intentional homicides are life in prison. And he's got 6 of those. And I don't know what the little charges are. They're not little charges, but you know what I'm saying. Jenna said, why didn't you take the bunny to the vet if you knew it was sick? Because, to be honest, I wasn't going to spend thousands and thousands of dollars on a bunny that we were trying to give away. So we made sure it wasn't in pain and all that stuff. But, yeah, we weren't going to spend thousands and thousands of dollars running tests with an exotic animal veterinarian, because even our vet won't work on bunnies. So our vet was like, yeah, you can bring him in and put him down. I'm like, I'm not gonna do that. We'll just keep him comfortable. We'll pet him. I pet him the day before he died. Wasn't that nice? I was like, you's a good bunny. Like this, like seriously, it actually, and this is how I knew it was sick, because it would sit on my lap. Normally it would try to like kill me. But yeah, it was sitting on my lap and just being nice. And it was hopping around playing with the dogs, but we could just tell it wasn't really eating. So it was going to die. And it did die. Poor bunny. So because we felt bad about it, we took the other bunny, the big hairy-ass bunny, and we took it out of my little guy's room. We moved around the living room and put that bunny in the living room so it could be a part of the family. So now the dogs want to fucking eat it all day. And they chew. And they're like trying to get at the bunny all day. It's fucking funny. But that bunny, he gives 2 fucks. He's just like, look at all my hair. And he walks around. Like, if the bunny could walk on 2 legs, this is how it would do it. But it can't, because it's a fucking bunny and they can't walk around like that. Deplorable Chicken Head said, I still can't get my mascara on. Oh, well, that's sad. Hopefully you're a female putting mascara on. But this is 2022, so we don't know. You could be a man. I'm not saying you're a man. It's kind of a joke, but whatever. What else? Life is only 30 years. So many counts they could put him away forever so he can't hurt anyone anymore. Was this the boxing bunny? It was the boxing bunny that passed away. And do you know what's crazy, though? The boxing bunny, when it was, like, rigor mortis sets in fast as fuck with bunnies. Like a human, it takes like 12 hours, right, before they start tensing up. No, this bunny, I mean, the last time we saw it alive was 8 hours. And good thing, here's the best thing, because we found it at like 6 o'clock in the morning, all sprawled out, open with its eyes like this. But my son that night said he wanted to sleep on the couch. He knew it was going to happen. He knew it. Deplorable Chicken Head said, "Stop it, Steve. You know I'm a girl. God." I know. I'm just being funny. Kristen Mern said, "My bunny wears diapers in the house. That's fucking weird." I mean, you know what we do? Our bunnies are fucking potty trained. They go in the litter box. Like, litter bunnies. Susan said, "Steve's bunny passed away, Christine." Literally, we were trying to give away the bunny, okay? So, like, it's not like a dog. Like, if a dog, you know, when my dog Miles and my dog Lily died, I cried, you know, because I'm I'm a man, but I cried over those animals. Lily, we spent thousands and thousands of dollars trying to keep her alive because she was, like, truly my dog. Miles was, like, my wife's dog, so fuck that dog. But Lily, she was my dog. I loved Lily. And I couldn't even go. I had to take Miles to have him put down because he was just dying. He was old. And so I had to sit there. And I had like the movie crying. You know, like when you see someone in the car, right? Oh, fuck, it's back. That was going to be a good fucking story. Fuck. Remind me later. Haha, she dropped her papers.
Right, we are back on
Fucking
the record.
stupid. She dropped her
The jury
papers.
has not been brought out just yet. I indicated I would address.
Someone said, am I giving away the dead bunny? No, it's in the garbage at my store.
Mr. Brooks.
That's what the animal control said to do with it. Throw it in the dumpster. The dumpster.
I have
Okay,
reclaimed
anyway.
my rights, parenthesis,
Fuck
that I
Darrell
never
Brooks.
gave up
I'll
or
shut up
consented
now.
to give up, parenthesis, to be present, and you have not honored your oath of office to protect my constitutional rights, specifically my 14th Amendment, Section 1, which references equal protection of the laws. Would you like to explain this on the record, or should I will if you won't. I would like to make an offer of proof for my appeal on the record. I indicated previously that should Mr. Brooks want to come back into this courtroom pursuant to Illinois versus Allen, he could certainly reclaim the right to be present, but he would need to be willing to conduct himself consistently with the decorum and respect inherent in the concept of courts and judicial proceedings. I specifically advise that he would need to pledge to not interrupt the proceedings. He has not done that, meaning he has not indicated he wants to come back or that he will pledge to be courteous and follow the rules of decorum, and specifically pledge to not interrupt as I read through the jury instructions. And his letters or notes that he passed will, of course, be made part of the record, but I'm going to deny his request to make a further record for appeal, as I need to continue advising the jury of the jury instructions. So with that, Mr. Brooks will remain where he is at.
He's waving his hands.
Anything further? he
Wave
wants to
him
address,
like you
he will
just
need
don't
to
care.
do that in
Put those
writing,
fucking
as
killer
he has
hands
done
in the
with a
air.
note, but I don't feel
Yeah.
the need to give him any
Yeah.
additional opportunity
Wave,
to
wave.
explain
God.
that.
He's going to have shoulders that
What
are
I will
pumped
ask
after this.
is he going to make a
Better
request
so he
to
can
come
get down on his knees for Bubba.
It's true, he can give me a thumbs up sign, and then I will address that. All right, I will unmute him. Mr.
Okay.
Brooks, what is your request as it relates to coming back into this courtroom?
Here we go, shithead.
I've requested to come back into the courtroom with the first writing that you said I had to write.
I put that on the record already, sir. You did not pledge to respect the rules of courtesy and decorum and pledge to not interrupt the court. Are you willing to pledge that at this time?
Your Honor, with all due respect, I've never had to do that before to reclaim my right. I've always asked, when you've given me the opportunity, when I felt that the time was right, I've always asked to come back, have I not?
Mr. Brooks, given your conduct
bailiff-
this morning and your blatant violation of my direct order to you to not interrupt when the jury was being brought out, I felt it important to strictly enforce the language of Illinois versus Allen and only bring you back if you are willing to conduct yourself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings, and specifically pledge to not interrupt as I go through all of these jury instructions. If you're willing to do that, I will bring you back in.
Your Honor, with all due respect, can we at least be fair and say today hasn't been as volatile as other days, or as the back and forth between you and I hasn't been what it has been previously?
Mr. Brooks, we started the advisement to the jury an hour later than I anticipated, so I would thoroughly disagree with you that it might not have been volatile or loud, but it was nonetheless disruptive. So I will ask you these questions, sir. If you come back into this courtroom, are you willing to honor my request and order to you that you not interrupt as I read through the jury instructions?
Your Honor, I don't understand the question that you're asking.
Sir,
And
are
the
you
reason
willing
why-
to refrain from raising the issue of subject matter jurisdiction if you come back into this courtroom?
Your Honor, with all due respect to your ruling on Illinois versus Allen, that was not part of Illinois versus Allen. I don't understand why that's being
Mr.
made
Brooks, I'm
of-
not going to debate the meaning of Illinois versus Illinois v.
Yeah.
Allen with you. I'm simply trying to get you back into this courtroom. You seem to want to be here, but you don't want to pledge to follow the rules of courtesy and decorum.
Get your shit together,
So that's on you.
fucker.
Your Honor, this
Just
never
hang
been
up
done
on me.
before. It's never been done before, and I've always been able to reclaim my right to be able to be present,
Are you willing?
which is what I stated when I first came over here. I've been stating the same thing. I've actually told the bailiff numerous times.
Mr. Brooks, I am strictly enforcing the language of Illinois versus Allen,
Strict
which
as
says the
fuck.
following. I will repeat myself again. Once
Get 'em.
lost, the right to be present can, of course, be reclaimed as soon as the defendant is willing to conduct himself consistently with the decorum and respect inherent in the concept of courts and judicial proceedings.
Hell yeah.
I have not required the pledge previously. I've allowed you to come back. But given the interruptions this morning and your immediate discussion of things like subject matter jurisdiction and my oath the minute one juror walked through that door, I cannot take that. I will not bring you back in without that pledge.
Pledge it, bitch.
So where does it say anything about a pledge?
Holy fuck, this dude is so dumb.
Sir,
I
I'm
hate
not going to
him.
debate the language with you. I am establishing what I believe is a reasonable restriction on your right to come back into this courtroom based upon the history in this case of your repeated violations of the simple rules of courtesy and decorum and your failure to follow my very clear and direct requirement this
pledge.
morning that you not interrupt the reading of the jury instructions and you be silent once the jury entered the courtroom. I did that in part because it not only preserves the dignity and decorum of this trial, it also frankly protects your rights and it minimizes your bad behavior in front of the jury.
Your Honor, I didn't interrupt you while you were talking. I let you make your record without talking over you or interrupting you.
Thank you. I would agree with you just now.
The way that I'm interpreting when you reference to me with the Illinois versus Allen, where your ruling is coming from, the way that I interpret that is not the way that you're saying it
Oh
to
my
me
god,
now. That's
who
why I don't
fucking
understand
dude? Judge,
what you're asking.
Judge.
I'm interpreting that in a totally different way.
because you're stupid.
I'd refer you to the third section of Illinois versus Allen, where the U.S. Supreme Court was discussing what the trial court did in that case. And it said the following: the trial court in this case decided under the circumstances to remove the defendant from the courtroom and to continue his trial in his absence until and unless he promised to conduct himself in a manner befitting an American courtroom. As we have said earlier, we find nothing unconstitutional about this procedure. So that is the authority, sir, in addition to the other quotation. I'll tell you this. I'll give you one more
Oh
opportunity,
my god,
sir.
stop
You can
being
come
a
back into this
pushover,
courtroom.
Judge. Stop
But I do
being
not
a
want you
pushover.
to address or attempt to address subject matter jurisdiction or any of the other rulings that I've previously made. I need to continue with the advisement to this jury about the rules that govern their deliberations. That is the stage we are at. And if you violate that in any way by raising any of those legal issues in their presence, that will be in direct violation of the requirement for you to reclaim your right, and you will be removed back to the other courtroom. Did you hear me say that, sir?
I'm informed, but Your Honor, now you just stated on the record if I raise these issues in their presence, but if they're not in the courtroom, it's not in their presence, correct?
Sir, I can't bring them into the courtroom until you're here. I expect you during that short interval not to raise these legal issues that I've already addressed multiple times. So yes, I'm telling you, if you come back into this courtroom, I don't even want to have you raise any of those issues. I want to bring the jury right out without interruption. That is my clear expectation, whether the jury's in the courtroom or not.
Your Honor, I'm confused because you just said don't raise any issues in their presence, and now I'm confused.
Because you're indicating to me by your statement that you intend to raise them once you get back into this courtroom. And so I'm making that another restriction, and you need to pledge to me that you will not do that.
Your Honor, the way that I'm interpreting what you just read to me from the other section that you just read from Illinois v. Allen, it does not have that language. So I'm
Mr. Brooks, I'm not going to debate the language. Do you want to come back in here or not?
I've stated numerous times that I shouldn't even have been brought over here anyway, and that I wanted to come back. But now what I don't understand about it, Your Honor, is that there's being rules enforced.
Mr. Brooks, do you want to come back in here or not? It's a very simple question.
I said yes already.
All right,
how many
then
times
I'm
do I
going
have to say the same thing?
Because then you go on and make other statements, and then I can't even effectuate your request.
But I'm trying to tell you how I'm interpreting what you're saying to me. If you want
Mr.
me,
Brooks, I'm going to
be
mute
informed-
you. We're going to go in recess. He can be brought back over, but I will advise you that if you start back in, even outside the presence of this jury, with any of the legal issues I've already ruled on, you will go back to the other courtroom. It's that simple.
She has to let him
He'll be
do
brought
it.
back
She
over, and
has
then we'll
to.
start back up.
She has to because she's trying to avoid any grounds for appeal. Or that's the only reason. She has to, based on Illinois versus Allen. She has to allow him to come back into the courtroom. He's going to go into the courtroom. He's going to act a fool. And then they're going to be back at it again. And then she's going to kick him out of the courtroom. Again, look at his fucking stupid mouth. I can't wait until it's full of Bubba instead of full of shit. Do you know what I mean? You guys all say whatever. You all say, do you guys understand with what I said? But dude, look at him. Oh my God, I can't wait till he gets to Gen Pop and someone just like pops him right in the face. You know his tattoo over his right eye says shithead? Like it's not real. It's not really true, but it should. It says mega shithead. You know, if I was, I can't say that. There's so many things I would like to say. Gen poop. I like what you did there, Chad. He said when he gets back to Gen poop instead of Gen pop. Oh, pop goes his butthole. Is that too much? Shit. Gen pop. Because that's what his butthole goes pop. I just think I lost it. I'm fucking crying. Oh, that was funny. Jen Pop, because Pop goes his butthole when he drops his soap. laughing. Oh my god. My eyes are fucking raining. Oh boy. Oh, that was funny. That was off the top of my dome right there. That shit was dope. Oh, fuck. Amazon just delivered to my house. Hopefully no one steals it. Because I'm not going back there. But yeah, that was funny. April said, you need Pop Goes the Weasel music to make that song. Like, how would I even make that shirt? I don't want to go to Gen Pop. Oh, man. That may have been the funniest moment on this whole entire live stream. At least it was for me. Like, my eyes are watering. Oh, boy. Aunt Karen gets a big shout out. No, she gets a fucking song. Not in addition to being our top donation, she just put us over 300 for the day. Yeah. Aunt Karen. You're not my real aunt, but you fucking rock. Aunt Karen, save the day. She makes everything okay. And Pop, his butthole's gone. Corn Pop was a bad dude. Gen Pop. See, I'm just gonna keep doing that. I can't keep doing this. Thank you, Karen. Gen Poop was a bad dude. That's funny as fuck. I don't care who you are right there. If you don't think that's funny, you suck ass. What was that? Via Cash App or Venmo? Oh my gosh, dude. Now I feel like I just had a good cry. That was Cash App. That was funny as fuck. That really made my day. Gen Pop goes his butthole. Oh fuck. I don't care who you are. Hiram Lewis said he has been raising issue all along. She already made his decision. One thing mentioned the other day was the process he used to waive his right to counsel. He questioned the form she used. Like I said, the case law says you can't waive constitutional rights forever, and if there becomes a time that he doesn't understand what he can't understand, his failure to understand causes him not to be able to provide effective defense, that he could argue that he effectively lost his right to an attorney. No, not Wisconsin, though. See, that's the thing, is when you got people that argue shit that they don't know. In Wisconsin, he tried to amend the waiver of counsel to say that a licensed attorney could sit second chair, which violates Wisconsin law. That's why his edits on that form were not valid. It's already been discussed. It's already been ruled. It's already been everything. So it goes by the state's law. Yeah. Man, my nose is watering now. That was funny as fuck. We are $91 away from a night show tonight. Can we do it? $91. And then I'll do a night show. Maybe I'll do a call-in show. See, you know what's funny is Chris with WYSIWYG TV the other day had like an emoji thing. So instead of like the regular face, it was an emoji. And I think it would be funny to do a whole, like convert this channel to talk about news and shit, but do it as a chipmunk with this voice. Talking about the news every day in like an offensive like punk chimp rock, chipmunk. You know what I mean? Like someone that doesn't give a fuck. You know what I mean? Yeah. Someone said nose watering. Yeah, my nose is leaking because I was literally crying because the Gen Pop Darrell Brooks' butthole is like the funniest thing I think I've ever said in my life. It's funny as fuck. Taking forever to get into the courtroom. Yeah, hopefully he's fighting and gets shocked a bunch and you know what I mean? Exactly what we've been saying that about the attorneys to Haram for hours. Yeah, and here's the problem is when people don't understand the law, the only reason I know that, it's not because I'm smarter than Haram. No, I mean, I probably am. But the reason why I knew that is because I looked it up. But someone said Haram said that creates a due process equal protection argument for the Supreme Court, which is my point. It doesn't matter. This is going to be appealed no matter what. His convictions are going to be appealed no matter what. But here's the facts. He's had 4 competency tests. He's had 4 psychological evaluations that all came out saying he's perfectly competent to not only stand trial, but also represent himself. The last 2 were specifically geared towards that. Someone said that is the issue he can actually win a new trial on. No, it's not. It really isn't. Haram Lewis, a comment I just read about some Milwaukee Journal interviewed Brooks about conditions of the jail. He's going to be one of those people that will make correctional officers' job hard. Someone said, what was the story earlier? I'll do it during the lunch break. I can't do it right now. I don't want to. We're on a good mood right now. Right now. Big Bubba got him a Loom gift basket waiting on him to come home. What? A fucking AY? Where are these fucking trolls? Please don't write long comments on Facebook because then I automatically assume that you're trolling. I don't think you are. You're just saying stuff. But please don't write like novels on the Facebook comments because when it comes through my feed, I'm just like, it's fucking bullshit. Bullshit. Fuck, man. I hope no one steals my fucking shoes outside of my house. And I hope it doesn't rain. Kind of looks like it's going to rain. And then my shoes are going to get wet. Bum, 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 la, da, da. Haram Lewis said, I understand the law, and I'm saying that the U.S. Supreme Court can determine the failure to provide standby counsel is unconstitutional. Okay, so you think Haram Lewis, do you think that that's never been contested in the state of Wisconsin, ever? With someone representing themselves that doesn't get standby counsel? Do you think that's never been argued? Come on, bro. Come on. The fucker is guilty as shit. Please don't come in my chat trying to think of ways that he's going to get away with this and get new trials. And even if that's not your intention, that's what you're doing. You could mask that as rational thought, but I don't think it's rational. I think it's irrational. I am pissed off that we even have to have a trial for this guy. It's my humble opinion as the almighty chipmunk that he should have been taken out into the backyard. You know what I mean? 1 bullet. Costs like 30 cents. Actually, with Biden inflation, it's like $6 now, but whatever. Fuck that. Those are only facts. 0439 said, guess Steve only sees Facebook comments. Well, you're stupid. Because I just read your comment, so clearly it's not. Someone said, how long of a break are they taking? I have no idea because they said they were just bringing him into the courtroom. And yeah, it's just not anymore. Pissed off nurse said he jumps around. Jump around. Jump around. Sherry Vincent Carroll on Facebook said Haram is fucking something. I don't know. Whatever. The comments went too quick, so I can't read that shit. Court TV took a poll and 2% said mistrial, 2% said innocent. Well, because they're fucking stupid. Again, here's the idea that I had the other day. Like, you could make the argument that he didn't intend. If you go by Wisconsin case law, they have to prove that he intended to kill people. Not hurt, not maim, but intended to kill people. You know? You could make the argument that the state didn't prove that he intended to kill them. My opinion is that he did. But if you're going off of just what case law says for that state, then you would have to be like, was he actually intending, or was he just being stupid and running people over? The social media posts where he was talking about hating white people, those posts were not allowed to come in. His background on running people over in the past and facing charges for it and bail skipping and all that, yeah, it wasn't allowed to that's not allowed to come in. So you only, if you look from the eyes of a juror, Like, it's you don't have any of the information that we've gained outside of the jury room. You are just kind of left scratching your head. You know what I'm saying? But then again, his behavior inside the courtroom and what the jury has seen, and as much as the judge is trying to be neutral, she is being reactionary in her behavior, and I can't fault her for that at all. But she is being reactionary, so she's not taking the offensive on anything. And then when she is talking to the jury, she's got, you could tell she's had a rough day. You know what I mean? Rightfully so. Darrell Brooks is a fucking shithead. But Sane Goat said, I'm gonna go make some chili. Are you gonna make goat chili? Because if it's not goat chili, then fuck off. No, I'm just kidding. Your name had goat in it, so I said goat chili. Find it, fix it, said dropped freight. Okay, I'm assuming you did. Haram Lewis said intent could be inferred by reckless. Well, not in my definition. I know, but you're some big fancy lawyer. So, yep, you know more than me, Haram. Very good for you. Yep. I don't think intent can be inferred by recklessness. I know it can in the eyes of the law, but that's not my definition for intent. Intent means that you would intend to kill someone, to take their life. Do you know what I mean? And maybe that's been specified in the jury instructions today that I missed. I have no idea. Someone said you need to send the judge some coffee. Oh, speaking of which, did you guys know that today we're giving away a 32-inch flat screen Roku TV? All you have to do is go over to Gratis Cafe, GratisCafe, and order a bag of coffee. It's $17.99, free shipping, comes in whole bean and ground. We have 9 different flavors and roasts, including pumpkin spice, Italian, flying high, which has a shit ton of caffeine. We've got the medium house roast, which is the best coffee fucking roast ever. And then we have a shit ton more. French vanilla, breakfast blend, Supreme Dark, which is like inexpensive. That shit cost me $12 a pound for that fucking coffee because it's so good. It's so good. But yeah, go over there, order a bag of coffee, gratiscafe.com.
Appearances are
and you have a chance to win a TV. All right.
The record to reflect
Whoa. Phil Green said, is it Black Rifle Coffee? Actually, you wrote Black Rife. No, fuck them. That fake conservative woke shit.
My understanding is he is now saying he doesn't understand what this court wants. I've made it very clear.
Oh, now he's back in the courtroom.
Or not in the courtroom. Is that
that's why it took so long.
I continue with the jury instructions without interruption, that Mr. Brooks follow the rules of courtesy and decorum. He's had those for quite some time, and that he conduct himself consistently with the dignity and decorum that these proceedings deserve. And that includes not interrupting or bringing up legal matters that this court has previously ruled on. We have lost a significant amount of time now addressing, or not even addressing, but Mr. Brooks really interrupting the flow and the proceedings based upon his responses, and then he attempts to engage with this court on the meaning, for example, of Illinois versus Allen. He needs to make a very clear statement to this court, not an ambiguous one, but a very clear one, that he wants to come back into this courtroom and that he's willing to conduct himself appropriately. And until he does that, he will continue to forfeit his right to be present in this courtroom as I instruct the jury. So
hold on. Greg Grinker just made a comment on Facebook, which is completely and utterly false, and it has to be addressed. Greg Glinker said, another piece of information, BLM took responsibility for this the day it happened. Look it up. It was right after Rittenhouse was found innocent. Yes, this did occur right after. Actually, I believe the same day Rittenhouse was found innocent while protests were going on. A guy named Von Mays, who is not the spokesperson for BLM, said he wouldn't be surprised if this was in retribution for that. I actually interviewed Von Mays on my show, realized that he is just a complete and utter shithead that has no fucking brains. So yeah, that is not true, Greg Grinker on Facebook. Back to your regularly scheduled program.
Jurors go out. 11. I just want to put on the record that at 11:01 I took the break. It's now 11:48. So I intended to take 10, 15 minutes tops.
Haram, you're fine.
Mr. Brooks, you can write it down. I'm not going to interrupt further. The jury's coming out.
All rise. Get your asses up. Huh. Wave your hands like you just don't care. Oh, the jury's back. Oh, yeah. Oh, jury is back. The jury is back. Wait, whoa. Heather, what the fuck is that comment? Is that true? Is that true? You're gonna make me look up now. Jury is back. Jury is back. This is not fucking true. This is not you. That's not him. Is it? Is it? Whoa.
Thank you, everyone. Please be seated.
Hold the fucking horse's head.
Continuing on then with the jury instructions. If you are satisfied beyond a reasonable doubt.
Wait. Hold on. I gotta interrupt this for a second. Haram Lewis, tell me you are not from West Virginia. Haram Lewis, right now in the chat. Tell me you are not Haram Lewis from West Virginia. Tell me your middle name isn't Carson and you're 50 and you live in Procedural. Is that you? Is that you? Yeah, I didn't dox you. It's on a fucking news article. Is that you? There's no fucking way that's him. It could be another one, but you should change your name. If that is you, you should file to have your name changed. Hold on. I'm waiting for his comment. This is very important. Is that you, bro? Oh, is he not going to answer now? He's on Facebook. I don't know if it's the same fella. You want to hear the judge. We've been listening to this the whole time.
Count 45. If you are not so satisfied, you must find the defendant not guilty as to count 45. If you find the defendant guilty of count 45,
saying the same shit she's been saying for 4 hours.
Or no.
Haram
Did
Lewis.
The defendant commit the crime of first degree, recklessly endangering safety while using a dangerous weapon. If you are satisfied beyond a reasonable doubt that all 3 elements of first degree recklessly endangering safety have been proved as to count 46, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 46. If you are not so satisfied, you must find the defendant not guilty as to count 46. If you find the defendant guilty of count 46, you must answer the following question, yes or no. Did the defendant commit the crime of first degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all 3 elements of first degree recklessly endangering safety have been proved as to count 47, you should find the defendant guilty of first degree recklessly endangering safety as charged in count 47. If you are not so satisfied, you must find the defendant not guilty as to count 47.
Is that fucking you?
If you find the defendant guilty...
Whoa. So the guy that's been giving legal advice in my chat... Thank you for your service, by the way. The guy that's been giving legal advice in my chat... Is this... hold on. Let me just say this. Dude, don't give legal advice to anybody. You shouldn't be giving legal advice to anyone. Now you're going to make me look this shit up. I don't really... It fucking looks a lot like you, homie. Are you kidding me, bro? So the guy that's giving legal advice in the chat, this year, January 5th, 2022, apparently, someone by his same name, don't know if it's him, okay? Full clarity. Don't know if it's him. But someone by a...
Same name. So let's say it this way. Clay County, West Virginia. A former candidate for West Virginia Attorney General and State Supreme Court has been jailed on animal cruelty charges stemming from an alleged incident in Clay County in 2019. Haram Carson Lewis of Procedural was booked Tuesday into the Central Regional Jail where he was being held on an $8,800 bond on charges to cruelty to animals and animal abandonment in Clay County. A $5,000 bond was listed for Lewis from charges in Roane County, but those charges are not immediately available. The criminal complaint filed in Clay County said the charges stem from an incident reported December 1st, 2019, in which a resident in Orma contacted the sheriff's office and said a horse belonging to Lewis had been abandoned on the property. According to the complaint, the resident said neighbors had not seen Lewis for about 3 weeks, and the resident had been feeding and caring for the horse while the resident stayed at a camp near Lewis's property. The complaint said a deputy made multiple attempts to locate Lewis and had no success. He previously made unsuccessful runs for Attorney General and Supreme Court. Media reports indicate he was charged with malicious wounding and wanton endangerment in 2012, but was acquitted of those charges. He said in media reports he should have never been arrested and was trying to defend himself. Is that you? Are you accused of what, or were you accused of animal cruelty? The pictures look very similar to you. And you didn't, based on the pictures that have been posted online, don't appear, I mean, the animal looks like it's in good condition. But here's the thing, like if someone said it's you, but it's fake news and you're suing for defamation. You were charged with it. It's not fake news. And that's why we just read it in the way we did. This comes from Eyewitness News, WCHS Fox 8 and 11. I don't know how it's false news when the actual charging documents. That's crazy, dude. That's crazy. Yeah, please don't give legal advice in my chat. Please. Please. I don't know. I mean, I'm looking at the horse and it said near the foundation of a flooded house in Elk River with no food or water last month and been taking care of it since then. Yeah, just don't. Yeah, wrong chat for you, buddy.
You should find the defendant guilty of first degree.
I don't really like
endangering
people
safety as charged
that are
count
accused
54.
of animal cruelty.
If you are not so satisfied, you must find the defendant not guilty as to count 54. If you find the defendant guilty of count 54, you must answer the following question, yes or no. Did the defendant commit the crime of first degree, recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree, recklessly endangering safety have been proved as to count 55, you should find the defendant guilty of first degree, recklessly endangering safety as charged in count 55. If you are not so satisfied, you must find the defendant not guilty as to count 55. If you find the defendant guilty of count 55, you must answer the following question, yes or no. Did the defendant commit the crime of first degree, recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree, recklessly endangering safety have been proved as to count 56, you should find the defendant guilty of first degree, recklessly endangering safety as charged in count 56. If you are not so satisfied, you must find the defendant not guilty as to count 56. If you find the defendant guilty of count 56, you must answer the following question, yes or no. Did the defendant commit the crime of first degree, recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree, recklessly endangering safety have been proved as to count 57, you should find the defendant guilty of first degree, recklessly endangering safety as charged in count 57. If you are not so satisfied, you must find the defendant not guilty as to count 57. If you find the defendant guilty of count 57, you must answer the following question, yes or no. Did the defendant commit the crime of first degree, recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree, recklessly endangering safety have been proved as to count 58, you should find the defendant guilty of first degree, recklessly endangering safety as charged in count 58. If you are not so satisfied, you must find the defendant not guilty as to count 58. If you find the defendant guilty of count 58, you must answer the following question, yes or no. Did the defendant commit the crime of first degree, recklessly endangering safety by using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all three elements of first degree, recklessly endangering safety have been proved as to count 59, you should find the defendant guilty of first degree, recklessly endangering safety as charged in count 59. If you are not so satisfied, you must find the defendant not guilty as to count 59. If you find the defendant guilty of count 59, you must answer the following question, yes or no. Did the defendant commit the crime of first degree, recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 60, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 60. If you are not so satisfied, you must find the defendant not guilty as to count 60. If you find the defendant guilty of count 60, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 61, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 61. If you are not so satisfied, you must find the defendant not guilty as to count 61. If you find the defendant guilty of count 61, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 62, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 62. If you are not so satisfied, you must find the defendant not guilty as to count 62. If you find the defendant guilty of count 62, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 63, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 63. If you are not so satisfied, you must find the defendant not guilty as to count 63. If you find the defendant guilty of count 63, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 64, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 64. If you are not so satisfied, you must find the defendant not guilty as to count 64. If you find the defendant guilty of count 64, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 65, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 65. If you are not so satisfied, you must find the defendant not guilty as to count 65. If you find the defendant guilty of count 65, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree reckless endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 66, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 66. If you are not so satisfied, you must find the defendant not guilty as to count 66. If you find the defendant guilty of count 66, you must answer the following question, yes or no. Did the defendant commit the crime of first-degree recklessly endangering safety while using a dangerous weapon? If you are satisfied beyond a reasonable doubt that all 3 elements of first-degree recklessly endangering safety have been proved as to count 67, you should find the defendant guilty of first-degree recklessly endangering safety as charged in count 67. If you are not so satisfied, you must find the defendant not guilty as to count 67. If you find the defendant guilty of count 67, you must answer the following question, yes or no. Did the defendant commit the crime of first degree, recklessly endangering safety while using a dangerous weapon? The defendant is charged with 6 separate counts of violating a duty after having been involved in an accident resulting in death. The 68th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021 on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in it.
Hey, real quick, just because I think it's important. So the Haram guy, we didn't ban him. Obviously, we're not going to. He admitted to everything, all the allegations against him extremely fast. And usually you don't see guilty people do that. So I'm going to give him the benefit of the doubt because he's saying it was corrupt politicians and judges and police, blah, blah, blah. We know that does happen. Look at Donald Trump. We know it does happen. And because he was military, I'm going to give him the benefit of the doubt for that. I am curious if he is a practicing attorney. I asked you on the chat. You should answer that because you should come on the show tonight. If you are licensed and to practice, you should come on the show tonight and talk about the case and what we've seen thus
render
far.
Reasonable assistance to any person injured in the accident, including transporting or making arrangements to transport the person to a physician, surgeon, or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary or if requested by the injured person, contrary to Section 346.67 sub 1 and 346.74 sub 5 sub D and 939.50 sub 3 sub D of the Wisconsin statutes. The 69th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Leanna Owen and failed to reasonably investigate what was struck, and if the operator knew or had reason to know that the accident resulted in injury or death of a person, and failed to stop the vehicle he was operating as close to the scene of the accident as possible and remain at the scene of the accident until he did all of the following. Give his name, address, and the registration number of the vehicle he was operating to the operator or occupant of or person attending any vehicle collided with, and upon request and if available, exhibit his operator's license to the operator or occupant of or person attending any vehicle collided with, and render reasonable assistance to any person injured in the accident, including transporting or making arrangements to transport the person to a physician, surgeon, or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary or if requested by the injured person, contrary to Section 346.67 sub 1 and 346.74 sub 5 sub D and 939.50 sub 3 sub D of the Wisconsin statutes. The 70th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Tamara Durand and failed to reasonably investigate what was struck, and if the operator knew or had reason to know that the accident resulted in injury or death of a person, and failed to stop the vehicle he was operating as close to the scene of the accident as possible and remain at the scene of the accident until he did all of the following. Give his name, address, and the registration number of the vehicle he was operating to the operator or occupant of or person attending any vehicle collided with, and upon request and if available, exhibit his operator's license to the operator or occupant of or person attending any vehicle collided with, and render reasonable assistance to any person injured in the accident, including transporting or making arrangements to transport the person to a physician, surgeon, or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary or if requested by the injured person, contrary to Sections 346.67 sub 1, 346.74 sub 5 sub D, and 939.50 sub 3 sub D of the Wisconsin statutes. The 71st count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Jane Kulik and failed to reasonably investigate what was struck, and if the operator knew or had reason to know that the accident resulted in injury or death of a person, and failed to stop the vehicle he was operating as close to the scene of the accident as possible and remain at the scene of the accident until he did all of the following. Give his name, address, and the registration number of the vehicle he was operating to the operator or occupant of or person attending any vehicle collided with, and upon request and if available, exhibit his operator's license to the operator or occupant of or person attending any vehicle collided with, and render reasonable assistance to any person injured in the accident, including transporting or making arrangements to transport the person to a physician, surgeon, or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary or if requested by the injured person, contrary to sections 346.67 sub 1, 346.74 sub 5 sub D, and 939.50 sub 3 sub D of the Wisconsin statutes. The 72nd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Wilhelm Hospital and failed to reasonably investigate what was struck, and if the operator knew or had reason to know that the accident resulted in injury or death of a person and failed to stop the vehicle he was operating as close to the scene of the accident as possible and remain at the scene of the accident until he did all of the following: give his name, address, and the registration number of the vehicle he was operating to the operator or occupant of or person attending any vehicle collided with, and upon request and if available, exhibit his operator's license to the operator or occupant of or person attending any vehicle collided with, and render reasonable assistance to any person injured in the accident, including transporting or making arrangements to transport the person to a physician, surgeon, or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary or if requested by the injured person, contrary to sections 346.67 sub 1, 346.74 sub 5 sub D, and 939.50 sub 3 sub D of the Wisconsin statutes. The 73rd count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, did operate a vehicle involved in an accident that resulted in the death of Jackson Sparks and failed to reasonably investigate what was struck, and if the operator knew or had reason to know that the accident resulted in injury or death of a person and failed to stop the vehicle he was operating as close to the scene of the accident as possible and remain at the scene of the accident until he did all of the following: give his name, address, and the registration number of the vehicle he was operating to the operator or occupant of or person attending any vehicle collided with, and upon request and if available, exhibit his operator's license to the operator or occupant of or person attending any vehicle collided with, and render reasonable assistance to any person injured in the accident, including transporting or making arrangements to transport the person to a physician, surgeon, or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary or if requested by the injured person, contrary to sections 346.67 sub 1, 346.74 sub 5 sub D, and 939.50 sub 3 sub D of the Wisconsin statutes. The defendant has entered a plea of not guilty to each of these charges, which means the state must prove every element of each offense charge beyond a reasonable doubt. Section 346.67 of the Wisconsin statutes, commonly referred to as hit and run, is violated when the operator of any vehicle involved in an accident on a highway fails to reasonably investigate what was struck, and if the operator knows or has reason to know that the accident resulted in death of a person, fails to stop the vehicle he is operating as close to the scene of the accident as possible, and remain at the scene of the accident until the operator has given information and rendered reasonable assistance to any person injured in the accident. Before you may find the defendant guilty of any count of hit and run, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 4 elements were present with respect to that count. 1. As to each count, the defendant operated a vehicle involved in an accident on a highway. A vehicle is operated when it is set in motion. 2. As to each count, the defendant knew that the vehicle he operated was involved in an accident on a highway. 3. As to each count, the defendant violated a duty after being involved in an accident. A driver who is involved in an accident has 2 duties. The state is required to satisfy you beyond a reasonable doubt that the defendant violated at least one of the 2 duties, but you are not required to agree as to which duty was violated. The first duty is to reasonably investigate what was struck. The second duty is that a driver involved in an accident involving a person must stop and provide information and render aid. To prove a violation of this duty, the state must prove the following beyond a reasonable doubt: that the defendant knew or had reason to know that the vehicle he was operating was involved in an accident involving a person, and that the accident resulted in death of a person, and that the defendant did not immediately stop his vehicle as close to the scene of the accident as possible and remain at the scene until he had done all of the following. A, give his name, address, and the registration number of the vehicle he was driving to the person struck. And B, if it was requested and was available, exhibit his operator's license to the person struck. And C, rendered reasonable assistance to any person injured in the accident, including the transporting or making arrangements to transport the person to a physician, surgeon, or hospital for medical or surgical treatment if it is apparent that medical or surgical treatment is necessary or is requested by the injured person. 4, the defendant was physically capable of complying with these requirements. You cannot look into a person's mind to find knowledge. What a person knows or has reason to know must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon knowledge. The information alleges not only that the defendant committed the crimes of hit and run, but also that the accident resulted in the death to a person. If you find the defendant guilty of a count of hit and run, you must answer the following question, yes or no. Did the accident involve death to a person? Before you may answer yes, you must be satisfied beyond a reasonable doubt that the answer to that question is yes. If you are not so satisfied, you must answer the question no. If you are satisfied beyond a reasonable doubt that all 4 elements of hit and run have been proved as to count 68, you should find the defendant guilty of hit and run as charged in count 68. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Virginia Sorensen? If you are satisfied beyond a reasonable doubt that all 4 elements of hit and run have been proved as to count 69, you should find the defendant guilty of hit and run as charged in count 69. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Leanna Owen? If you are satisfied beyond a reasonable doubt that all 4 elements of hit and run have been proved as to count 70, you should find the defendant guilty of hit and run as charged in count 70. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Tamara Durand? and I will specifically address Mr. Brooks at a later point. Count 71. If you are satisfied beyond a reasonable doubt that all 4 elements of hit and run have been proved as to count 68, you should find the defendant guilty of hit and run as charged in count 68. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Jane Kulik? If you are satisfied beyond a reasonable doubt that all 4 elements of hit and run have been proved as to count 72, you should find the defendant guilty of hit and run as charged in count 72. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Wilhelm Hospital? If you are satisfied beyond a reasonable doubt that all 4 elements of hit and run have been proved as to count 73, you should find the defendant guilty of hit and run as charged in count 73. If you are not so satisfied, you must find the defendant not guilty. If you find the defendant guilty, you must answer the following question, yes or no. Did the accident involve death to Jackson Sparks? The defendant is charged with 2 separate counts of bail jumping. The 74th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, having been charged with a felony and having been released from custody under Chapter 969 of the Wisconsin statutes, did intentionally fail to comply with the terms of his bond, contrary to Section 946.49 sub 1 sub B and 939.50 sub 3 sub H of the Wisconsin statutes. The 75th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, on Main Street in the city of Waukesha, Waukesha County, Wisconsin, having been charged with a felony and having been released from custody under Chapter 969 of the Wisconsin statutes, did intentionally fail to comply with the terms of his bond, contrary to Sections 946.49 sub 1 sub B and 939.50 sub 3 sub H of the Wisconsin statutes. Bail jumping, as defined in Section 946.49 sub 1 of the Criminal Code of Wisconsin, is committed by one who has been released from custody on bond and intentionally fails to comply with the terms of the bond. Before you may find the defendant guilty of any count of bail jumping, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 3 elements were present with respect to that count. 1, as to each count, the defendant was charged with a felony. A felony is a crime punishable by imprisonment in the Wisconsin state prisons. 2, as to each count, the defendant was released from custody on bond. This requires that after being charged, the defendant was released from custody on bond under conditions established by a court commissioner. 3, as to each count, the defendant intentionally failed to comply with the terms of his bond. This requires that the defendant had the mental purpose to fail to comply with the terms of his bond. This also requires that the defendant knew of the terms of the bond and knew that his actions did not comply with those terms. The defendant is charged with violating a condition of bond that required that he not commit any crime. The state alleges that the defendant committed the crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, hit and run, resulting in death, and battery. The state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant committed the crime of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, hit and run resulting in death, or battery. The state is required to satisfy you beyond a reasonable doubt that the defendant committed a crime, but you are not required to agree on which one. The crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, and hit and run resulting in death have already been defined for you, and you should apply the same definition here. Battery will be defined in just a bit, and you should apply that definition here as well. You cannot look into a person's mind to find intent or knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent and knowledge. If you are satisfied beyond a reasonable doubt that all three elements of bail jumping have been proved as to count 74, you should find the defendant guilty of bail jumping as charged in count 74. If you are not so satisfied, you must find the defendant not guilty as to count 74. If you are satisfied beyond a reasonable doubt that all three elements of bail jumping have been proved as to count 75, you should find the defendant guilty of bail jumping as charged in count 75. If you are not so satisfied, you must find the defendant not guilty as to count 75. The 76th count of the information in this case charges that Darrell E. Brooks, on or about Sunday, November 21 of 2021, near Frame Park in the city of Waukesha, Waukesha County, Wisconsin, did cause bodily harm to Erica Patterson by an act done with intent to cause bodily harm to that person without that person's consent, contrary to section 940.19 sub 1, 939.51 sub 3 sub A, and 968.075 sub 1 sub A of the Wisconsin statutes. Battery, as defined in section 940.19 sub 1 of the Criminal Code of Wisconsin, is committed by one who causes bodily harm to another by an act done with intent to cause bodily harm to that person or another without the consent of the person so harmed. Before you may find the defendant guilty of battery, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following four elements were present. 1. The defendant caused bodily harm to Erica Patterson. Cause means that the defendant's act was a substantial factor in producing the bodily harm. Bodily harm means physical pain or injury, illness, or any impairment of physical condition. 2. The defendant intended to cause bodily harm to Erica Patterson. Intent to cause bodily harm means that the defendant had the mental purpose to cause bodily harm to another human being or was aware that his conduct was practically certain to cause bodily harm to another human being. 3. The defendant caused bodily harm without the consent of Erica Patterson. 4. The defendant knew that Erica Patterson did not consent. You cannot look into a person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent and knowledge. If you are satisfied beyond a reasonable doubt that all four elements of battery have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. I want to go back to the bail jumping, because the battery is not part of that charge. And there's an inclusion of that in the jury instruction that I will have corrected. So I'm going to read the definition, the substantive instruction on bail jumping once again, starting with what the charges are. Well, the charges I've already read, they will stand. So bail jumping as defined in section 946.49 sub 1 of the Criminal Code of Wisconsin is committed by one who has been released from custody on bond and intentionally fails to comply with the terms of that bond. Before you may find the defendant guilty of any count of bail jumping, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 3 elements were present with respect to that count. 1, as to each count, the defendant was charged with a felony. A felony is a crime punishable by imprisonment in the Wisconsin state prisons. 2, as to each count, the defendant was released from custody on bond. This requires that after being charged, the defendant was released from custody on bond under conditions established by a court commissioner. 3, as to each count, the defendant intentionally failed to comply with the terms of the bond. This requires that the defendant had the mental purpose to comply with the terms of the bond. This also requires that the defendant knew of the terms of the bond and knew that his actions did not comply with those terms. The defendant is charged with violating a condition of bond that required that he not commit any crime. The state alleges that the defendant committed the crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, and hit and run resulting in death. The state must prove by evidence which satisfies you beyond a reasonable doubt that the defendant committed the crime of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, or hit and run resulting in death. The state is required to satisfy you beyond a reasonable doubt that the defendant committed a crime, but you are not required to agree on which one. The crimes of first-degree intentional homicide, use of a dangerous weapon, first-degree recklessly endangering safety, use of a dangerous weapon, and hit and run resulting in death have already been defined for you, and you should apply the same definitions here. You cannot look into a person's mind to find intent or knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that all 3 elements of bail jumping have been proved as to count 74, you should find the defendant guilty of bail jumping as charged in count 74. If you are not so satisfied, you must find the defendant not guilty as to count 74. If you are satisfied beyond a reasonable doubt that all 3 elements of bail jumping have been proved as to count 75, you should find the defendant guilty of bail jumping as charged in count 75. If you are not so satisfied, you must find the defendant not guilty as to count 75. An information is nothing more than a written formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. The defendant has a constitutional right to represent himself. I have advised the defendant that the same rules apply whether a lawyer acts for him or he acts for himself. The defendant has decided to represent himself, and this decision must not influence your verdict in any manner. At times, Mr. Brooks has appeared from another courtroom. This must not influence your verdict in any way. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence which satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. The identification of the defendant is an issue in this case, and you should give it your careful attention. You should consider the reliability of any identification made by a witness, whether made in or out of court. You should consider the credibility of a witness making an identification of the defendant in the same way you consider credibility of any other witness. Identification evidence involves an expression of belief or impression by the witness. Its value depends on the opportunity the witness had to observe the offender at the time of the offense and later to make a reliable identification. Consider the witness's opportunity for observation, how long the observation lasted, how close the witness was, the lighting, the mental state of the witness at the time, the physical ability of the witness to see and hear the events, and any other circumstances of the observation. You should also consider the period of time which elapsed between the witness's observation and the identification of the defendant and any intervening event which may have affected or influenced the identification. In evaluating the identification evidence, you are to consider those factors which might affect human perception and memory and all the influences and circumstances relating to the identification. Then give the evidence the weight you believe it should receive. If you find that the crime alleged was committed, before you may find the defendant guilty, you must be satisfied beyond a reasonable doubt that the defendant is the person who committed the crime. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. You are to decide the case solely on the evidence offered and received at trial. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that the defendant committed the offense before you may find the defendant guilty. Evidence has been presented relating to the defendant's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe deserves under all of the circumstances. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received as evidence whether or not it goes to the jury room. Parties for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of parties, the court is not indicating any opinion about the evidence. You jurors are the judges of the credibility of the witnesses and the weight of the evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. During the trial, the court has ordered certain testimony to be stricken. Disregard all stricken testimony. The weight of evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to greater weight than that of another witness, or even of several other witnesses. Remarks of the parties are not evidence. If the remarks suggested certain facts not in evidence, disregard the suggestion. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability of the witnesses and of the weight to be given to their testimony. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same here. Evidence has been received that 2 of the witnesses in this trial have been convicted of a crime. This evidence was received solely because it bears upon the witness's character for truthfulness. It must not be used for any other purpose. Ordinarily, a witness may testify only about facts. However, a witness with specialized knowledge in a particular field may give an opinion in that field. In determining the weight to give to this opinion, you should consider the qualifications and credibility of the witness, the facts upon which the opinion is based, and the reasons given for the opinion. Opinion evidence was received to help you reach a conclusion. However, you are not bound by any witness's opinion. During the trial, a witness was told to assume certain facts and then was asked for an opinion based upon that assumption. This is called a hypothetical question. The opinion does not establish the truth of the facts upon which it is based. Consider the opinion only if you believe the assumed facts upon which it is based have been proved. If you find that the facts stated in the hypothetical question have not been proved, then the opinion based on those facts should not be given any wait. At this time, I will reserve the instruction on closing arguments because we are going to take our lunch break and then come back after the lunch hour for closing arguments. All rise for the jury. All right, thank you. Be seated. As soon as the doors close, I just need to put a couple things on the record. As I read, the doors closed, right? There we go. As I read through the bail jumping, it dawned on me that the battery should not be referenced because the battery was not on Main Street. And so I took it out because the way that the charge and the information reads, and we had that discussion preliminarily, which is why later on it doesn't reference the instruction for battery. So I cleaned that up by rereading it and taking that out. So I wanted to make a record of that. Obviously, I will need to have a new set made that has that correction. And I apologize for not catching that previously. But obviously I caught that as I read it. There was one other heading that said preliminary on, I think it was instruction 70. I need to cross that out. And I think I found the word a or depending on how you say it, missing from one thing. I'm going to add that in, and I'll have that for the parties. And then I did note that at approximately 12:19, it may have been a little bit earlier than that, but I noticed Mr. Brooks was waving his hands. At one point, I did indicate I would address that at a later point in time. I am aware of a number of filings. I addressed 2 of them previously, but there are 2 additional. I am going to have copies made of all of these filings for the state so that they have an opportunity to review them. From my perspective, just briefly, he's making some objections to what I am doing, but at no time in those did he ask to be brought back to the courtroom, and certainly within those, he did not pledge to follow the basic tenets of courtesy and decorum. Given where I was at in the proceedings with the reading of the preliminary instructions, and given the court's prior finding that he had forfeited his right to be present, I thought it important to get through the reading of the instructions up until the point of the closing argument instruction, which I reserved because I'll review that with the jury when they come back prior to the parties being given their opportunity to give closing arguments. I will also be advising Mr. Brooks that given that I'm moving on to a second part of this, that being the closing arguments, he will be invited back into the courtroom here for those closing arguments, of course, subject to his conduct. I expect that he will follow the rules of courtesy and decorum and also not raise legal issues in front of the jury when they are here. With that, we will take our lunch recess. It's 12:47. We'll take an hour and 15 minutes. Thank you, everyone. So, yeah.
How long did she say it was going to be? I wasn't paying attention. Did she say an hour and 20 minutes? That's a long one. I don't know why they're taking such a long break. You know, they could do a shorter one. Hour and 15 minutes, she said. So they'll be back at 3 o'clock Eastern time, 2 o'clock Western. Huh. Very interested in something that I just discovered. Interesting. Bear with me 1 second. I'm going to keep reading some of the stuff. Oh, this is just stupid shit. April, did you see that email that we just got a few minutes ago from somebody? If you did, look at 01-5. And then slack me what your thoughts are. Pay attention to the name and where that name says they work. Oh, let's see if my lawyer wants to get involved. Anyway, fun stuff, man, huh? Fun stuff. So now it's the big time. We got the big time coming up because we have the closing arguments. Now, we're going to have to wait and see if Darrell Brooks is going to be allowed in the courtroom. How they handle that if he's not allowed in the courtroom is going to be mildly entertaining. Because how are they going to handle his objections? You can't, and I'm not a lawyer, but I don't think you can have him objecting. Like, you need to be able to object live as it's going, right? Because otherwise, even if you instruct the jury to not listen to something. I want to see if April. Now I'm just waiting for April to reply. It's the first paragraph, April, in that thing that I mentioned. That's the only thing that matters. Just that first paragraph. So you guys remember, well, it doesn't matter. It's already been filed, so I could say it. So you guys remember how I'm facing $5.5 million worth of lawsuits for our coverage into a company called Nexus Services. The company and their executives were served with major search warrants a couple of weeks ago for allegations of fraud, allegations of financial misconduct, and sexual assault allegations as well. Sexual assault, rape, allegations. So I just got my hands on a court document for a recently filed lawsuit. And one of those things, you may remember, so I'm getting sued by there's two different lawsuits. One's for $2.5 million. The other's for like $3 million. One is from Michael Donovan, the guy that's going to go to jail for a long time, because he said I ruined his relationship with Tucker Carlson by saying that he stages protests outside of people he has disagreements with, which is a fact. We know that. But and we have all the proof. That's why that court case is going nowhere. The other one is by a guy named Eric Schneider. Eric Schneider owned an investigations company unknown to us. I didn't know that Eric Schneider owned it. And to be honest, we never even wrote about Eric Schneider ever prior to these lawsuits because he was the only one that was affiliated with Nexus Services that didn't have a felony record. So Eric Schneider, so we wrote an article about Nexus Services having a government contract to do the fingerprinting of aspiring police officers, teachers, first responders, and things like that. The address was registered to Nexus's compound, and we were told about it from a whistleblower, essentially, someone that reached out to us and was like, hey, I bet you didn't know this. So we did a little bit of digging. We found out that Fieldprint was a contractor that apparently hired this Nexus affiliated company to do the fingerprinting, right? So we wrote about that. We contacted Fieldprint. They refused to give us any sort of comment on it, but then they terminated their contract with Nexus, with the company that had the contract with them. Now that company and its owner, Eric Schneider, sued me for $2.5 million because they lost that contract. Eric Schneider, in his actual complaint, he said that we inappropriately tied him to Nexus Services that he wasn't an employee of Nexus and had nothing to do with Nexus and only merely rented an office from that, which we know is false because of his social media profile showing that he's the director of risk management for Nexus Services. Well, we just got a sworn statement that has something to do with a different court case where Eric Schneider, at the very same time that he said in a sworn document that he had nothing to do with Nexus Services, we have him literally saying he's the director of risk management for Nexus Services in an actual statement, like a witness statement. So I may not wait until they're all done and deal with the anti-slap stuff. Like literally, like these guys, we did a motion for sanctions because they lied in their complaint. You can't do that. And the motion for sanctions after the hearing, it was tabled. And so that's still outgoing. I'm going to see what my lawyer says, but I think we're going to fire back right now. I mean, I've already paid the lawyer. I think I need to fire back right now and prove that they lied to the court. If a motion for sanctions isn't justified before, well, guess what? It is now because we have that we could prove that they lied to the court. And so I just got that email like 5 minutes ago, and I'm reading through all these other, stupid shit. I'm reading through them all. And then I get to this sworn statement from the very same guy, and their lawyers must have been sleeping and not paying attention because I don't know if it would be called perjury. That'd be a question for actual lawyers. If someone says in a complaint that they don't work and have no connections with said company, and then in a different lawsuit, they say that at the very same time that I wrote the article that this person is employed by this company and they lied about it. Yeah, it's mildly entertaining. I hope that my attorney wants to deal with it because otherwise I'm just going to do it to myself. After watching all these lies, I'm a lawyer now, but
I can't have this voice. Like, it would be funny if I could have this. Can I just suck on helium?
when I'm alive in a courtroom. I used to want to be a lawyer. In fact, watching this trial and the show I was watching on Hulu, I even turned to my wife and I'm like, man, I should have been a lawyer. And she's like, you always say that when you watch these shows or when you cover trials. Because I'd probably be a good damn lawyer. You know what I mean? But then the amount of schooling that you'd have, I think I would have to go back again, or at least finish my undergraduate degree because I've never finished it. Go back, do that, and then find some law school that would allow me in. Can you imagine that? That would be funny. Someone said if it's a sworn statement that all statements are true and correct. Yeah, well, this document here is a sworn statement. His original one wasn't a statement as more as it was a complaint. And I got to look back to it. Yeah, this is a sworn affidavit, the one where he said now. And they just filed this. They filed this today. That's how quick we get shit because we got people everywhere. Actually, we just got all these people flagged. So the second they file anything, we know. But yeah, it says, I worked as senior investigator for Nexus Services. My responsibilities, and he says the entirety of the year of which I wrote the article, which he said he had no commonality with the company. This is like, oh my God. Oh my God. Oh my gosh. You'd win a lot of voices.
Objection, Your Honor.
Can you imagine having that voice? Get your master's and do 3 years of law school. Does anyone know how you send stars that won't let you anymore? Huh? I don't know. Someone said I should do it. I've got too much on my plate. There's no way in hell I'm going back to school. Plus, I fucking hate college. It's worthless. I know more than the professors. Like when I was going for logistics and supply chain with a concentration of reverse logistics, I knew more than my instructors because I actually work in the industry. At that time, I worked in the industry. I was an executive within the industry, and these people hadn't worked in logistics in 10 or 15 years, but they're teaching it. So they didn't know shit. And I used to argue with them about everything. And they'd be like, oh, the pricing for this. I'm like, you're stupid. That's not the pricing for anything right now. When's the last time you moved freight? But yeah, 6 years is how long it takes to become a lawyer. Yeah, but that includes undergraduate. So it's, from what I understand, it's 4 years undergrad and 2 years for graduate studies. Isn't that what it is? I don't know. I don't have the time. But hey, guess what? If I quit doing all this and stop making money, guess what? You guys would have to pay for my college. Right? Because of Biden. Except, even though that's not really going to happen, maybe I should just do that. Maybe just say, hey, listen, I'll go to school. You guys pay for my college. Isn't that what people do now? They GoFundMe that shit. Fucking stupid. I would not do that. Yeah, like, there's no reason for me even to go back to school. What is the Flying High coffee flavor? Flying High. It's just regular coffee. It's Flying High because it's got a lot of caffeine. Read the descriptions, people. I'd be a good fucking lawyer, though, man. I used to dream about being a lawyer. When I was a teenager, when I was a troublemaker and all that, the staff members of group homes and stuff used to call me F. Lee Oatley, after F. Lee Bailey, because I could argue anything. I really did, for a long time, thought I'd be a lawyer because I like to argue, and I was good at it. Noel said, do we sell K-Cup coffee? We did for a little bit, but I'm not doing it anymore. It takes too long for us to do it. Someone said, don't join the dark side. Not all lawyers are bad. I've got a good lawyer. No. Kevin Cosgrove asked, so is a court in recess now until the jury comes back with a verdict? No. What's going on now is they're on lunch break. When they come back, we have closing arguments. First, the state's going to go. Then Brooks is going to go. And then the state has a rebuttal should they choose to rebut whatever Brooks says. And then the jury will retire. My guess is what's going to end up happening is they're going to come back at 3:00. And then Darrell Brooks is going to do the same thing about whether or not he wants to be in the courtroom. They're going back and forth about it. Eventually, they're going to end up kicking him off. And then that's how it's going to go. You know what I mean? And then he's going to be sent to the other room. Finally, probably around 3:30 Eastern time. They'll get to the closing arguments for the state. The state said they had anywhere from 30 to 45 minutes of closing arguments, at which time then Darrell Brooks will be allowed to do his closing arguments. My guess is there's going to be a tremendous amount of objections to both the state. He's going to object to everything. They're going to end up having to mute him. And then with I believe the state's going to object to virtually everything because I think he is going to bring in jury nullification, especially with the way that the judge argued about jury nullification yesterday. I do believe Darrell Brooks will mention it in an effort to have her flip out in the courtroom. I would not be surprised if he does that. Now, jury nullification, it caught me off guard, was something I didn't understand you couldn't do. Jurors are not allowed. They have to convict based on evidence. I know. Like if they find that someone did the job, did the crime in that jury room, they have to convict him. They can't say, well, you know what? He was justified in committing the crime. They can't do that, apparently. That's jury nullification. And I may be dumbing it down, but I never knew that. I didn't know you could get kicked off a jury for speaking about jury nullification. In fact, there's been several times. There's been whole juries that have been sequestered or even criminally charged. Granted, those were back, in the early 1900s, 1800s, where juries were fully reprimanded for, basically saying, okay, we know the law was broken, but we're going to overlook it for this person, which is crazy, But then again, I didn't think, I never thought that would be as big of a deal in the first place. You know what I'm saying? You know what I mean? I'm hot. The air is on. The air is going to be cold and then hot and then cold and hot again. Holy shit, soundtrack Zian Clark said, not all lawyers are bad. I have one basically told my dad that he could sue him because my dad was helping him as a AAA driver and the truck rolled back and squished him and the lawyer didn't have a license to move the truck. Oh, shit. Like in a divorce, usually no one wins except the attorneys who get paid. Yeah, well, that's why, originally with the court case that I have, I spoke to one of the most well-known. Hold on, I'm just updating our goal. Shout out to that $49.99 YouTube. I spoke to one of the most well-known attorneys, actually, like a phone call. I reached out to her on Facebook. Fuck, I'm wearing a green shirt. That was stupid. So my shoulder's disappearing because I'm wearing a green shirt in front of a green screen. That's really smart, Steve. Let me see if I can I fix it? Kind of. There we go. But yeah, this is a green shirt. It's changed the color because that's a much brighter green back there. But whatever. Yeah, but I spoke to a really high, when I first got served with these lawsuits, I spoke to a really, really high priced, well-known, you guys would all know who it is. She's always on the news channel. She's always super active on social media. And I had a conversation with them about, my lawsuit and, I sent them everything. I sent them the complaints. I sent them the articles that we wrote that they were saying were bullshit. And I said what my plan was. I wanted to go after these guys, and she's like, okay, well, it will be, I forgot what the retainer was just to do the answer to the complaint. It was like $40,000 or something astronomical. And I'm like, so much for being free speech or, a free speech fighter and all that. But what they said is they knew who these people were. They knew who they were. And this law firm is based on the other side of the fucking country. But they knew who they were by reputation, and they weren't going to sue them because they knew even when they win, and they're like, you will win, but you're not going to get any money out of them. If you do an anti-SLAPP lawsuit, sure, you're going to win, but you're not going to get any money out of them because they don't pay any judgments. They don't pay sanctions. They've been sanctioned. They've got judgments out the ass, and they just don't pay them. So no attorney is going to actually take the case on a pro bono thing. So we found an attorney. We paid the attorney. He filed the motions. And granted, it's not, I don't really have to fight with him too much to do stuff. But right now he's like, why are you going to do anything? Let's just wait because now it's in their ball court. And I'm like, I don't want a lawsuit out, even though they're not doing shit. I don't want them to have that power, but kind of lost that battle because I didn't want to pay more money. With this, however, this may be interesting because I think I could prove, well, I don't know how it works. I'm not a lawyer, so I would have to look it up. But they lied on their original complaint, their original lawsuit to me. They said they had nothing to do with Nexus, which now, based on this sworn affidavit, was a fucking lie. And you can't lie in court documents, Someone said there's someone else sharing the case doing the voice changer. Bullshit. Really? Someone's stealing my ideas? What assholes. Hey, if it works, it works. I don't frown. I've turned your frown upside down. I don't care. So there was this video that's going to be released here in a minute. President Biden receives his updated COVID-19 vaccine and delivers remarks. He's getting booster number 17, allegedly. I bet he's not even getting a booster. I bet he's not getting anything. I bet it's sugar water. And he's like, yeah, I'm getting boosted. And then he goes back into the back. He's like, I'm not fucking putting that shit in my body. Can you imagine? I wouldn't be surprised at all. But someone said yours is better in terms of my badass commentary. Yeah. Someone said, don't do politics. No, I don't really want to show Biden anyway, because what are they going to do? They're going to cut to him for a minute. The press is going to be yelling at him. It's the same thing. You could forecast what's going to happen. They don't care. Boom, boom, boom. A placebo. Last time he used a fake arm, it had dark hair all over it. Hilarious. No, it was his real arm. Come on, that's the lighting in their fake White House building. It's real. He's really getting some shot in his arm. Who cares? I don't care. I really don't care. If people want to go get vaccinated, go for it. It's fucking stupid. You're stupid. You know what I mean? Just who cares? It's like people that get the flu shot. I got the flu shot every year. until I caught the flu. And then I had the worst fucking flu I've ever had because I had the flu shot that year. And I said, no, I'm never getting a flu shot again. I thought I was going to die. My wife thought I was going to die over the freaking flu. All right. I was still on the fire department at that time. That's the whole reason I got the flu shot. But I remember getting off a 24, going to work at the nightclub that I work security at, being like, I feel like death by the end of it. The next day I was in bed all day, got dressed, went to the nightclub to do the work. I ate some food before guests even showed up, and they were like, you got to go home, because I was like purple. I was like sick. And then I went home and I was in bed for 3 days. Didn't eat anything, barely drank anything. And, I think I lost 22 or 26 pounds being sick for 3 days. Granted, I have a lot of water weight because I drink a gallon of water a day. But yeah, that was the last time I ever took that. I took the flu shot or anything like that, But it's funny. This whole thing, and the fact that everyone freaks out about very basic illnesses now. And granted, there is this new, like, extremely deadly, extremely resistant COVID variant that's in a lab, I guess, in Boston or Massachusetts or something, or it's already out in Massachusetts. I don't know. And they're anticipating that everyone is going to get sick again. I don't know. I don't know if I even care anymore. If you want to get vaccinated, go get vaccinated. If you want to wear a mask, wear a mask. If you want to dress up as a woman, do it in your own house. Like, you know what I mean? Very basic ways of thinking. I don't know. Someone said I only got the flu shot while I was pregnant because the other time I had it against my will as a child, I got sick. Yeah. Boston University created the ultra COVID strain. Gotcha. I knew it was something like that. 80% death. I don't know. Oh, that's with the COVID strain. Yeah. I know it was like resistant, right, to all the boosters and vaccinations. And the New York Supreme Court just a few hours ago reversed the decision ordering that all laid off employees, all fired employees who refuse to get vaccinated. I don't know if it goes to private businesses or it's just state employees, but they all had to be hired back with back pay. That's fucking huge. Anyone who is let go in the state of New York, I believe on the state level, so all the cops, every firefighters, all that stuff, that were all let go, that chose to be fired rather than get vaccinated, have all been told. Matter of fact, I'm just going to make you all stupid for a second. You're welcome. Because what I am going to do is I'm going to make you all watch Joe Biden get jabbed in the arm. Because why the fuck not, right? What else do we got going on?
Hello, folks.
What's your stupid comments?
You can roll your sleeves up. I'll come up if you want.
Shut up.
Good afternoon. I'm here today with my COVID team, as well as leaders from some of America's top pharmacies, Walgreens, CVS, Rite Aids, Albertsons. And we're here with a simple message. Get vaccinated.
Why?
Update your COVID vaccine. It's incredibly effective, but the truth is not enough people are getting it. We've got to change that so we can all have a safe and healthy holiday season. That's why I'm getting my shot updated today. And I think we were a little intimidated the nurse is going to give it when we told her it's on television. But at any rate, as we know, this virus is constantly changing. New variants have emerged here in the U.S. and around the world. We've seen cases of hospitalizations rise in Europe in recent weeks, and the weather is getting colder. People will spend more time indoors, and contagious viruses like COVID are going to spread considerably more easily. And as a country, we have a choice to make. Can we repeat what happened in the past winters? More infections, more hospitalizations, more loved ones getting sick, even dying from the virus? Or can we have a much better winter if we use all the tools we have available to us now? And let's start with COVID updates of vaccines. They're designed to fight a specific Omicron strain that's as dominant in our country right now. This is a serious giant step forward. Remember, Omicron did not even exist when the first vaccines against COVID were developed. Didn't even exist. We're especially fortunate here in the United States because my administration made sure that we're the first country in the world to have vaccines that target most common COVID strains. For Americans over 5 years of age who are fully vaccinated, our nation's health experts recommend that they get the updated COVID vaccine once a year. In other words, it's just like the flu shot. And if you're fully vaccinated, get one more COVID shot once a year. That's it. Now, some high-risk people, such as elderly and immunocompromised, may need more than one COVID shot. But for most Americans, one COVID shot each year will be all they need. And if you get it, you're protected. And if you don't, you're putting yourself and other people at unnecessary risk. The shot is free. It's widely available and conveniently located, just in time for the holiday season. Look, over 20 million of our fellow Americans have already gotten the shot. I'm calling on all Americans. Seems like having to make this case again. All Americans to get their shots.
No.
Just as soon as they can.
No.
Your old vaccine or your previous COVID infection will not give you maximum protection. Let me be as plain as I can. We still have hundreds of people dying each day from COVID in this country, hundreds. That number is likely to rise this winter. But this year is different from the past. This year, nearly every death is preventable. Let me say it again. Nearly every death is preventable. So get your updated COVID shot. Now's the time to do it. By Halloween, if you can, that's the best time. And that way you can be protected for the holidays. And please, while you're at it, get the flu shot. Have your kids get their flu shot. You can get them at the same time you get the flu shot and COVID at the same time. Either your doctor's office or one of the drugstores. We're already seeing a rise in flu and RSV and other respiratory illnesses, especially among young children. So take precautions, stay safe. You can spend Thanksgiving with family and friends with a peace of mind knowing that you've done your part for everyone's well-being. My administration is doing our part. We've made these updated vaccines easy to get and available for free at tens of thousands of convenient locations. These include local pharmacies, doctor's offices, community health centers, rural health clinics that serve the hard-to-reach areas in America. 95% of Americans can find a free update vaccine within 5 miles of where they live. You can go to vaccines.gov. Let me say that again. Go to vaccines.gov to find a location near you. Again, I'm going to say it one more time. Go to vaccines.gov to find a place where you can get the shot near you. We're working with doctors, community groups, faith leaders, and companies. Leaders of some of our nation's largest pharmaceutical chains, I said, are standing behind me. They're all stepping up to help more people get vaccinated. Some are offering coupons when people get their updated COVID shots. Get the shot. $5, $10, $20 off your drugstore grocery purchase next time at the same time you get the shot. Some are making it easy for you just to walk in and get your vaccine right away, including on nights and weekends. And others from the private sector are stepping up as well, including delivering COVID treatments right to people's homes for free. Now, what do you do if you think you have COVID? Well, please get tested so you can be treated. We mailed out hundreds of millions of free test kits earlier this year. We had to pause the program because, unfortunately, some of our friends in Congress failed to continue to fund the COVID response. But if you have already used up these free tests, that's okay. We've required health insurance companies to cover free at-home tests, 8 tests per person per month. Folks on Medicare and Medicaid can get free at-home tests as well. And we have made free testing widely available in communities. And then, if you test positive for COVID, get treated. We have amazing treatments available now. They can help stop COVID infections from turning into serious illness. We are the only large country in the world that made Paxlovid widely available for free. You can get it prescribed by your doctor or at thousands of test-to-treat sites or even from your local pharmacist. Pick it up for free at your pharmacy. It's a pill. It's a pill. It's easy. Paxlovid can save your life. It's worth it. And here's the bottom line. Virtually every COVID death in America is preventable. Virtually everyone. Almost everyone who will die from COVID this year will not be up to date on their shots, or they will not have taken Paxlovid when they got sick. We've made the vaccines free and available. We've made the tests free and available. We've made Paxlovid free and available. Please use them. Use them. And encourage your friends and loved ones and neighbors to use them as well. It can save a life. To employers, help your employees get vaccinated. Set up a vaccine clinic in your building. Give people time off to get it if necessary. Share good, clear information, just like you do for the flu shots. To school and college leaders, help your communities get vaccinated this fall. Host on-site clinics before Thanksgiving. And to our friends in Congress, it's time to step up with much-needed COVID funding. Help us stay ahead of the virus and keep our communities going strong with free vaccines, free tests, and widely available treatments, as we've done so far. Some of our friends in Congress say we don't need COVID funding, or they say there's really no reason that the government should be paying for it. I strongly disagree. Strongly disagree. This is a global health emergency. If we really want to put COVID behind us, we have to keep up the fight together. We can't leave people to face it alone. Some members of Congress say they don't want to move beyond COVID, but they don't want to spend the money to do it. We can't have it both ways. The funding we seek is critical to continue the work to develop and purchase the most effective treatments and vaccines against COVID. It's important. It's important. Now I want to speak directly to those with special conditions. New variants may make some existing protections ineffective for the immunocompromised. Sadly, this means you may be at a special risk this winter. So I urge you to consult your doctor on the right steps to protect yourself. Take extra precautions. I also want to say this. As we enter this new moment in the battle against COVID, let's use it to start fresh as a country, to put all the old battles over COVID behind us, to put all the partisan politics aside. We've already lost over 1 million Americans to COVID. Over 1 million Americans to COVID. You know, we can do so much now to reduce the number of people who die from this terrible disease. We have the tools. We have the vaccines. We have the treatments. None of this is about politics. It's about your health, the health of your loved ones. I'll close with this. Over the past 20 months, my administration has left no stone unturned to make life-saving tools widely available and easily accessible. Now, COVID cases are down by more than 80% from when I took office. COVID deaths are down nearly 90%. And now, we're in the longest stretch since the virus emerged, when our hospitals are not overrun with severely ill COVID patients. That didn't just happen. It took a combination of incredibly effective vaccines, tests, and treatments to get us there. One of the biggest public health efforts ever undertaken in this country. But together, we did it. Now let's keep doing it. Let's keep going. This fall, get your COVID shot and get your flu shot. It's simple. It's easy. For most Americans, it's one of the COVID shots per year. Once a year, it's going to be required. And it's the most important thing you can do. So thank you. And now I'll show you just how easy it is to get that shot.
Fucking lame. Oh my gosh.
You're not giving me the shot.
Oh, I'm not.
Here, Joe Biden, I'll give you the shot. Wait, actually,
Hey, Joe Biden, my name's Bubba. I'll give you that shot. Drop the soap.
Yeah, that just didn't sit right. All right, so who thinks his arm is going to be incredibly muscular? Oh, nope, never mind. Oh, they are going to zoom in. Look, they can't even get this shit.
Necessity to deal with making sure it doesn't become one.
So fucking stupid.
On oil, urging you guys not to use reserves.
And you watch, there's going to be like 20 people who zoom way in on this.
New York to withdraw its mandate for vaccines?
Say again?
Do you think it's a mistake for New York to withdraw its vaccine mandate for private employers?
No, I don't think. That's a local judgment.
It's a state judgment, you shithead.
What is your next move now that Brittany Griner lost her appeal, Mr. President?
We're in constant contact
Bullshit.
with the Russian authorities to get Brittany and others out. And so far, we've not been meeting with much positive response. But we're not stopping.
Would you
Dirty bomb allegations from Russia. Do you believe this is the beginning of a false flag operation? Mr. President, on the dirty bomb allegations from Russia. The dirty bomb allegations from Russia as it relates to Ukraine. Do you believe that this is the beginning of a false flag operation? Is Russia preparing to deploy a dirty bomb itself or a nuclear weapon?
I spent a lot of time today talking about that. Let me just say, Russia would be making an incredibly serious mistake if we're to use a tactical nuclear weapon. I'm not guaranteeing you that it's a false flag operation yet. Don't know. But it would be a serious, serious mistake.
Thank you very much. Mr. President, is a dirty bomb a nuclear strike?
Thank you very much. We appreciate it. Thank you.
All right, so what we know is nothing. Fuck the shit. Who's calling me? No. I'm not answering. Fuck off. Get a real job, telemarketers. Unbelievable. Unbelievable. How many of you guys watched my show last night? Did you? Did you watch it? Did you watch it? It was a good show. I think. You may not think it, but I think it. All right.
I know many of you guys don't like The Voice. Many do like The Voice, but many don't. You watched it this morning. I thought it was a good show, and it had a lot of views. That's what I'm talking about. It wasn't monetized, by the way. Neither was the little clip about the mass shooters that I put out this morning or last night, I think. That wasn't monetized either. They said, no, Steve, you're being too honest. We can't have honesty. To Google, honesty is not the best policy. What else is going on? So you got a stupid shot. Yay. What else? Sean Fauci has announced a nationwide tour next year, 2023 to 2024. Sean is going to host a worship event at every state capital in the United States. No shit. That is a big tour. Right? He's the Christian rocker worship, the live worship one. It's good, actually, if you've never been. It's pretty good. Brittany Griner's appeal denied by Moscow court. That's what they were talking about there. Fuck. It's going to make me pay for the news article. Nope. A Moscow regional court upheld the drug conviction of U.S. women's basketball star Brittany Griner, paving the way for the two-time Olympian to serve 9 years in a penal colony for the possession and smuggling of less than a gram of hashish oil. The court hearing Mrs. Griner's appeal on Tuesday had the option of leaving the verdict as it is, reducing the sentence, or overruling it and returning to the lower court where the case was first heard. The decision sets a stage for further diplomatic wrangling between the U.S. and Russia amid icy relations over the war in Ukraine, which is just stupid. If a white, I'm not even gonna say it. I'm not even gonna say it. I'm not gonna say it. Like I'm sure there are people in the chat that are like, Steve, nope, Steve, just stop, nope, don't do it, Steve. So I'm just gonna stop myself right there. Not even gonna do it. Not even. What else is going on today? I don't know. I haven't really been reading the news outside of this stuff anymore, which is nice. It like cleared my mind, to be honest. This trial has been mildly entertaining, though. Someone said Brittany Griner is a dude. No. She's a woman, a very tall basketball playing woman. So good for her for, smuggling drugs into a foreign country and then believing that you're being charged unfairly because you were caught with drugs in a foreign country. Yeah, it's crazy. Crazy. Oh, so today the UN Security Council, is that live right now? Today the UN Security Council is holding a meeting. Where did the article go? Discuss dirty bomb threat. I wonder if that's going to be live. I wonder if it is live. Or what time that is supposed to take place. And then the White House press secretary is scheduled for 9:40 or 2:45.
It has
let's watch Ned Price lie to the American public, huh?
Under the NPT and more broadly.
Ned Price.
The type of rhetoric that we have heard from Russia consistently over the course of this conflict, the nuclear saber rattling, and now references to the false allegation of a dirty bomb use as irresponsible. But third, it's concerning because Russia also has a track record. And whether you call it mirror imaging, whether you call it projection, we're concerned because Russia has demonstrated a pattern of accusing others of that which it ultimately itself is planning. Again, we are watching very closely. We've seen no need to change our own nuclear posture. We don't have any indication that Moscow is preparing to use nuclear weapons, but this type of rhetoric is concerning for many reasons.
Someone just asked a question, and Teal Ladybug, Glenda, let me put this up on the screen because this is kind of stupid. Someone said, question, Steve, do you think Michelle Obama is a woman? Yes, I do. She's just an ugly ass woman, but yes, and she's a woman. Are you trying to say she's a man? Because that's just stupid. That's you being critical of someone's appearance. Who does that? Look at this fucking dude's hair. He looks like he's out of the Godfellas. Godfather? He looks like he should be a Godfather. Oh, wait. You know what I can do? So Russia is very evil. Everything about Russia is very evil. And you have to just believe that what I'm saying is true, no matter whether it's just factually inaccurate. It doesn't matter. Okay, you? Oh, wait. Does anyone else have any questions? Okay, go ahead. Oh, so what you're saying is Joe Biden just got a shot in his arm. And why are we still doing this? COVID is everything that you have to think it was. I mean, I'm looking at this piece of paper trying to understand what I'm supposed to say here to you, and I frankly just don't fucking understand. Well, let me tell you, Baldy. Putin is bad. Ukraine is an ally, and we're going to send them more of your tax-paying dollars, and there's literally nothing you can do about it. And if you dare to question the power of the United States government, well, I'm going to look over here to my left and then look back at you, then look down again, because what you are trying to ask me is simply irrelevant. And I think you are as shitty as Tucker Carlson. And even though Tucker Carlson is, on Fox News and has the highest rated cable television company in the world, it doesn't really matter. Because, well, Joe Biden says one thing and we all have to blindly follow like sheep, That's kind of how it works. So I'm going to look down at this piece of paper, and every now and then I'm going to look up at you, and you're going to sit there and be intimidated by my little scrunchy voice and my little rat face nose, right? Every time he talks, he reminds me of a rat. Like, I wish I had some really good graphic design skills, because I'd put a rat over my face when I'm talking like this. And then, I lost focus because I started saying, well, he looks like a rat, and then I lost my focus on what I was trying to do. Okay, now I'm back into Jake Sullivan. Who is this? Ned Price? Jake Sullivan? Shithead? What's his fucking name? I don't even remember. This is Jake Sullivan. Oh, no, this is Ned Price. They're all fucking stupid. They all look like... Wait, what are you fucking talking about? You want us to sit here and believe that you are going to actually tell us You are not going to tell us the truth, okay? Let's just be honest. Biden is a shithead. I want to hear this now.
A negotiated two-state solution.
Do they have the right to resist the military occupation that is killing them daily, assaulting their villages, stealing their crops, destroying their cars, their homes, day after day? Do they have the right to resist that occupation? Or maybe the Palestinians are the children of a lesser God.
Saeed, the loss of every innocent life is a tragedy. It is something that we feel deeply. It is precisely why we have been so engaged.
Anyway, okay, here's what I really think. I don't care. Joe Biden is my Lord and Savior. I must pledge allegiance to everything he says, even when he pulls out his wrinkly, shriveled arm. You guys thought I was going to say something different, but I wasn't. And gets a fake COVID vaccine in his arm, and while encouraging everyone else to get a booster, which obviously we're live on social media, so we can't tell you what happens to people that are regularly getting a booster. That does nothing to stop transmission. But it does, science says, here's my disclaimer for YouTube, it does keep you out of the hospital sometimes. And, but here's Ned Price. Okay, back to you. Let me pucker my lips. All right, so what you're trying to tell me here is that we gotta do what you say we gotta do, even though fucking douche canoe over here says, and you douche canoe up there tell us what we gotta say. Like I'm gonna give the fucking scissor hand. What's his hand? That he did that to him. He's fucking pissed. He's like, fuck you, bro. Like the fucking... Here's Ned Price. So, again, like I said 17 times, Joe Biden is right. Everyone else is wrong. And if you want to debate Joe Biden and say that what Joe Biden is saying is not right, we have to be forthright and say, well, that's just probably because you are a MAGA supporter, and therefore you are a terrorist. And even though that doesn't make any sense, it doesn't matter because, well, Joe Biden's administration says it is. So it doesn't matter. Ah, shit.
Lapse of moral judgment.
He's still fucking yip-yapping, you.
Of any human life.
All right, let's... Human life.
We are also aware of that disciplinary action is being taken against 3 commanders of the unit involved in the incident.
Of what unit?
We're continuing to follow this very closely.
Afghanistan. And then on Israel, do you have any readout on the secretary's meeting with the Israeli president?
It has just concluded, or even soon will conclude.
We
Just
got a $5
as I
super
promised
chat from
yesterday with another
Dora
readout,
the
I promise you we'll have a readout
She's
of this
never heard
meeting,
that before.
and I suspect we will.
Super
I suspect
original.
we will have it today.
Well, there's an Israeli election coming up soon, and I realize it's not a presidential one, but but still.
Look at him! He's got the little goatee going now.
Understood. We will have a written readout for you.
Say yip yapping, yippity yap, yippity yippity.
I wouldn't speak to anything that
I wouldn't speak to anything that Joe Biden did tell me. Okay, you go ahead. All right.
Well, I'm very honored, Ned Price, to be sitting here asking you questions. What color underwear are you wearing?
Well, actually, sir, I'm not wearing any underwear. I don't believe in underwear. It's not as freeing. I believe in thongs because even though I sit here looking like a man, contrary to what society believes, I also identify as a woman. My name is Ned Price, and I am signing off for The Price is Right. Nope, that's not my job. Your turn. Uh-huh.
Hi, so I had a really bad hair day today, and smoked too much herb in the 1960s, and I have a hairstylist like an 80s rock lead singer. I'm wearing too much blush, too.
Well, that's an interesting conversation, man. But I have to be honest with you. I just read someone's comment. They're like, "Wow, she's dead." Sorry.
Anyway, this is Ned Price talking really fast because I gotta make up for the time that I was talking about nothing.
So when we go down the river, the boat in the sea is just preponderous, and we don't know why. Man, I should get a new job as a UK or like a UN translator, right? Because I'm doing such a spot-on job. So Ned Price is bobbing and weaving, trying to avoid Big Bubba behind him. What's up, Nettie? Hey, Nettie. How you doing, Netties? Netties is nose in Spanish. See, it's another Spanish word that I know. Isn't that amazing? Okay. Anywho, so there's this guy, and let me tell you a story about this guy. And so he was driving a car down in the desert, and he was bobbing around, and he had a favorite tagline, and he's like, "Are we there yet?" "Alrighty then!" That's what he used to say all the time, not "Are we there yet?" See, I fucked that one up. And he was riding around, and then he had to go into the jungle because he was trying to rescue this this bat that was very weird. And so he had to go into this cave with all this guano, and he was trying to save this special white bat. You may know. Oh, here's the fucking 80s rocker again. What's up, Aerosmith? Anyway, back to the story that I was talking about the guy riding through the desert or the jungle, right? And so then he was with his guides, and he's in the middle of the jungle, and he couldn't figure out what's going on, and he runs into this weird tribe of Indian people in the middle of the desert. Aerosmith! What's up? Oh, look at my hand motion. Look at the ring. It's so fucking huge. It's fake, though. Don't worry. Look at her fucking hair. It is like an Aerosmith hairstyle. She looks like she's done entirely too much LSD. I mean, I'll be honest. Let's go back to Ned Price so we can hear the rest of the story. Let's see if any of you guys know what movie I'm talking about. Do you know? Okay. Anyway, so he was in the jungle, right? And he was trying to get to this bat cave, and it had all this guano around, right? And but then he's having this soiree with all these Native Americans, and then he ends up betting. Okay, he ends up going into like a teepee or like their cave or whatever the fuck it was, and then he he ends up. Oh fuck! David got it. Ace Ventura. Yeah. Wasn't that good? How many of you guys actually knew it was Ace Ventura? Yeah, I was telling the story of Ace Ventura too. Yep, I'm fucking bored. That's what we do. Instead, man, I could just make a whole show doing this shit. Like where I take the White House like press conference and shit and just ad lib over each one of them because they're fucking stupid, and you'll probably learn more from watching me than you would have watching them. Like, here, really? Ready? Russia is evil. North Korea is evil. Iran is evil. Saudi Arabia is working against us. UK, who cares? Our allies in China, our adversaries in China, who gives a shit about Haiti? Like, that's literally our U.S. policy right now. So bad. Chris Pearl said, "What's going on with the trial?" Well, let me tell you, Chris. Are you ready? Is your seat belt fashioned? Darrell Brooks is guilty as fuck, and he's about to get sentenced to 6 life sentences plus 999 years for the 60 other charges that he's facing. Closing arguments will begin in approximately 18 minutes, with the state going first, followed by Darrell Brooks getting admonished several times during his closing arguments, followed by a rebuttal to the closing arguments by the defense by the state, at which time the jury is likely gonna look at this fucking dude. He looks like he should be writing a book in some Starbucks cafe somewhere. And watch the guy behind him. That dude's about to stick his finger in his mouth. It's gonna happen. Anyway, Is this the side effects of coffee? No, this is the side effects of not enough coffee. It's the side effects of me trying to make $1,000 goal so I could do a live show tonight, a call-in show, completely, entirely in this voice. Well, not completely, because we have a guest that may be coming on. The guy that I was harsh with in chat. I forgot what his name is already. Harem. He's going to come on the show because he's a licensed lawyer, both in West Virginia and on the federal system. And he's going to provide a little bit of context into what the fuck is going on in this trial that we don't actually know. Linda said, dude, you caused an earthquake over here. Yeah, there was an earthquake last night in Virginia, but it was too weak to be felt by anybody. Just like Biden's policies. Nope, actually, we all feel the effects of his policies. Yeah. Paige Paige said, is court over? No, it's not. It's on intermission. It's lunch break. So what we're doing is we're showing the Ned Price press conference, but because they're not saying of anything of significance whatsoever, I'm just ad-libbing over in this stupid voice talking about whatever the fuck I want to talk about because I'm gangster and I could do that. Gangster. Yeah. Ace Ventura, pet detective, motherfucker. Hairball, yeah. Sue Walsh said, how long before the trial is back? Why, are you kind of tired of listening to this incredible voice? This incredible ad-lib? Come on, bruh. This is sick. Yeah, Sarah said, your father was 101st during Vietnam and they mean business. Hell yeah, they do. Idnar said, did I hear Joe say we can get $20 off groceries if we get boosted? I have no idea. I hope no. I hope not. Because that means more people. Who pays that $20? Oh, that's right. The people that don't want to get vaccinated. It's just like student loans, right? The people that go out and pay all their student loans apparently have to pay for the student loans for everybody else that doesn't want to pay their student loans because that's the new America. That's how it works now. Right? Even though it's not really how it works, and President Biden lied to the American public the other day saying the application's open and people could do it because an appeals court put everything on hold, so it doesn't really fucking matter. But you know what? It doesn't matter. Joe Biden will continue to lie to the American public, and you guys are all just fucking sheep, and you're not going to pay attention. The only thing you're going to do is sit around and say, where's my money, Joe Biden? You promised me if we cast our imaginary votes for you that if we casted our 2 votes for you, that we would get all this free welfare, free shit, free medical, free college, free food, free gas, free everything. And now look, you pay more for your food, you pay more for your gas, you pay more for your college. Look at that. The guy's not sucking on his finger anymore. Now he's sucking on his top lip like a weirdo. What the fuck, bro? Here's Jake Sullivan again, coming live at you. So yeah, I stuck a finger in my bum the other day, and it was really weird. And I can't look at you in the eye, so I gotta keep looking down at this piece of paper, and it's gonna tell me exactly what I'm supposed to say, but it's not really saying anything at all. But I just keep running my mouth because I'm fucking stupid, and there's not a lot that I could say that are gonna make anything make it okay. The status of America right now is very frightening, and we're not gonna talk about the mass shootings that happen every day in America, but let me look at the camera for a second, then turn away quickly because I don't want you to take what I'm saying as serious, because of course it's not serious. It's only the American history and what we love and why we know. Why are statues being taken down across America? Why are they trying to change the names of streets and what? Okay, your question. Oh yeah, yep, I did. Yep. Uh-huh. I'm not doing it. I am not doing it. I'm not. Nope.
It has been said
nope.
that for a while that the new Special Envoy for Human Rights going to be appointed, but it's not.
That's so the exact accent that I would be doing, by the way.
So on your first question.
Okay, so on your first question, yes, it is true. I ate a salad for lunch today, and it was very good. It wasn't very green because I got it from Subway, where they use artificially inseminated lettuce. It's not real lettuce. I don't know what the fuck it is. It's kind of like a napkin painted green, shoveled up, and made a little bit damp. But you know what? That's what you get when you order from Subway. Eat fresh, they say. Fuck that. It's not fresh at all. Anyway, so yeah, every morning it takes me approximately 6.5 hours to do my hair every morning. I have a whole crew of tax-paid hairstylists that get together and put the fake gray in there and everything. Yep, my name is Ned Price, and I'm a shithead. Okay, yeah, I didn't even pick this tie. Joe Biden first told me how I had to get dressed when I was putting on his morning diaper. And, you know, I did raise my eyebrows a bit because it did stink, but it's something that you have to do when you are the press secretary for the whoever the fuck I work for, because I don't even know. Someone said, I think this is the opposite of the news. It absolutely is. There is no news here. No news. And you know what? I'm keeping all the viewers, so you guys must be mildly entertained by this, because otherwise you wouldn't be here. Ew! Someone said cabbage. Nobody likes cabbage. The only time a politician tells the truth is when they call they call another politician a liar. That is true. Yep, absolutely. He's the Pentagon's the State Department press secretary. That's correct. Ned Price shithead. Yep. Right now he's talking about tomato sauce and how he really likes tomato sauce when it has chunky tomatoes in it, but he doesn't know why a lot of people don't put chunky tomatoes in it, because they're gross. But he's going to talk about it, and he wishes last night he had garlic bread. He looks right at the camera yelling at his husband. Is he gay or does he have a wife? Who knows? Who cares? Anyway, and he's really pissed off that the tomato sauce and the husband or the wife, whatever, chose to make spaghetti instead of ziti, and he really likes ziti, and he really wanted ziti, and he didn't want spaghetti, but they gave him spaghetti anyway, and they couldn't deal with it. The mainframe fucking crashed. Linda said, we really did have an earthquake, a 5.0. Yes, that wasn't felt anywhere in Virginia. The only way you knew that there was an earthquake is because it said it in the news. I live in Virginia, too. Chunky sauce poll coming up. Yeah, I don't like chunky tomatoes in my sauce. However, I do like ground sausage in my sauce. Ground sausage and tomato sauce is very good. And we're not talking the same kind of sausage that Darrell Brooks is going to get every single day for the rest of his life in jail. And that's Bubba's sausage. We're not talking about that. We're talking about actual, like, food sausage. That's what we're talking about right now. A head of lettuce lasted longer than female British Prime Minister. Oh, Mr. Make That Make Sense made a not-so-funny joke. Because a head of lettuce doesn't actually last 47 days, and I believe that is the amount of time. But who's the new... Shook. Nope, not doing it. Not doing it. He was like, what about one? What about white rice or pork fried rice? Which one do you like better? I fucking tried to stop myself. I couldn't do it. Oh, my gosh. Oh, no. I just like the screen. God. How old is she? That's my only question. She's probably very smart.
I will.
She said I farted. I heard it. You guys all heard it too. She said I farted. That's exactly what she said. She said I farted. And he's like, yes, you did fart. It smelled really bad. It smelled like cow. Like not like cow shit, but actual cow. And I just realized I'm being kind of loud, so my neighbor's probably like, what the fuck is he talking about? Yeah, we're talking about cows and how they smell. Sky said, Steve, smell my finger. Fuck, what? That's weird. I don't like that. Walt called me a clueless buffoon. Love you too, bro. The guy at the toilet paper, the guy at the podium rips the toilet paper on purpose. Yes, he does. He's like, my name is Ned Price, and I don't use toilet paper. I'm too good for that. I use tax-paying dollars. Tax bills, your IRS tax bills is what I use to wipe my ass every single day. Because why? Fuck you, Americans. That's what he's saying. That's what he's saying. What else? God rides a Harley. He's trying to get me banned. Every single time I'm like, nope, not doing it. He's like, do it. He's like the evil fucking thing on your shoulder where he's just trying to get you to get in trouble. You know what I mean? Cindy said I should restart my stream. No, we've been live for 5.5 hours on Facebook. I could restart it. Should I just restart it right now? I don't really want to. I'm kind of on a roll. I'll restart it when the trial comes back. How about that? Because how many people are watching right now on Facebook? 2:52 p.m. Eastern. Can chipmunks eat salted cashews? Yes, they can. I don't know. I made that up. They would have some issues with water intake. Don't you dare, Darren Harlow. Don't you fucking dare put fake ass shit in my chat. All right? You gotta pay me if you want to put your stupid ads in my chat on Facebook. Get the fuck out of here. Get the fuck out of here. Get out of here. Trolls. I'm trolling my own feed right now. Isn't that amazing? Linda said, now you're causing aftershocks. Hell yeah, that's every time I take a shit. No, that's weird. Too much. Denise said, don't restart. Yeah, I'm going to have to restart. Otherwise, it's going to cut off at 5:30 because I've been live since 9:30. That's how it works. I've been live for 5.5 hours. Facebook lets you do an 8-hour live stream. So, then leave this video. Oh, are people getting really mad? Are people getting mad? Oh, don't get mad at me for having a sense of humor. Sense of humor. Oh shit, the trial's back. All right.
It is Wembley to Philly.
Fuck, I gotta mute the other feed.
I don't know how you get.
Shut up, you fucking worthless piece of tax-paying fucking garbage. I could say that because I'm gangster. All right, Tobias, who's talking shit in my chat? Huh? Who's talking? Turn this guy off like a cartoon character. Who the fuck is? Oh, who's this shithead? Patricia Monroe. Turn this guy off like a cartoon character. Who the fuck is he? He's very annoying. Said Patricia Matudo. She goes by the pronouns shithead. I just cracked myself up there. What are your pronouns, Patricia? Shit and head? Forgot to shower today? Are those your pronouns? Are those your pronouns, Patricia? Dirty asshole? My pronouns are dirty and asshole. My name is Patricia. Fucking shithead. Yeah, this isn't the day, Patricia. You don't want to fuck with me. All right? Right now, we're doing a 5 for 5. Every $5 you contribute via Cash App, Venmo, or PayPal makes Patricia cry herself to sleep. It's scientifically proven not to be true, but it does work. Patricia, if you send $20, maybe you could buy a sense of humor. Shithead. There's no sound yet on this feed. I can't believe he's in the courtroom. He's gonna fucking say something stupid, right? He's gonna wait right into the middle, and then he's gonna flip over the table, and they're gonna shock him, and then he's gonna piss himself, and he's gonna shit himself, and it's gonna be glorious. And then Bubble's gonna be like,
No, Darrell, don't get all stinky. I like it clean. Pick up that soap, Darrell.
And he's gonna be like, I'm not gonna do it. He's like, no, Bubba, no.
Darrell's like, yeah.
No.
Yeah.
And no.
Yeah.
And no.
Yeah.
And no. Oh, yeah. How do you like that, Patricia? Is that professional enough for you? Fucking A. My views went up, Patricia, so let me tell you that. You may not like it, but 1,184 of you fucking crazy asses do. Someone said sing a song. All right, I'll sing Patricia's song, right? Fuck Patricia. Yeah. No, actually don't. She doesn't shower. Allegedly. Patricia is a troll in my chat.
She is talking so much shit.
And Darrell Brooks is looking down.
As he's gonna do forever.
The old lady behind him. She wants to kick his ass. Everybody knows he's
guilty as shit.
Yeah. You like that? Was that a good song? Salty Ma'am 20 said, oh my God, what did I walk into? You walked into pure excellence. That's what this is. Pure excellence. Nobody wanted Patricia tears. You're lucky, Patricia. Normally when I do that, people are like, fuck yeah, Patricia tears. Boop, 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 boop. Nobody's doing it today. They're all like, fuck you, Steve. We like your voice, but fuck that. Kristen said my dog is freaked out. Oh yeah? You want to see your dog really freak out? Did your dog freak out? Because I do that to my dogs, and it's funny. And they do freak out when I do it. Someone said we need sound. There's no fucking sound. The court is not in session. There's no judge there. There's no sound. The sound is all the way up. You will hear it when they turn it on. God damn. Because no other channel is showing him live right now? Yeah, it's because the trial's not back. Serenity said, Steve, no more, please. Why, did you piss yourself? No. My job isn't complete until you all urinate on your clothing. You know, because you laugh so hard you peed yourself. Yeah, that's how. Yeah, it's funny. Steve, I'm out of Tylenol. My goodness. Oh. Jenna said, I really needed this today. So nervous about my upcoming surgery. Takes my mind off for a while. Well, I'm glad I could do that for you. Corey said, okay, awesome. Glad I'm here. Oh, yeah. Well, we're happy you're here too, Corey. We're so happy you're here, Corey. Guess what I'm going to do? I'm going to end all my Facebook feeds. Fuck off, Corey. No, seriously. I'm just going to restart them. Click on my name. If you're watching on Facebook right now, click on my name and just refresh that page in like 20 seconds. Okay, bye. Just for Facebook. Everyone else, you're good. And Martha said, you already made Chloe spit her water all over you. Why isn't Chloe in school? Chloe, get your ass in school! Right now. Watch, I'm going to be your liberal principal. Chloe, you're not allowed to wear that shirt to school. Do I sound just like your principal? Fuck yeah. Hell yeah, I'm good at this shit. This shit's copyright. Who the fuck walked in front of the camera? Don't you fucking walk in front of my camera again. Darrell Brooks is staring at the sky. He is wondering when I'll die. But he is not gonna die soon because the state of Wisconsin doesn't have the death penalty. Alright, DB stands for douchebag, also known as Darrell Brooks, also known as Jen Pop That Butthole. It still makes me laugh. He doesn't want to go to Gen Pop because they're going to pop his butthole. Oh, see, he doesn't rise for the jury. What a bitch. Oh, that was for the judge. Okay, bye. I'm going to eat some chips, and I'm going to do it on the microphone. You know why? Because fuck Patricia.
That's from yesterday, too. You got to scan that in, too. Okay. And do you have the sheets for me? From the yellows. Mm-hmm. The yellow. His yellow sheets. Yes. Isn't there a fourth one? There's more. There's one on your, I bet on your. Yeah. Thank you. Mm-hmm. All right, it's 2:00. I'll call the case. State of Wisconsin versus Darrell Brooks. Case number 21 CF 1848. May I have the appearances, please.
Good afternoon, Judge Slaughter, Leslie Daisy, and Zach Wichow appearing for the state.
I'm here without prejudice by special appearance. Beneficiary, I'm here under fraud, menace, duress, and extortion. Judiciary, Jennifer R. Darrell. This is a social security SESTQ trust action which you are a real party and interest to as sui juris and propria persona. This is a military admiralty tribunal and maritime law under Title 4 of the United States Code Section 1, which you can see, which states placing of fringe on a national flag is within discretion of president acting as commander-in-chief of the Army and Navy. Is this a common law court or an admiralty court?
The records reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is wearing a dress shirt. I know he has a suit coat, but it's not on. He's also wearing a mask. The court is not going to address any of the issues that he is raising as they are meritless. I would also say the same as to the notes that he passed while he was in the other courtroom. For the record, I did provide a copy of all of those to the state as well. They are also uploaded into the file and are made part of the record. To the extent that he raises objections or lack of consent, it is noted for the record.
I was about to do that and say that I don't consent to being called that name or identity. That is the trust name, and it is not me, myself. I don't recognize that name, nor do I consent to being called by that name. With all respect, Your Honor. And we still have yet to address subject matter jurisdiction, which has yet to be proven on the record. received those original copies time-stamped.
All right, I need to make a record of one part of a jury instruction that I do need to advise the jury. It will also be corrected in the packet. I believe within the last year, the jury instruction on credibility of witnesses was modified by the jury instruction committee, and it was just an oversight on the court's part to not include, it's really just one paragraph. It was read to the jury at the beginning of the case with the preliminary instructions, but it is a paragraph regarding implicit bias, and so I do think it's important to advise the jury of that. I intend to do that when they come out, and then again, the full instruction will be amended so that it's in the packet that goes to the jury. And Madam Clerk, if you haven't already, if you could print off page 72. It's the, it adds a paragraph before the last paragraph that starts with, "There is no magic way for you to evaluate the testimony." And again, I wanted to be consistent with the most recent version of the jury instructions and consistent with what was instructed or provided to the jurors at the beginning of the case. And so I will make sure that they have that and so advise them when they come out. Also, I will read instruction 160, closing arguments. Madam Clerk, if you could just make the change so that it's of parties. We've missed that correction as well. So it's the closing arguments of the parties, not the attorneys. And so I will just make that correction and make sure it's...
I accept for value and return for value this document. And Your Honor, I requested that I have copies of my filings from earlier, time-stamped.
Mr. Brooks, I'll provide you with the copies later on. I need to continue with the instructing of the jury and have the parties make their closing arguments.
Your Honor, with all respect, the state received copies. How come I can't receive the copies of my filings?
You know what? I can give you the print-offs, but I can't give you the originals right now. That's what I'm referring to, and you will absolutely get those back. I guess I was mistaken that you wrote copy on it. I thought you retained a copy for your records. So with that, Madam Clerk will print off from the record. It won't be the yellow copies just yet. I'll take that up later outside the presence of the jury after the case has been given to them. Now, in terms of the closing arguments, I did set a time limit for the parties yesterday. Each side will have a total of 1 hour. Mr. Brooks, so that you are fully aware, the party with the burden of proof, which is the state of Wisconsin, goes first. Then you, as the opposing party, will have an opportunity to respond and argue. And then, time limit willing, the state also has the opportunity to present rebuttal because they have the burden of proof. And that is provided with the excerpt from the bench book that was provided to you yesterday. It has the purpose of the closing arguments is to summarize the facts, marshal arguments, focus the issues for the jury. I just talked about the order of the arguments. The scope of the arguments, are the content, duration, and form of argument are within the court's discretion. That's why I set a time limit of 1 hour for the parties. And Mr. Brooks, I will advise you that I certainly will wait and see how you present your argument today. I will certainly wait to see if there are any objections raised, but I also want you to be aware that if I feel the arguments are improper, I may simply, without an objection, say, please move on, as a clear indication from this court that what you are stating is not proper under the various rules and case law that govern closing arguments.
Again, Your Honor, without prejudice, I'm here by special appearance. I don't consent to being called that name for the record.
It's noted, sir. All right. Then with that, I will have the jury. Oh, go ahead. Looks like Attorney Upper has some issues she wants to raise.
Yes, I just have one question, Your Honor. Would I have permission to put the easel up and display some of the poster boards I did confer with Captain Dussault as far as security is concerned, and he agreed to it if the court would give me that authority.
Where would it be displayed?
He's going to put it like right here, and then you want me standing at this table during.
I do.
Yes, so I would just position it like right here. And I don't have to leave it up through the whole thing. I realize it blocks the view of people in the courtroom. Detective Casey would be willing to assist me in removing them when I'm done with them, if that's okay with you.
I trust it won't block Mr. Brooks' view of the jury, and
That's
as long as
yeah, I was going to put it like right about here so that he could still see me and the jury.
with that caveat, yes, I will allow that.
All right.
Objection, what is that? What is supposed to be put up?
They were previously admitted, Your Honor. It's Exhibit 15 and 130, I believe.
So are they exhibits? I'm confused to what they are.
Mr. Brooks, I've made a ruling. The state has made a request. I've granted it.
Yeah, but
In
I'm
terms
saying
of-
I don't understand what's being shown. Should not have the right to ask to object and ask what it is that's actually going to be shown.
The state's put on the record what it is. They are exhibits that have previously been received by the court during the course of this trial. That is proper for a party to do that during its closing arguments.
So can I put up exhibits?
Mr. Brooks, I don't know what you have planned for your closing argument.
I'm making a request, the same request. May I be able to put up
Well, I
exhibits?
guess it depends on what it is, sir. So I'm not going to take up any more time because what I intend to do is once the state goes through its closing, I may take just a short comfort break depending on how long it is. And if there's something in particular, what are you will need to tell me what it is. As long as it's an exhibit from this case, then I wouldn't have an issue with it.
They would be from this case, obviously. It's just not nothing that the state has.
I'm not aware of exhibits that the state wouldn't have, that you would have. Everything that's been received, we have a list. So if it's not something that was received during this trial as an exhibit by the court, unless you tell me what it is so that I can make a ruling, I can't see how it would be relevant or appropriate for your closing argument.
They're part of my filings that you filed.
The filings have no relevance to the issues that are before the jury. The closing arguments are to direct the jury so that they have your arguments so that when they go back to determine the issues in this case, which are related to whether you're guilty or not guilty of the 76 charges, things like subject matter jurisdiction or like that would not be something that would be proper before this jury. Those are legal issues that the court would decide. The jury is the judge of the facts. The court is the judge of the law. That's why I have all of these jury instructions to give to the jury.
I'm not referring to subject matter jurisdiction.
What are you referring to then? Be very specific so I can make a finding and ruling.
I was specific, my other filings that
That's
was filed.
not specific enough, sir. What are you
My
referring
court
to?
docket
Which
sheet,
filing?
let me know when you're done, Your Honor.
Which filing, sir? Not generally, but specifically.
Are you done? Are you done?
Sir, that's very rude and
No,
disrespectful.
I didn't know if you was finna say something.
I
That's why I'm
paused.
asking, are you done?
What filing
Your Honor,
are
how
you
come
referring
every
to?
time I try, even when I try to err on the side of caution, you find some way to
Yeah,
make
he's
it
trying to get kicked
to
out
be
again.
something that it's not. I didn't know if you was going to say
Dang.
something else.
I've asked a question, sir, so when I do that, I would hope it would convey to you I'm looking for an answer. So which filing are you referring to?
Which
All my filings,
filing?
all my filings,
All of them.
my notice of appearance, my statement of particulars, my bond, the court docket sheet, all of those filings.
The request to display those to the jury is denied. It's not relevant.
How's it not relevant? Not even your
That's my
oath of office?
determination, sir. So I'll take I am going to start this.
Not even your oath of office can be shown?
No, that is not relevant to these proceedings, sir.
It is.
It's not relevant in front of the jury.
Why is it not relevant? Can you
Mr. Brooks,
explain why that's not relevant?
you are not going to be able to raise those types of issues and present a closing argument based upon my oath of office, whether I'm licensed to practice law in the state of Wisconsin.
I said your oath
whether
of
there's
office.
subject
I didn't say
matter jurisdiction,
anything.
whether you consent to this appearance or not. None of those things help the jury determine the issues in this case, which are related to whether you are guilty or not guilty of the 76 charges that have been
The jury
filed
should
in
know
this
that
case.
they should know the truth in their duties, in their rights. They should know that at least.
Mr. Brooks, I'm putting you on notice that if you continue with this insistence upon presenting information that's not properly before the jury as evidence in this case, that I will instruct you during your closing argument to move on and potentially ask the jury, have the jury leave so that I can admonish you. And if you keep insisting on that, sir, that will be in direct violation of the court's direction
So
to
they
you.
can't even know that I got a shock device on my ankles?
They absolutely do not need to know that.
Why
so it's
not?
not relevant to the determinations of guilt or innocence in this
It's
case.
the truth.
Mr. Brooks, your custodial status is not on trial here.
I will argue that it is.
Your conduct from November 21st of 2021 is
That hasn't been proven.
You may not bring up the way that you've been shackled. It's not relevant, sir.
It's
and if
the
you
truth.
do so, you do it at your peril. But here's the
There
thing:
is
the
no
jury
peril.
is specifically.
It's my right,
no,
though.
Let me go. Okay.
It's my constitutional
is-
right. Just
There
like
are
under the
certain
First
things
Amendment,
that
which I
you're-
preserved my First Amendment right when I came in this morning, I also preserved my
All right,
Sixth
Mr. Brooks,
Amendment right.
Please stop. You do not have an unfettered First Amendment right. That is very clear based upon
What do you
all
mean
the
by
case law.
unfettered? What do you mean by unfettered?
It
I
means
don't.
it is not absolute. It can be restricted.
So the Constitution of the United States can be constricted.
All right, Mr. Brooks, I'm putting you on notice that if you continue with your insistence on raising issues that are
I'm going to
merely a
raise issues that the
distraction,
jury needs
that
to
are-
know,
They're not
regardless,
issues.
because they're under the rights of the United States Constitution, which
Mr.
is the
Brooks,
law
I
of the
direct your
land.
attention to closing instruction 460,
I'm
which will be
going
read
to
the jury
let the
at some
jury
point.
know the truth, their duty and their rights. Under the First Amendment and under the Sixth Amendment, I have the right to inform them of their rights, of the truth, and of their duties. Under the First Amendment and under the Sixth Amendment of the Constitution of these United States. You can't, no state law can override that.
Mr.
Any
Brooks,
law,
do you intend
any
to
law
keep this up when the
repugnant.
jury comes out?
Your Honor.
Because I need to
No, I
have
do
the
not. That's
state-
why I'm addressing this before
I'm not-
before they come out. That's why I'm trying to address this before they come out, so it doesn't become an issue once they're in here. But under the First Amendment and under the Sixth Amendment of the Constitution, which are rights that I preserved the moment we stepped in here this morning when this proceedings started, I preserved those rights for the record. And now you're telling me that those rights are not, would you say unfettered or I don't know what you say. I don't even know what that means. I don't even understand that. But any law repugnant of the United States Constitution is null and void.
Mr. Brooks, I'm putting you on notice that you can also forfeit by your conduct the right to present a closing argument. In appropriate circumstances, the right to present a closing argument, no different than the right to testify, may be subject to forfeiture where your conduct is incompatible with the assertion of the right at issue. The goals that this court has attempted to follow throughout this proceeding are multifaceted and multifold. Number one, I do have an obligation and I have done my best to ensure that this is a fair trial. However, a fair trial does not mean a defendant has unfettered rights to state whatever he wants when he wants. This court, not only through the course of the trial, is deemed with the responsibility to control the presentation of evidence as to ensure fairness and reliability of the criminal trial process. It also includes ensuring that the closing arguments are relevant, are appropriate. This court must also be concerned with efficiency and effectiveness, and of course, last but not least, courtesy and decorum in this courtroom, what I would generally refer to as civility in the courtroom. You do not have unfettered First Amendment rights or an unfettered Sixth Amendment right, sir. You must conform your conduct to the rules of decorum, the rules of evidence, and the rules of procedure. While you have a right to present relevant and probative arguments to this jury, you may not present arguments related to such things as jury nullification, subject matter jurisdiction, the court's oath or lack thereof, if that's what you believe, whether this court is a court of common law, admiralty, all of those things relate to your claim as being a sovereign, which are frankly baseless, they're meritless, they've been debunked by many courts, including the court in the Beneby decision that's been referenced by this court previously. I will give you a fair opportunity to present a closing argument, but again, it is not unfettered. The simple fact is, sir, this court can restrict your right to present a closing argument. This court has the authority under 906.11, under the various cases, including Illinois versus Allen, including Rock versus Arkansas, although Rock versus Arkansas and Chambers versus Mississippi dealt with the right to testify. There is a decision, I looked it up earlier, and I'll just pull it up and tell you the case site so that you have it. I would direct your attention to Herring versus New York, found at 422 U.S. 853, a 1975 case, although in a footnote, it does stand for the proposition that a defendant who has exercised the right to conduct his own defense has, of course, the same right to make a closing argument. That's quoting State Ferretta versus California, or following the same logic from Rock and Anthony and Chambers, a right, even a constitutional right that a defendant has may be forfeited by conduct. This court, just like it attempted to do with regard to your right to testify and set up reasonable restrictions so as to meet all of the goals that the court needs to meet, will be as follows, and that is, again, sir, you may not bring up matters that are not relevant to the determination of guilt or innocence. That means evidence that was not presented and not received in this courtroom is not relevant to your closing arguments. It's not, the arguments must be based on the law, not as you interpret the law, but as the law is. You must base your closing arguments on the facts that have been established during this case, meaning the evidence, the testimony. As I indicated earlier, the purpose of a closing argument is to summarize the facts, marshal arguments, and focus the issues for the jury. It is fair that you comment on evidence, including arguing evidence to the conclusion or inference. It is your ability or your opportunity to convince the jury that you are not guilty of these offenses. You may not convey any idea that you have undisclosed information. Neither party may vouch for a witness or otherwise express personal belief or opinion regarding truth or falsity of any testimony or evidence. It would be improper to ask a jury to draw inferences that the parties know are not true. And your comments on evidence is limited to evidence in the case. You may not comment on facts outside the record or peculiarly within your own knowledge. And that is just some of the guidelines for determining the propriety of arguments that I am guided by from my judicial bench book and all of the cases that are referenced therein. So you are put on notice, sir, that even without an objection, this court may, in an effort to preserve the dignity, the decorum, and to keep the issues properly before the jury, may advise you during your closing argument to move on. If you do not honor the court's rulings, then you will run the risk of forfeiting your right to be present and potentially forfeiting your right to further present your closing argument. With that, I am bringing this jury out to complete the instructions that I need to complete, to add to the credibility instruction the paragraph on implicit bias, and to let them know the full instructions that they receive will have it, to read 160 closing arguments of the parties, and then to have the state go first as they bear the burden of proof.
Now, Your Honor, I'll just let you make your record. I didn't overtalk you. I didn't interrupt you. Is that fair to say? I'll let you make the record.
Shut up. You didn't let her
With
do
all
shit.
due respect, when will I be able to make the record?
Never.
As I've tried to do numerous times by saying I wanted to present an offer of proof for my appeal. That's
You can make
the
it to
chance for me
Bubba.
to be able to make the record.
The Bubba.
I'm denying your request to make an offer of proof regarding your appeal.
Good.
It's
So,
not, I am
I'm
not
not allowed to
required
make
to
the
give you
record
that
at all, Your Honor?
opportunity, sir.
I'm not allowed
Sir,
to make the record at all. As I just let you did, because some of the
Sir,
issues
I
has
have-
been some
you
of the
have
issues
told me
has
what
been
you want to do. I've
Your
told
Honor.
you you can't. I've addressed
Your
the
Honor,
request.
some of the issues have been me over talking you and interrupting you. I did not do that. Even though everything that you said, you have not proven for the record, and it's unlawful law. You haven't shown one time that is lawful for you to do what you've been doing as
Mr.
far
Brooks,
as your rulings.
once again, I'm not going to debate with you the prior rulings of this court. There's absolutely no need at this point for you to
Your
make
Honor.
an offer of proof regarding my prior rulings or decisions that you disagree with.
Your Honor,
you will have an opportunity, if
I'm going
convicted,
to
to
inform the
raise
jury.
every issue you want on appeal.
I'm going to inform the jury of the truth, their duties, and their rights, as I have the right to do under the
He's
First
trying to get
Amendment
kicked
and
out
under
of
the
the
Sixth
courtroom
Amendment.
again. That's all he's trying
You
to
can't
do.
just disregard the United States Constitution. You can't do that. Again, any law repugnant of the United States Constitution is null and void. There's no state law that you can cite. There's no federal law that you can cite that overrides the United States Constitution. You
Mr.
know
Brooks, I
this.
direct your attention to State versus Anthony. Although that case dealt with the right to testify.
Okay, so
its
we're not
reasoning
talking about
is
the right to
equally
testify.
applicable.
We're talking about the closing arguments, correct? We're not talking about testifying, which you
Mr.
already
Brooks,
made a
I'm
ruling
not going
on.
to delay
You
any
already
further
made a
the
ruling
closing
on.
arguments
But
of
Your
the
Honor,
parties.
with all due
I will
respect,
address your further request
with all due
once the
respect,
state.
you already made a ruling about testifying. Did you or did you not?
Mr. Brooks.
So we're talking about now. We're talking about closing arguments that I said it's my right to be able to inform the jury of the truth, their duties, and their rights. That is my constitutional right.
Mr. Brooks,
You
we are
can't
at the stage
tell
of
me
the
I can't.
proceedings where it is the state's burden of proof where they get to make their closing argument.
We're talking
first.
about me though.
I understand that, sir, but
I'm going to inform
your
them of the
conduct
truth.
right now is delaying
I'm not intended
the court's
to delay
intention
anything.
of moving
I let
forward
you,
with
Your
the
Honor.
closing argument.
I just sat there and let you make the record. I didn't overtalk you or interrupt you. I let you say what you wanted to say. I let you make the record. I didn't interrupt you not one time.
No, but sir, you're attempting to disrupt the proceedings by
I'm
going
not
off on a
attempting to
tangent
disrupt
into
anything.
all of these other issues.
How-
From my
how am I-
perspective, that is in an
How am I
attempt
being
to
dishonored?
simply
How am I being
delay
in
what we're
dishonor?
doing.
How am
So
I being
you are
in
put on
dishonor?
notice. I am done dealing with
How am I
these
being in dishonor,
issues.
Your Honor? How am I being in dishonor of the court?
Mr. Brooks, I've made my determination.
And have
I'm
I not
going
preserved
to
my
address
rights?
this further.
Have I not preserved my rights?
If you insist on interrupting the court and disrupting the flow of these proceedings by a blatant disregard for the parameters that I've set up, you will forfeit your right to be present in this courtroom and potentially forfeit your right to present a closing argument.
Under what lawful law can you do that?
Sir, I've
You
made
can
my
hold me in
determination.
contempt by Illinois versus Allen. You can do that. You stated that numerous times.
Mr. Brooks, I want you here for the closing arguments,
Apparently
but you
you
do
don't.
not want
Apparently
to
you
follow
don't,
the
Your Honor,
rules.
because all I said was It is my right under the First Amendment and the Sixth Amendment to inform the jury of the truth, their rights, and their duties. I never once said anything about, oh, I'm going to bring up subject matter, or I'm going to bring
You're
up
right,
this,
sir. And
or I'm going to bring up
and
that.
see what you have to say, but I thought it prudent, given your conduct to date and your insistence on bringing up issues that have no bearing in this case.
This is a new day, though, Your Honor. This is a whole new day.
That it was prudent on my part to give you some guidance before you potentially do that in front of the jury.
Okay,
but you're right. I will wait and see.
Your Honor, it's still.
But I need to get going.
It's still
and
unconstitutional for you to
So
tell me that I
you
don't
need to
have
be
the First
quiet.
Amendment right that I preserved, or the Sixth
Mr.
Amendment
Brooks,
right
I'm
that I
going to have
preserved.
the jury brought out. I expect that you will be respectful, courteous, and quiet.
Or I'll be held in contempt.
Opens,
or I'll be held in
if
contempt.
you insist on making remarks, then I will excuse everyone from this courtroom and you will be removed because you will forfeit your right to be present for being disruptive.
Under what lawful law?
That
Because
is
I
my
haven't been
ruling.
dishonorable to the court.
Madam Clerk, please have the jury brought out.
Well, take me to the next courtroom then. Take me to the next courtroom, because you're not going to override my constitutional rights just because you feel like you can, and you don't have no lawful law to do that. We all have constitutional rights, and you cannot trample
Mr.
on
Brooks,
those.
what you are raising are essentially issues that you can raise on appeal.
No, I'm raising them now because they need to be on the record now. Because you won't allow me to make the record as I've let you do. You've even went so far as to mute
Mr.
me.
Brooks, the
Which you
jury
can't
is
even,
coming
there's no
out.
lawful law to say that you
I'm
can even
advising
mute me.
you to be quiet. They're coming
Your Honor,
out.
does Illinois versus Allen say
I expect you to be quiet. You will forfeit
and I
your
expect
right
for
to be
you
present.
I expect for you to answer questions as a public servant, Your Honor. You're a public servant.
jury's coming
You're
in.
supposed to serve the people.
All right.
Take me to the next courtroom. Please, take me to the next courtroom. Hold me in contempt. Hold me in contempt. Hold me in contempt. Hold me in contempt. I have constitutional rights that are being trampled on, and you're coming up with ways to make a lawful law where it doesn't say in Illinois versus Allen anywhere about utilizing the
Records
mute button.
reflect that the jury bailiff is in here. However, the jury is still in the hallway. I'm going to give Mr. Brooks one more opportunity to be respectful of the court's rulings, whether
Your Honor,
he
I
agrees
haven't-
with them
I
or
haven't
not.
dishonored the court. I'm merely exercising my rights under the Constitution, under the First Amendment, and under the Sixth Amendment.
Mr. Brooks, your rights do not include you disrupting these proceedings
I'm not
the way that you
disrupting
have through the course
proceedings.
of
You just
3
told
weeks.
me you don't have to honor my constitutional rights in so many words. You're using a mute button
Mr.
that's
Brooks,
not even
the
in your
jury is
decision.
outside this door. They're not brought in
I'm
yet.
informed that the jury. I'm
asking
informed
you
that the jury
to
is
be
outside the
respectful
door.
of their time.
They're not in the courtroom.
I'm
They're not
asking you
present.
to be respectful of the court's ruling,
They're
whether
not
you
present.
agree with
These
it
are
or
issues
not.
that need to be resolved before they're present.
Mr. Brooks, they will not be resolved to your satisfaction.
It's not about my
The
satisfaction.
record
It's
has
about the
been
Constitution. It's about what's right.
Are you going to
Are you going
follow
to
the
answer
court's
questions as a public
requirements?
servant on why you're making up laws that are not in the Illinois versus Allen? It never utilized
the
the
jury
mute button.
can
It
go
never
back
said
to the
anything
jury.
about a
Thank
mute
you.
button.
It is clear
Why
that
am I
Mr.
being
Brooks has
muted?
absolutely no intention of following the simple rules of decorum and courtesy. He has repeatedly talked over me. He's repeatedly interrupted. Even though I've made rulings, he's not respectful of the fact that I made a ruling, even though he disagrees with it.
How can you
I
make
attempted
it?
to bring the jury out,
How can you
and
utilize a
he
mute button?
continued to talk.
That's
So, Mr. Brooks, you
Your
have
Honor,
forfeited your right to
is
be
that-
present for the state's
is that
closing
not?
argument.
Your Honor,
You will
can
be
you answer
taken
this
to
question?
the courtroom next
As a
door, and I
public
will
servant-
invite you back over when it's time for your
You can't
closing
invite me
arguments.
back over. I can reclaim my right. So how can you invite me
All
to
right,
do
the
anything?
courtroom is to be cleared so that Mr. Brooks can be removed to the next courtroom, and I'll make appropriate findings when he's in the other
Yeah,
courtroom when I can
and
do
you'll
so
mute me,
without
which you can't lawfully do.
Interruption.
You can't lawfully mute me. So now you're trampling over my First Amendment.
Man, they got quick on doing the mute button, didn't they?
They got quick on doing the mute buttons today. Yesterday, we had a couple of times where they brought him to the other courtroom, but they didn't mute him. So we got to hear him bitching about just how his life isn't fair. I want to express for some people that are watching for the first time, because we have high numbers right now. You have to understand what you just saw is what we've been watching for 3 weeks. Nonstop. Every single time he gets a moment, he starts running his mouth. Today are the closing arguments. This is extremely important. And the judge is being way like I imagine that would be like a kindergarten teacher where they're sitting, talking to the children, trying to get them to settle down. And then you got Crazy Johnny in the back that's like high on sugar running around. And they're like, Crazy Johnny, Mr. Johnny, you have to sit down now. It's time to sit down, time to be quiet, read your book. Like, you know what I mean? That's what this judge must feel like, which is insane. And it's a constant. It keeps happening every single day. So now what's going to happen for everyone that's just tuning in? He is now being removed from the courtroom. They're going to place him in another courtroom that's right next door. It's got full audio video hookups. And I said this, guys, before the break. I said it was going to be 3:30 Eastern time. And he was going to argue with the judge for a half an hour. She was going to kick him out of the courtroom. He's going to go in there. She's going to go through her putting it on the record, right? Like she has every other time. He's going to hand a note to the juror or to the bailiff saying that he's going to act in accordance with decorum and all that crap. He's going to be brought back in. He's going to start in just because they have to make a record of it. He's going to start back in just like he did. She's going to kick him out. And it's just going to be this long game. This trial should have been over 2 weeks ago. He's done this virtually every day, arguing about this, a sovereign citizen this, sovereign citizen that. It's really interesting, to be honest, how much she has put up with. Someone said it's 2:30, not on the East Coast. They're genius. It's 3:30 on the East Coast. And I wasn't saying genius to be rude. I was saying genius to be a smartass because that's what I am. Anyway, guys, just in case you didn't know, I own a coffee company called Gratis Cafe. Well, it's actually Cafe Gratis because you got to say it separate because it's Latin. So it means free coffee. So we have a series of coffee shops that we're opening beginning on the 1st of the year that are going to be completely free coffee shops. One of the ways that we are able to afford it is by selling our extremely awesome coffee that you can roast at home. If you go to gratiscafe.com, Gratis cafe.com, and order a bag of coffee, we may not have that much in stock now because we don't sell any in advance now. We're just doing what we have in stock, and then I buy more, blah, blah, blah. But you can order that now. In addition, I'm going to choose one person at the end of this video today, whenever it's done, probably around 5:30, whenever they rest for the day. And I'm going to give away a 32-inch flat screen Roku television. We're going to do it live on the air. I'm just going to randomly select one person that placed an order and get it. And here's the thing. If you order a sweatshirt, you'll have double the chance as well because the sweatshirts also help us. So you can go over to gratiscafe.com, Gratis cafe.com in order. And if you're curious about free coffee shops and how we're able to do it, click on the frequently asked questions and you'll find out all sorts of stuff. Go to the homepage, whatever. There's a bunch more. And if you're a business and you want to advertise in some of our upcoming locations, the first one's going to be in Northern Virginia. We're going to do two. We'll have the first one, a brick and mortar in Northern Virginia, a small town. And then we'll also have a mobile cart that'll be roaming around Loudoun County as soon as we're able to get that up and running. So check it out. We have advertising opportunities. And to be honest, we're doing it at cost to begin with. At cost advertising. You're not going to find that anywhere else because we need to... Did this feed freeze? It kind of looks like it's a frozen feed, doesn't it? Hopefully not. It's saying it's playing back at high. But anyway, so yeah, that's it. Teresa said ordered. Yeah, a lot of you guys ordered, so we may not have that much more coffee in stock, but we have whole bean as well. So get your whole bean orders in. In our Italian roast, which is our new roast, anyone that was with Pure Truth Coffee before, you've never had the Italian roast. It's brand new. That is the darkest coffee beans I've ever seen in my life. So check it out. It's very good if you like dark coffee or Italian coffee, especially like that. You know, when I was reading the reviews from the roaster, they're like, yeah, these are like the best like espresso for like an Italian espresso because they're very dark beans. So they're good. So check it out. And then we'll go from there. He did throw another fit just like he typically does. They're going to be back in. Man, it really looks like this may be a frozen feed. I'm just going to refresh it. I guess it's just out of focus. No, it's live still. Just looks like a frozen feed to me for some reason. But yeah, it's been a crazy day thus far. Like our lunch break was incredibly enlightening for anyone that didn't get a chance to watch it. Our lunch break for the trial, we covered President Biden getting the COVID vaccine booster in his shoulder. I think this is third or fourth booster. So if he follows the track record, he'll probably catch COVID next week. That's what's happened, I think, with all of his boosters within a week or two after he caught COVID. And it's not to say, well, we won't even talk about COVID right now. And then we switched over to the Ned Price State Department press conference. That was very interesting. There was a little bit of ad-libbage going on with
this sound effect.
So obviously it was quite enthralling. But yeah, it was good. Law and Crime channel is down. That's how I found your channel, said Bridget Webb. Law and Crime channel is down, or their feed died? Hold on. Now you got me all freaking out. I should just get it back up anyway. For some reason, this feed that I tap into starts having problems in the afternoon. Law and Crime is up. So it's not love. Yeah, no. So it's just the raw feed that's coming through is just blurry because I saw it on another feed where they have it too. Yeah, see, they got to fix that shit though because you can't see it. But he is now in the other courtroom. Wrong button. He is now in the other courtroom. There, they fixed it, so it's good. He's standing. This should be interesting. So the court's going to come in a second. The judge will come back in. She's going to go on record talking about how she had to remove him. She has to do that for the record for the trial. She will then give a state a moment to say something. She'll give Darrell Brooks a moment to say something, and then the jury will be brought in because Darrell Brooks will never actually answer anything. He always pretends that he can't hear, although they've on accident sometimes left the audio on. So we know that there is audio going into that room. In fact, yesterday they had an audio tech go in there with a decibel reader, and it read 62 decibels inside there. So it's obviously quite loud. Everyone can hear it. The bailiffs, answer whenever the judge said something. He always pretends he can't hear. He pretends that he doesn't hear what the judge is saying or what the state is saying repeatedly over and over. He does have shock ankle monitors on, so he can't go too crazy. He can't act out. And I think that's doing good because I think he probably would have flipped out a little bit more. He's probably hesitant to flip out because he doesn't want to get 10,000 volts of electricity running through his body. Rightfully so. I've been tased once. We all had to be tased for the line of work. It wasn't that bad. I mean, it sucked, but it wasn't that bad. The first time I ripped out one of the tasers, so it didn't really get a good one. Second time, dropped me like a can bricks. But pepper spray and all that, we had to do all that stuff too, and that wasn't shit. Okay, but I didn't have bear mace. It was just like basic pepper spray. Anywho, that was a different life. Someone said, I believe they said Court TV was the only one allowed recording in the beginning, so all feeds must be off other than that one. No, so yes, that's Court TV's media feed. So what Court TV does is they syndicate that feed out to everyone, which is why so many people are restreaming this because granted, they could check individual licenses because so many people are grabbing the feed. It would be futile. That you will get copywritten if you have like the watermarks of Law and Crime on or something like that. But even Court TV is the media company that's in there with the actual cameras documenting this because they won the contract. All right, I'll shut up now.
We are back on the record. Appearances are as they were before, except that Mr. Brooks has been removed to the other courtroom. The court did that because we came out on the record at 2:00 following the lunch break. Mr. Brooks was brought to the main courtroom, and during that almost 35 minutes or so, he was insistent on raising a variety of legal issues with which this court has either previously addressed or which are meritless and do not warrant any further response. He is insistent on making a record and an offer of proof. This would not be the appropriate procedural mechanism, meaning an offer of proof at this time. We are not in the midst of a trial where the court's made an evidentiary ruling that would require the preservation of the record by making an offer of proof. This court has been attempting, frankly, all day to get through the reading of jury instructions, to get to the point where the parties make their closing arguments, and ultimately to put this case in the jury's hands. It has been challenging. It has been met by resistance from Mr. Brooks. I would once again describe it as being stubbornly defiant, although at times he may wait for me to make my ruling. He continues to not respect the fact that a ruling has been made, and he wants to argue and re-argue and re-argue points that this court has already gone over. And in an effort to simply put him on notice regarding his behavior, given the history of this case, the court was attempting to set some parameters regarding closing arguments so that they are focused, so that they are proper, and that they follow the law. That was met with a considerable amount of resistance and repeated statements by Mr. Brooks that he has First Amendment rights, Sixth Amendment rights, 14th Amendment rights. He has all of those rights. That is not in dispute. But those rights do not come in a vacuum when we are in a court proceeding, in a trial such as this. The rules of evidence, the rules of procedure, the rules of courtesy and decorum all apply. And this case has demonstrated that a stubbornly defiant defendant can forfeit even important constitutional rights by conduct. That includes the right to be present. It included the right to present further witnesses and testimony, and it included the right of the defendant to testify on his own behalf. I hope that I do not have to go through a decision that forfeits his right, or that makes a finding that he's forfeited his right to make a closing argument. I will certainly wait and see how that goes. I would note he was very respectful when he did his opening statement. It was clear. He made a variety of points. He did so in a way that I would say was very conscientious of people's time. It was cogent. It was concise. It was probably about 35 minutes. I may be off a little bit, but that's what my memory is. It wasn't overly lengthy. I would hope that he follows some of those same things here when he does his closing argument. But he has been removed from this courtroom because of his stubborn defiance and disrespect of this court, of courtesy and decorum. And what I truly believe is an effort on his part to continue to delay and lengthen these proceedings. I've said it before, I'll state it again. It is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. And trial courts and trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. They noted 3 constitutionally permissible ways to handle such a stubbornly defiant defendant. But they also indicated that no one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. I've noted this before. This is a case from 1970. The technology that we now have in this brand new courtroom was not available then. I have the ability to have Mr. Brooks appear from the other courtroom by way of audio and visual means. We can see him, he can see us. I've confirmed prior to calling the case that the audio was working, that the video is working. The one camera, there's 4 cameras in my courtroom, there's 4 cameras in his courtroom. However, it is set to 1 camera since he's the only individual there, other than the bailiffs, but I'm talking about as a party to the litigation. So the courtroom, the cameras in my courtroom include one that would normally be on the witness stand that has been zoomed out so as to capture the large majority of the jury box. I even adjusted the camera that's on the state's table so that the exhibit that's currently up to my left, her right, Attorney Opper, is viewable in the camera angle, and she is still present within, meaning viewable within that as well. And although I've made a finding that he has forfeited his right to be present for the state's closing argument, I'll find that the technology that I have available, it is that his appearance from the other courtroom is the functional equivalent of appearing in this courtroom and being present due to the technology that is available. I do have him on mute for the time being because I needed to make a record, and there is a very lengthy history with Mr. Brooks during this case of him talking over me and my inability to make an adequate record if I am in a constant back and forth with him and trying to talk over him. And so I, yes, made the decision to utilize the mute function on the incoming audio. I know he disagrees with my ability to do that, but I believe it is consistent with ensuring dignity, order, and decorum that when appropriate, he be muted.
Look at that picture of dignity right there.
I will advise Mr. Brooks once again that although he has lost his right to be present in this courtroom, he can reclaim the right to be present as soon as he is willing to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. That includes not interrupting the court. That includes respecting when the court renders a decision by way of an oral ruling, even if he disagrees with it. So with that, I will advise him that once the jury is brought out, I will unmute him. I expect that he will be respectful of them, and I expect that he will not interrupt as the court goes through the couple of final jury instructions I need to go through, including the reading of jury instruction 160, closing arguments of the parties. And then I will turn it over to the state, but I will unmute him at that point. So should he have an objection, he will be able to state objection. I will be able to rule on it. And again, I expect him to honor whatever the ruling that is made. And if he does not do that, then I will utilize the mute function. If he doesn't have it, we'll make sure he has the objection sign. And if I see that, I will unmute him to hear what it is and then make a ruling accordingly. Attorney Hopper.
Your Honor, two quick things. Please, could you confirm that the audio and video are working in the next courtroom? And the clerk's shaking your head. They've done that. Thank you.
I don't know if you want to do it now or at a later time, but I think we should make a record, as I will be displaying a PowerPoint during my closing argument, throughout my closing argument, and I'm not sure how that is projected in the next room or how it affects what we see in this room, Your Honor, but we should make a record of that at some point.
Thank you. My understanding is Madam Clerk has the ability so that is displayed not only here, but in the neighboring courtroom. If you would be so kind as when you start displaying it, just make some type of record, excuse me, so that the bailiff who's over there, if it's not being properly viewable, if it's not viewable, that we can stop and adjust accordingly.
Okay. Thank you.
If you would like, before the jury comes out, we could do a test.
Yes, could we please?
Please.
Yeah. What is it? Oh, it's testing time. Testing the computer infrastructure. Darrell Brooks is locked away. The judges have an asthma. The state just wants this case to go away. The jury's getting $25 a day. Yes, I said a day. The jury's getting $25 a day to deal with all Darrell Brooks and bullshit. Oh, hear that note? That was
But he would also, there would also
that shit was fire.
TV monitor above the clerk over there. Well, it's smaller, and then the very large one over the witness stand. So it would be very similar to what is here if he were present in this courtroom. And again, I know that the diagram, it's probably not the most easily seen from a camera, but it's really no different than what I'm looking at the moment. So I appreciate you asking that I make a record of that. I would further make a record that there are headphones on the table where Mr. Brooks is currently standing. He has not put them on, but they are available should he want them.
I wish you had this voice during Portland
All
days.
right, then are you turning off the
Would have been
all right,
dope.
PowerPoint? Let us know.
By the way, if you came over from Law and Crime because they suck butthole and you really like our take on this whole thing, you could support us with Cash App, Venmo, or PayPal in the lower left hand of your screen. If you beat Linda G's top donation for the day via Cash App or any platform, we will put your name there and you get a special song written with this high-pitched voice. Hell yeah! Come on down. The price is right, the water is warm, and the... whatever. I lost it. Line could... No, I'm not saying that. But support the stream, guys, if you want. Press pad. I know I saw your comment. That's why I said it. Support the stream. Help independent streamers continue to be able to break the way news reported with some kick-ass news. I'm going to make a chipmunk emoji, and I'm going to do...
the jury, please.
Oh, shit. Oh, we forgot the song. All rise. All rise. All right. The jury is coming in right now. Darrell Brooks is still upside down. Wait, what? The state is still getting ready to present their closing. I think I would pay money to see Darrell Brooks puke right now. You know who else would pay money?
Bubba for the sentencing. Darrell Brooks, pick up the soap.
No, don't do it, Bubba!
Thank you, everyone. Please be seated.
No!
Ladies and gentlemen of the jury, when I read the jury instruction to you previously regarding credibility, I had a prior version of the jury instruction. Now, what I read to you in the very beginning, or at the very beginning of this case, was the most recent. I am going to read a short paragraph, but also tell you that in the packet that will be sent with the jurors to the jury deliberation room, it will have the complete instruction, and it's instruction number 300, excuse me. And this is what I want you to know about credibility. In your determination of credibility, you must avoid any and all bias based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. Consider carefully the closing arguments of the parties, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. With that, I will ask Attorney Opper to start with her closing argument. Go ahead.
And Madam Clerk, if you'll please turn on the PowerPoint. Yes.
Hold on one second. Mr. Brooks, do you have an objection?
I thought I was supposed to be unmuted.
You are now. All right. Attorney Opper, you may start.
Thank you, Judge. Good afternoon, everybody. It's kind of nice to stand here in the middle of the courtroom. You know, all week or the last 3 weeks, they shoved me at the end of the table because I'm the lefty in the group. It's nice to be able to look at you all and say thank you. Truly thank you. Each and every one of you, I want to express our sincere gratitude from the prosecution team, myself,
Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Woodshow. There's no one in this courtroom that does not realize the sacrifice that you've made serving your community in this very important task. You've put your lives on hold. I don't even want to hear from your bosses. Thank you. You've watched these proceedings and you've noticed as we sit at our prosecution table, we don't have a client at our table. But rest assured, we do represent someone. We represent the people of the state of Wisconsin. It's an entity. I can't bring it to the courtroom. People enact laws. People want to feel safe. People have representatives in Madison or Washington, D.C. that set standards, rules that we all are expected to live by. And when those rules are violated, prosecutors step in and enforce the law. Darrell Brooks does not represent anybody. He does not have a client. Darrell Brooks is the client. Darrell Brooks is the defendant. The state of Wisconsin is the plaintiff. It's really that simple. And it's consistent with any other criminal case you've ever heard about at any other time in any other jurisdiction. It runs the same, no matter what state or federal. I'm going to ask you for your guilty vote at the end of my comments. It's up to you. I can't tell you to do anything, except I'm going to say one thing to you that I wholeheartedly ask you to obey.
Attorney Hopper, I'm sorry for the interruption. Your objection, sir?
Mischaracterization of who I am and the way it was said. I feel like it was talking down.
All right, your objection's noted. It's overruled. The state may continue.
You must not consider anything about Darrell Brooks other than his conduct in downtown Waukesha on the evening of November 21, 2021. Nothing he's done before that, nothing he's done since that. When you go back to that deliberation room, please obey Judge Darrell. Confine your comments to his conduct on November 21 of 21. Is he guilty of the 76 counts that he's been charged with? That and solely that should be your topic of discussion. So, what are the charges against Darrell Brooks? Thank you for your patience in listening to the jury instructions. They must be read for each and every count. But sadly, they can be summarized very quickly like this as far as the actual counts. Counts 1 through 6 are first-degree intentional homicide while armed with a dangerous weapon. Counts 7 through 67, first-degree recklessly endangering safety while armed with a dangerous weapon. Counts 68 through 74, hit and run causing death. Counts 75 and 76, bail jumping, and count 77, battery.
Whoa.
Mr. Brooks, what is your objection?
I have 76 charges, not 77. It's a mischaracterization of the charges.
That is correct. It is sustained. It should be count 68 through 73, I believe, and then 74 through 75, and then 76.
Thank you, Your Honor. I do apologize for my math skills. 68 through 73, 74 and 75 are bail jumping, and 76 is battery. I apologize for that misstatement. We're going to talk about counts 1 through 67 in detail. Counts 68 through 73, hit and run causing death, in my opinion, are easily summarized as this. He never stopped. Never. Bail jumping, he was out on bail for 2 files in Milwaukee County, facing felony charges there. He was ordered to not commit any further crimes. If you believe he was involved in any of the conduct charging counts 1 through 67, you should find him guilty of bail jumping. Battery, that relates to the split lip and black eye suffered by Erica Peterson. We told the story kind of backwards. We started with the battery for background. First-degree intentional homicide. You've seen this in our opening statement. You've heard it from Judge Darrell. Did Darrell Brooks cause the death of the victim, a victim? Did he act with intent to kill, meaning either the mental purpose to take the life of another or was aware that his conduct was practically certain to cause the death of another human being? Count 1, Ginny Sorensen. Count 2, Lee Owen. Count 3, Tamara Durand.
Oh, I got.
Count 4, Jane Kulik. Count 5, Bill Hospital. Count 6, Jackson Sparks. Those are the individuals who lost their lives because of the conduct of Darrell Brooks. From there, we go to reckless endangering safety. What is that? In this case, it means that through his reckless driving, he endangered the safety of other people. And he did so demonstrating utter disregard for human life. Now, behind me is State's Exhibit 15. It's also on the PowerPoint. If you choose, you may have this chart with you in the deliberation room to help you walk through each of these counts if you find it helpful. It's up to you. If you don't want it, you don't have to have it. But it will be available for you if you ask for it. And it'll take you, as we did in our presentation of the case, right down Main Street and address all the counts that were involved, all the counts that were charged. To prove reckless endangering safety, and I'm just going to go back one slide, nowhere do you see there that we have to prove any degree of injury to anyone. Never once did Judge Darrell instruct you that somebody has to be physically injured. Now, Detective Casey told you that was the standard we used in deciding of all these hundreds of thousands of people who is included in these charges. And a decision was made by the prosecution team to include people who were physically injured to be efficient in our prosecution. And so everybody up and down the street, I would argue, had their safety endangered that day. I didn't charge 5,000 counts. We selected 61 counts of people that we can identify by name in Exhibit 15 that were injured by the conduct of Mr. Brooks. Those are the people in green. People in red are the fatalities. And we presented this case to you in much the same fashion that is presented here on Exhibit 15 as to how the injuries occurred going down that street. So we are absolutely held to our burden of proof and the elements for each offense that Judge Darrell instructed you on, but we are not required to prove any injury to anybody. The question is, was their safety endangered by his reckless conduct, his reckless driving? Now, some of the groups, Pretty easy. They walked in a formation, and you can get a photograph or a diagram, and you can kind of see pretty easily who was located where, right? And you can think back to the videos that you've seen for each of these groups and remember, and you'll see them again, the path of the vehicle as it went through each of these groups. This is South Band, of course. All of these names that are being displayed on the PowerPoint Exhibit 21 are on Exhibit 15 in green for Waukesha South Band. Pretty much the whole left half of the formation was endangered by the safety of Darrell Brooks driving up the side of that band. The Extreme Dance Team. It's a little difficult to read, but again, this chart was marked as an exhibit. It's exhibit number 33. If you want it, you can have it in the jury room. The names on this chart will match the names for the Extreme Dance Team on State's Exhibit 15. All of the girls that were struck and injured as they marched with the Extreme Dance Team, plus some people on the back that were handing out candy or serving in support roles as the unit made its way down the street. The Dancing Grannies, State's Exhibit 54, the formation that they marched in, who was located where, and your recollection of how that SUV zigzagged through that group. And you can just see the names and match it up to who was injured and killed versus who wasn't. Now, one of the big things in this case has always been, why did this happen? What was he thinking? Why did he do this? Again, those are things I don't necessarily have to prove to you. His intent, I do have to prove, and I submit without any doubt there's overwhelming evidence that this was an intentional act by Darrell Brooks and an act of utter disregard for human life. I say that for these reasons, folks. Number one, first and foremost, just stop driving. That's it. It's really that simple. Not one person had to be hurt that day if he would have just stopped driving.
Excuse me, Attorney Alford, your objection, sir?
You specifically, I'm sorry, can I be heard?
Your objection, sir?
I didn't know if I was on mute or not.
You're not.
You specifically said in your jury instructions that intent cannot be, you can't look into someone's mind, I think is what it says, to find intent. So how could that be characterized as someone knowing for sure intent or not knowing for sure intent?
You're making an argument. You'll have an opportunity to do that later. Your objection's noted. It's overruled. The state may continue.
I apologize.
We showed you at the very beginning, remember our first witness was Sergeant Warner, the man who was the incident commander for the parade. We put up another map. I think it's State's Exhibit 1. You can have that if you want it. Shows all the positions of all the police officers and the reserve officers, the barricades, the squad cars. How do I know it was intentional? Because even Darrell Brooks told Detective Carpenter, I could tell something was going on downtown. No reasonable person would drive upon this area, see the squads with their red and blues on, see the officers in the street with their bright yellow vests, see all the people milling around, see the floats lining up and the participants getting ready, and not know to drive safely, slowly, and obey officers. The bears prove it was intentional. The police presence help us prove it's intentional. The parade participants help us prove it's intentional, and the parade spectators help us prove it's intentional.
Excuse me, Attorney Alper, your objection, sir?
Speculation as to what the alleged defendant said he saw. It
Sir,
was never.
Your objection's noted, it's overruled. This is closing arguments, not the evidentiary phase. Go ahead,
So
Attorney
how
Alper.
can, so how can speculation be made to what was saw? if
Your
that was never
objection's
testified
noted.
to?
It's overruled. Continue, Attorney Alper.
Honking the horn. Quite interesting that Mr. Brooks asked so many witnesses if they heard the horn honking. Some of them said they did at the beginning of the parade. Yeah, I heard a horn honk. Most of them said they didn't. The horn honking cuts both ways, folks. If he's honking his horn, that means he can see something's in front of him. That means he knows there's an object in the road. You can rely on your common experience in your affairs of everyday life. If you see something in the road and you want to alert the other person to your presence, you will honk. But you do not have the green light to then just keep going if they don't move. He knew they were there. Intent. I've skipped one. I'm sorry. Going back to my street, number 15, I failed to include the Catholic community. That's just one of the photographs showing the people that will match up to Exhibit 15 from the Catholic community of Waukesha. There's a lot of photographs identifying the people that were marching with that group. The parade started. This is the starting point, or at least near the beginning, right? This is the area. We showed some videos of the groups passing by in this area. We heard testimony from 4 different police officers standing in 4 different spots near here, telling of their 4 different efforts to stop him. Intentional. Sergeant Wanners back here testified that this red SUV blew by me. I waved both arms over my head. I'm in a police uniform. I have an unmarked squad, but I have my red and blues on. And he blew past me. He gets down here to the corner where Detective Casey is standing. Detective Casey runs out into the street, gets close enough to put his hand on the hood of the car. He keeps going. He comes down, turns onto Main Street, gets in this area of East Avenue to the south and Buckley Street to the north. This is where he encounters Officer Schneider and Officer Buttrin. They each make a separate effort to stop him, and he keeps going. 4 police officers. It's intentional. He had plenty of opportunity to just stop. Anywhere along the way, one of the officers testified to it. I think it was Officer Schneider. This was an accident, and he mistakenly wandered onto the parade route after passing all this. And he mistakenly wandered onto the parade route. At any point, all he had to do was stop. They could have paused the parade. They could have moved the barricades and escorted him out. He didn't. It was intentional. He went on for 4 blocks. 4 blocks. It was intentional. He reached speeds of approximately 30 miles an hour. That's intentional. He plowed through 68 different people. 68. How can you hit 1 and keep going? How can you hit 2 and keep going? How can you hit 3 and keep going? Didn't faze him a bit. He kept going until he got to the end, and there was no more bodies to hit. It's
Your objection,
intentional.
sir?
mischaracterization of the evidence.
Noted, overruled.
His conduct when he left the parade route, we'll get into this. His flight, his hiding, his panic, his desperation to run. Get the hell out of town as fast as he could before the cops came. That shows his intent. His interview with Detective Carpenter, we spent several hours playing you snippets of that interview. How telling was that? Never once did he say any of these things. Never once did he say, like he told you in his opening statement, it wasn't an accident, it wasn't intentional. Never said that to Detective Carpenter. No, he came up with some convoluted story about, I got a ride out here from a buddy in a tan Kia, and then I left to go meet Erica, and we got into a fight, and then I went back, and the other guy got into a fight, and he was leaving, so I took off on foot. Absolutely nonsensical story. Does not match up with the known evidence in this case.
Overruled.
He never
I
stopped.
didn't even state the objection.
This is closing argument. She may continue.
I'm going to play this slide, which is a snippet from State's Exhibit number 53. Go ahead and play with sound, please. That was just a snippet that I selected because I thought it really captured the environment that so many witnesses tried to explain to you, right? It's a Christmas parade. People are there with their families, their little kids, their grandkids, their neighbors, their friends, strangers, standing next to strangers. That's what's going on Main Street. While that's going on Main Street, this is going on. Remember this? This is the gas station on the corner of Barstow and North Street. While the units are marching down Main Street, entertaining the crowd, Darrell Brooks is driving recklessly. He's enraged, and he's arguing with Erica Patterson. Why is this important? This is important because before he even gets to the parade route, this is how he's driving. He drives the wrong way down North Street and then acts like it's everybody else's fault in the world.
Your objection is noted. It's overruled. You may continue, Attorney Opper.
When he finally pulls into the gas station, he rolls down his window and yells at the driver who's properly stopped at the stoplight that it's somehow that guy's fault that Darrell Brooks is trying to drive the wrong way down North Street. And from there, the rage continues. We get to this point, State's Exhibit number 3. Please play. The video is playing. You can see the pushing match between Darrell Brooks, Corey Runkle, Erica Patterson, and Nick Kirby. Watch this. He turns to get in the car, flips up his hood, and goes and gets in the passenger seat. I'm sorry, driver's seat.
How long are we gonna mischaracterize testimony?
Sir, it's argument. I've heard nothing improper. Your objection is noted. It's overruled. You may continue, Attorney Opper.
Thank you.
They need to know they can nullify.
That's it. He drives off onto the parade route. From this moment, right here on Exhibit 15,
they're lucky he didn't just get a public acknowledgement. He just said they need to know they can nullify.
Flips up that hood, and he zooms past Sergeant Warner, past Officer Casey, onto the parade route. Now, there's no doubt, for the first 2 blocks, he does not strike anyone. And as we've discussed, some even said he was driving at a reasonable speed initially. By the time he gets past Officer Buttrin and Officer Schneider in this area here of East Avenue, past East Avenue, and clearly once he gets past Barstow, that's where it starts, right? That's where it starts. Nicole White, our first victim, walking with Remax and the hot air balloon. Knocks her over, keeps going, runs up and over the backs of Waukesha South Band, hits the green children spectating on the sidewalk, keeps going, runs over Kelly Grabo and her daughter Adelia, walking with Burris Logistics, keeps going, plows through the entire extreme dance team just before the 5 points, keeps going, hits Deborah Ramirez and her son Isaac spectating on the south side of the street, keeps going, clears the 5 points area, hits Jane Kulik square on, causing her to go up on the hood of the car, and then fall off and drives over her body. He doesn't stop. He keeps going. Runs through the kids over by the steaming cup. We heard the parents testify about little Brinley and Kelsey and Owen that were standing there outside the steaming cup. They were struck by the red SUV driven by Darrell Brooks. Keeps going. Plows through the grannies in that zigzag fashion, striking most of them, injuring them, killing them, keeps going, gets down here to the end, and goes through the Catholic community. The witness, remember Holly Berg, she testified about that mobile gas station incident. She said she was standing down here in this area. She said, I saw 15 to 20 people fly in the air. They look like bowling pins. And when you saw the video, she's absolutely right. It's a terrible description when you think these are human beings, but that's exactly what it looked like. When does the intent exist? Doesn't have to be even for a second. I'm not telling you who set out that morning to cause this carnage. But when he became enraged back here, he didn't give a damn who or what was in his way. He intentionally went on. I'll show you. Motive. I don't know why he did this. Folks, I don't know why. Other than the rage. He's right. You cannot read minds, neither can I. But the law doesn't require you to. The law gives you a way to reach a conclusion as to what is somebody thinking, and it's right here. Decide it based on his acts, words, and statements, and from all of the facts and circumstances. I've already been through many of them. I want to show you what I mean. Look at this. Was there room for him to get out? This is way back at the beginning. This is Officer Buttrin's squad video. Way back at the beginning. That's Buckley Street here that you're looking at. Look at those barricades. Look at the sparse crowd. And there's Officer Schneider in her yellow fluorescent vest on the left side of the picture, about to run into the street and stop him.
Intent. I'm going to play this video for you because, folks, for me, this is where it becomes crystal clear. You watch this video, the first thing you're going to see if you direct your attention to the left side of the screen is you're going to see him hit Nicole White. Knock her to the ground and keep going. Now, if that was the end of the story, you may sit here and say, Madam DA, I don't know how you conclude intent from that. Maybe it was an accident. Maybe he didn't mean to do it. But watch what happens in this video after he knocks Nicole White down and tell me this does not prove intent. Please play. Keep watching the left side of your screen. That's intent, folks. No reasonable person is going to come across a group of teenagers playing band instruments, drive over them, and keep going. That's a still shot of the same thing. That's intent.
I'm sorry to interrupt your objection, sir.
How can you tell the jury what they're supposed to think?
Proper argument, your objection's noted, it's overruled. You may continue.
I will argue that it's, I would say that it's improper, and I move
Mr.
for a
Brooks, I've made
mistrial.
my ruling. I'm going to mute you if you don't follow the rules.
Exhibit
I move for a mistrial.
Exhibit 152. Clearly intentional conduct. Clearly intentional conduct. States Exhibit 93. We asked the court to take time to have you go look at this car in person because it's remarkably amazing that this damage was caused by human beings. That's intent. This is an excerpt from States Exhibit 154. Maybe a little hard to see. A lot of that laying in the front part of this photo are shoes. Remember what Dr. Vidritsky said about the shoes, and the feet, the scuff marks on the toes and the ankles? Look at all the shoes laying in the street. This is the area at the end when he ran through the Catholic community. All the shoes laying there because of the velocity. Remember, the medical examiner talked about the velocity. It's not just the speed, it's the velocity. The power that these people were knocked right out of their shoes. That's intent. The flight, the hiding, changing his appearance. He had to go through some effort, right? Crawled up in this playhouse, ditched his sweatshirt and his sandal. The other sandal seems pretty reasonable. He dropped it when he was jumping over a fence. Changed his appearance. Please play.
Excuse me.
Intent. What's he running from? What's he running from if he's just a lost guy with no ride back to Milwaukee? What's he running from as there's cops
Sirens wailing in the background. Whoops, that was me. So, State's Exhibit number 130. Put that up here quickly. Take this one. Thank you. I'm not going to go through this whole thing, folks. Suffice it to say, after Officer Skolton tried to stop the threat at that intersection at the top, Wisconsin Avenue, and he blew through the barricades there and drove south on West Avenue over to Prospect Court, cutting through the yards and ditching the vehicle on Maple. You heard all the testimony about the commotion on Maple. The eyewitness testimony from Officer Sailors, off-duty police officer who saw this, saw the defendant, Darrell Brooks. He identified him for you in this court. Get out and run from this car. And how we tracked him through the neighborhood. And again, the desperation, whether he had to ask or use veiled threats like, I won't hurt you, but I need your phone. He was absolutely desperate to get out of there until he took refuge in the home of Daniel Ryder. Now, remember the interesting thing, folks. None of these witnesses in this area knew anything about what happened at the parade. None of them. None of them were there. None of them were there. So some of them tried to help, some of them didn't. Daniel Ryder did, and it's actually probably a really good thing that he took him in because it stalled, right? It stalled them from keep running, kept them in one place until the cops could close in and get there. Now, Mr. Brooks repeatedly asked witnesses who had just watched their loved ones get struck by this SUV if they happened to catch a license plate. State's Exhibit 150, there's the front license plate. Definitely a little blurry, but definitely you can make it out. State's Exhibit 151, there's the rear plate. State's Exhibit 175, there's Darrell Brooks in his music video with the same car and the same license plate. There's the key to the Ford that was found in Darrell Brooks' pocket. There's no doubt Darrell Brooks is the person responsible for this. Because this man in this picture is the same as this man in this picture wearing this sweatshirt. And again, it's a little hard to see, but you can ask for these exhibits in the jury room if you want. The photograph, you can see this design on the front of the sweatshirt if you look close enough. This is a sweatshirt from the playset that has Darrell Brooks' DNA on it, according to the crime lab. That's him right there. That's Darrell Brooks driving off into the parade. That's Darrell Brooks driving in the parade. That's Darrell Brooks driving in the parade. That is also Darrell Brooks driving in the parade. And so is that. And he kept asking people about the tints on the window. Well, guess what, folks? You don't need to see the tints on the window when the windows are rolled down. And there's clearly one person in that vehicle in every one of these photos. And it's that man. And it's that man. And it's that man. Darrell Edward Brooks Jr., date of birth 2/21/1982, on his identification card issued by the state of Wisconsin. In all capital letters, Darrell Edward Brooks Jr. This was in his pocket when they arrested him. So this entire shenanigans that he's presented to you through his questioning of witnesses about, I'm not Darrell Brooks and that's my name and I don't know who that is and I don't consent to being called that name. It's just nothing but a distraction. It's Darrell Brooks. It's the man who drove through the Waukesha Christmas parade and killed people, injured people, endangered the safety of people.
I'm sorry, your objection, sir?
Your Honor, with all due respect, I would appreciate the quote unquote language to what does she mean by shenanigans and this and that and the third?
Sir, your objection's noted. It's overruled. The state may continue.
Well, can she tone that back? Because if that was me, if I would have said
Mr.
something
Brooks,
like
your
that, it would have been a
objection
problem.
is noted. It's overruled. These are closing arguments. There's nothing improper. It's noted. It's overruled. She may continue.
I just wanted to be fair.
You'll have an
Your Honor, that's it.
opportunity to respond, sir. Please let her finish.
So I can rebuttal?
Go ahead, Attorney Opper.
Thank you. I'm going to conclude my comments with this, folks. I'm going to show you the video, a stitched together video of all the carnage caused by Darrell Brooks, and I apologize.
It's together.
This is important that you know what he did. It's important that you think about the women like Nicole White and Kelly Grabo and her daughter and Jane Kulik, who were just there with friends and co-workers supporting a local business. The teenagers marching in the band, representing, wearing their school colors. It's important. The boys and girls with the Blazers baseball team and their coaches doing nothing more than handing out baseball cards. The young girls in the extreme dance team. Can you imagine how many hours they spent practicing that routine? He drove right through them without a care in the world. The grannies dancing their way down the street, perfect step, every one of them. Catholic community there, as Father Matt said, spreading the light of Christ in the weeks before Christmas. He snuffed it out. It's time for Darrell Brooks to stop running. It's time for him to stop lying. It's time for him to be held accountable for his actions. Darrell Brooks cowardly rammed his way through this parade. For his actions, killing and injuring so many people. I'm going to stop talking and play this video. But please, I ask you to add up the evidence. Use the map 15. You can check off the names. We've covered them all. Walk down that street like we did with you. Return guilty verdicts on all counts. Please. Please.
Screen back up.
No, I need one more. Yes, please. Go ahead.
Thank you. Before we continue with Mr. Brooks's closing arguments, I am going to take a short break. All rise for the jury, please.
Damn. The judge almost lost it a couple of times.
Am I muted?
No.
Disgusting.
The jury should know that they can nullify.
You are muted now.
She's going to admonish him. She's going to admonish him. Oh my gosh. You just said it again. What? No remorse whatsoever with this guy. No remorse.
Thank you. We'll be in recess for about 10 minutes.
It's unbelievable how someone can have zero remorse for the heinous. We've been watching this trial now for 3 weeks, every single day. I can't believe how the only time that he shed tears, the couple of times, is he felt like the court wasn't giving him a fair shake. He never once talked about the victims. He never once talked about anybody that was injured in any of his cross-examinations. In fact, he even called a mom of the mother of 4 children who were seriously injured. He called her as his witness. That to me was like one of the most like holy shit moments of this trial for me personally. Because how someone could just be so evil, I don't know. I don't know how anybody could be that evil. And he truly is the epitome of evil. He sits there and watches the video that they just showed, and I can only imagine what it was. It was the video of all the different camera angles, all the video that we haven't even seen, some that hasn't been released to the public. Obviously, it was incredibly graphic based on the crying in the crowd, the judge's face, even the detective that works for the DA that was sitting there. A couple of times he had to look down. And Darrell Brooks shows no emotion whatsoever. No emotion. His only emotion that he's showing is, I don't know, man. It's crazy. It's crazy. It's crazy. And the thing is that taxpayer dollars have to be used to keep this guy alive for the next, he's what, 38? Right? How old am I? I'm 38. So he's 40. So for the next 30, 40 years, unless the taxpayers in Wisconsin get lucky and someone decides a little bit of prison justice, the taxpayers are going to have to pay an average of $313 a day to keep him alive, let alone all the court costs related to this, let alone all of because he's going to appeal, he's going to do all that stuff, and all the time and transport and everything. It's just, my gosh, man. And I don't know what's gonna transpire with his closing. I know when they come back, the judge is going to, I think the judge now has a zero tolerance. I would like to say that she doesn't have a zero tolerance because she lets him continue doing this because she doesn't want to give grounds for an appeal. So she needs to allow him a chance to do his closing, but he keeps mentioning jury nullification. Here's what's going to happen, right? He's going to come out. They're going to go back and forth and argue about this shit again, just like they've been doing the entire time. Thank you for that, sound guy. Just like they've been doing. They're going to go back and forth. He's going to talk about how they're allowed to say things. He's not allowed to say things. And she's going to probably admonish him for the comments about nullification. Again, nullification means, and the reason why he keeps saying the jury, I'm going to talk to him about nullification. What jury nullification means is that a jury goes in there and one juror or the group of the jurors are talking about, listen, we know he's guilty of the crime, but we're going to acquit him anyway. That is nullification, saying that you're going to not pay attention to the law and acquit someone for whatever other reason. You know he committed a crime, but you still are going to give a not guilty verdict over that. That's nullification. And I don't know if it's a crime. I know that jurors can be excused for doing it, and that he can't mention nullification to the jury, which is weird. You know what I mean? Because I would have thought that was prevalent in court cases across America already. Cindy said he could forfeit his right to closing through his disrespectful actions. Yes, but I don't think they're going to do it. I think she's going to go as long as she can. Tyson on Facebook. Come on, bro. You're writing Free Brooks. I know you're just trolling with some stupid profile picture that's not you and just trolling. Just go somewhere else, buddy. I don't want to go through the problem of logging into Facebook to ban you. Just go somewhere else, buddy. What would cause a juror to do that? I don't know. Political bias? Racial animus? Anything. Anything. A juror could just say, listen, we know he's guilty, but we're not going to charge him with it. That's jury nullification. We know he's guilty, and especially if they talk about it. Because a juror can have that in their head, although I don't know how you can based on his own actions. And the court has been, or the jury has been made, or they've been made aware of some of his actions. Where she held the jury at the door today while he was having his outburst, instead of immediately sending him back, the jury bailiff came in and stood outside or inside the door while the jury was right outside. You know damn well they heard everything that was going on in that courtroom. You know. So right now, the state has officially stopped their closing argument. Well, their first part, they get a rebuttal as well. So the state has stopped. Now Darrell Brooks, when the court does come back, Darrell Brooks is going to provide his closing arguments. We saw his opening arguments. So the opening arguments were a woe versus me cry, or woe is me cry fest. He didn't once mention the victims. He didn't do anything like that. And the only slight mention of victims, which I wouldn't say is even a mention of victims, is when that tornado, the tornado alert went through. Remember? And the judge was telling everybody, this was early last week, and the judge was calling it a day early because she had to go check on her house, everyone. And he made a comment about, the state checking on the house, and he's like, even my family has to check on the house and all that stuff. Can the judge overrule a nullification if it's done? See, I don't know. There's been, it hasn't happened much where it's open nullification where they actually talk about it. I'm assuming it's happened quite a bit where people just won't, it doesn't matter what the guilt is, that they're just like, no, we're not sending this person to prison. But I know in previous case law, like in the early 1900s and 1800s, jury nullification was you get excused from the jury, even if you walk in there and you mention the term nullification. That's why the judge had such a stern response to him when he said he was going to tell the jury about jury nullification. She's like, you absolutely will not. She was very, very quick about it yesterday. He mentioned it twice in the closing arguments today versus the state. One time the state was making a comment. You could tell the prosecutor heard it. The judge maybe didn't hear it, or maybe she made a conscious decision not to draw attention to it. But then, of course, he says it again, clear as fucking day, as the court is leaving. The ACLU says jury nullification is legal. Look it up. Yeah, but it's not permitted in the courtrooms, from what I understand. And I even said I don't think it is or isn't legal. I believe I said that. I could have been wrong. We also put out a new shirt on it's still Pure Truth Coffee right now. There's no coffee on that site though, but that's going to switch over to the official shirt for my shows and all that, where it just says objection, because it's not specifically for this trial. Because here's the thing, you could object and you could wear that shirt and object to virtually every single thing that's transpiring here in America, whether you're on the right or left. That is literally the most neutral shirt I've ever made, where it just says objection in big bold letters across the front, because you could wear that anywhere. You could wear that when you're pumping gas and people will probably be like, I get it. You could wear that when you're grocery shopping and people would be like, I get it. That's probably the most neutral shirt I've ever made. And you can get that right now in the store. It's $27.99. I increased the price because everything has free shipping now. So it's $27.99. One person was lucky and got it for $25 before I remembered that I put free shipping on everything. And then that store, the Pure Truth Coffee website, that's going to be switching, and that's just going to be a store of clothes and mugs and different shit just for, my shows and things like that, which will go to support me in this effort, and being awesome, and reporting stuff. This is going to be interesting. I'm kind of interested to see what's going to happen. So I was going to look up jury nullification real quick, because I think based on her comments yesterday, is jury nullification yesterday? It's legal and so here's the Fully Informed Jury Association. Jury nullification is legal in the United States and many other countries as well. The rest of the section will discuss only the details with respect to the United States. In the United States, it's illegal for a judge to direct a jury that they must deliver a guilty verdict. Jurors cannot be punished for their verdicts, whatever their reasons may be, and a jury's verdict of not guilty cannot be overturned. Confusion over whether or not jury nullification is legal often comes from prosecutors, judges, and other detractors who wish to discourage its use. They will often strongly imply or outright falsely state, even in the instructions to the jury, that there is no such thing as valid jury nullification, or that to engage in jury nullification would constitute a violation of a juror's oath. Such harsh and authoritative seeming statements are intended to dissuade jurors from exercising their full authority as the final arbiter in courts of law, but even in appeals cases with rulings unfavorable to jury nullification, such as those allowing judges to fail to inform or to outright lie to jurors about jury nullification, courts agree that jury nullification is a power that jurors have, that they cannot be punished for exercising it, and that a not guilty verdicts cannot be overturned, even if arrived by the way of conscientious acquittal. Yeah. Supreme Court Justice Sonia Sotomayor, currently the only Supreme Court justice who has ever presided over a trial by jury, this is an old article, spoke publicly about jury nullification, saying that, the Second Circuit has an opinion that basically says that juries should never be instructed about jury nullification, and that any instruction that would suggest it is wrong. I hewed very closely to the Second Circuit line for many, many years. As I've grown more in the system and watching it, I'm not so sure that is right. See, and it's kind of like what I said in the beginning. With jury nullification, I said I don't know why that would be illegal. You know what I mean? Because that's basically saying based on your... I understand why a judge would want to say it's illegal or not permitted. But now just reading this, and granted, obviously this has got a left-leaning slant to it. Jury nullification is the source of much debate. Some maintain it is an important safeguard in the last resort against wrongful imprisonment and government tyranny. Others view it as a violation of the right to a jury trial, which undermines the law. Some view it as a violation of the oath sworn by jurors, which I guess it could go that way too, because you could think, listen, a jury could find that the evidence doesn't prove someone is guilty of something, but they may, based on jury nullification, decide that that person is guilty anyway, based on the character of that person or the way they acted in court or something else. You know what I mean? And so I understand why people or why judges would not want to have that prevalent in court. So essentially jury, and I don't know if it's ever been used in that regard, but jury nullification refers to a jury's knowing and deliberate rejection of the evidence or refusal to apply the law, either because the jury wants to send a message about some social issue that is larger than the case itself, or because the result directed by law is contrary to the jury's sense of justice, morality, or fairness. Essentially, with jury nullification, the jury returns a not guilty verdict, even when jurors believe beyond a reasonable doubt that the defendant broke the law. This can occur because a not guilty verdict cannot be overturned, and jurors are protected regardless of the verdicts. Now, do I believe that there's any chance in hell of Darrell Brooks getting even a single juror to believe that he needs to be let out of jail, and so they would have, say, a hung jury or something like that? Because they're certainly not going to universally make that determination unless they're all stupid. Again, I got to reference the truck driver in New Hampshire that ran over the 12 motorcyclists. A jury found him not guilty. He was high on crystal meth, and he literally crossed over the lines and ran over and killed 12 Jarhead Motorcycle Club members. Prior service, 11 of the 12 were prior military. Killed 12 of them less than 2 years or 3 years ago, I believe it was. A jury just found him not guilty 2 or 3 months ago, and it was a New Hampshire jury. So you got to understand that this shit does happen, and it's hard to explain sometimes. That case was a bit different because all his drug talk, his drug charges, and his drug tests and everything, the judge decided that they weren't going to allow any of that in. So instead, they didn't have the fact that he was high in meth, or the fact that his license should have been suspended, or the fact that he had been pulled over 2 months previous for being high on narcotics while being behind the wheel of a commercial vehicle and was fired for that. It does happen. It does happen. You never know what a jury is going to do. I would just hope that this jury, and I have faith that this jury has some sort of amount of credibility that they're going to find him guilty on all counts. Again, the only thing that I was thinking that you may be able to do, because intent to me means something different than what they were describing in the courtroom. And I get that aspect, okay? Like me, I would have, if it was first degree reckless homicide, then I would have no problem, whatever. But first degree intentional homicide, to me, my personal meaning has a different meaning than what it does in the eyes of the court. Because that, to me, based on what I read of the Wisconsin statute, that seemingly means that the person intended to kill. That's literally what it says in the code, the Wisconsin code, that the person intended to kill the intended target. I mean, you could make the argument, and this is what the state did, that by him striking the first person and not stopping, by continuously going through and striking, dozens more, he intended to kill those people. He knew the consequences of it. He knew that bodily harm. But my argument would be, did he intend to kill them? Because it's very specific. And they also have first degree reckless homicide, which specifically states killing someone without doing it deliberately. You know what I mean? But there is already case law in Wisconsin. There was a case in the early 90s when a brother was driving his other brother, and they were in a fight with someone a couple of days prior, and the brother shot an assault rifle, or actually that was an automatic rifle, out of the passenger seat window at two people that were walking on the sidewalk. Well, one of the bullets hit the person that they were trying to hit. Or actually, no, I'm sorry. They missed the person they were trying to hit, and they ended up striking two people. One of the bullets went through a young girl's arm and then went into another young girl, killing her. They charged him with first-degree intentional homicide, saying that because he was shooting at the first, he intended to kill that person. The other person dying as a result of that, the innocent child that was standing behind him, died as a direct result of his intent to kill someone, and they successfully did that. And that went all the way to the Wisconsin Supreme Court and was validated in the Supreme Court, because I think an appeals jury actually, kicked it back, and then the Wisconsin Supreme Court was like, nah, fuck that. This dude's guilty. He's going to jail for life. So, but yeah, speaking of jury nullification, that's what he's trying to say. If he actually understands what jury nullification means, he's trying to say, even if you find me guilty, or even if you find that the evidence proves that I was guilty of these crimes, you have the right, and it's kind of a last-ditch effort for him. He's trying to say you have the right to find me innocent, is essentially what he's trying to say, which is stupid, because, I mean, he's guilty as shit, The whole thing is it's very odd. This whole case from start to finish has been one of the weirdest cases I've ever watched, doing this political commentary shit. It's a really long, drawn out case. Even the Kyle Rittenhouse case didn't seem like it was drawn out this long. And I think they had a 14 or 15 day state's witness present, or the witness evidentiary period, whatever. And then we watched the Derek Chauvin, George Floyd murder trial, and we covered that in its entirety. And the Kim, whatever her name was, the police officer that killed, she thought she was drawing her taser. She drew her pistol. Kim Potter, that's her name. But yeah, it's crazy. No, it's not over for today. Kathleen Meade Anderson on Facebook. No, it's not over. We are just waiting right now. They're going to do closing arguments for Darrell Brooks, the defense. He's going to provide closing arguments. I'll be honest, I don't think we're even getting to closing arguments. I don't think we're going to even get to closing arguments. Here we go. So I'll shut the fuck up now. If you want to support the stream, do so. Links are over at the side. Super chats, stars on Facebook, whatever you can. I log the stars. If you want to be our top donation, which is right there. The sound's not on yet. That's why I'm still talking. If you want to be our top donation and replace Linda G, you got to kind of guess how much it is. But that's via Cash App, PayPal, or Venmo. But I appreciate everyone. If you like these streams and you want me to keep doing them, please do it. I will be doing a show tonight because we reached our goal for the day of $400. So I will be doing a show tonight. We'll talk about this trial. We may have a special guest on the show. I got to see if he emailed me. But we may have a special guest on the show tonight, and we'll go from there. But I'll shut up now and allow this court case to resume. And let's see. What do you think? Should we do over-unders on whether or not Darrell Brooks is going to immediately mention jury nullification and get admonished by the judge in public in front of the jury? I would be curious to see how she tries to admonish him in front of the jury. And those people behind him want to, that dude right there wearing the blue thing, he wants to get him. You could tell. D with a $50 Venmo. Thank you so much.
For the record
All right.
should reflect
I'll shut
that
up now.
Mr. Brooks is now present in the main courtroom. Prior to reopening following the break, I did invite him back into the courtroom, and he is here. I trust you are ready with your closing argument, sir.
I'm ready to address subject matter jurisdiction as well, too.
That request is denied.
Just for the record, I was addressing it for both courtrooms here in courtroom number, I think it's 20.
Mr. Brooks, I'm going to bring the jury out. Are you prepared to present your closing argument?
I would like for you to prove subject matter jurisdiction on the record, Your Honor.
I'm not addressing that any further than I've addressed already, sir. There's a written decision. I remind you of that.
In that written decision, did I receive, well, actually, I didn't receive anything. Was there copies made?
Mr. Brooks, I'm going to ask you one more time. Are you prepared with your closing argument? I'm going to have the jury brought out. There's no other legal arguments I need to address from you at this time.
I'm informed of what you're saying. I was merely asking, was there copies made of your, you said written decision?
Sir, my written decision has been filed into the record. That is done electronically. You were provided with a written copy previously. Are you asking for another copy of that, sir?
Yeah, because I don't have it.
As a courtesy, I'll have my clerk print off a copy and provide that to you.
Is it proven subject matter jurisdiction?
Your objection to the lack of jurisdiction has been noted repeatedly on the record. It is a meritless argument. I've indicated that in my written decision as to why there is subject matter jurisdiction, and I will continue forward with the final stages of this trial, which I hope include your closing argument and then the final instructions to the jury.
I would hope it proves subject matter jurisdiction on the record, too.
All right, I will instruct the jury to come out. For the record, the written decision is once again being provided to the
I
defendant.
accept for value and return for value this document as it is not based in lawful law. And it does not prove subject matter jurisdiction whatsoever. Refers to
He's going to get kicked out of the courtroom. That's all. That's what's going to happen. He's going to get kicked out. You watch. Guarantee it.
Not my name. Were you aware of that, Your Honor?
Mr. Brooks, the jury has been asked to be brought out. I mean, I've requested that they be brought out. They're on their way.
Were you aware of that?
Please be prepared with your closing argument.
Were you aware of that, Your Honor? Or is that a tacit agreement that you don't have to answer any questions as a public servant?
All rise.
So that is a tacit agreement.
Record to reflect the jury is coming out.
He's going to start crying. You could tell by the veins on the side of his head. This is what he did the other day.
Thank you, everyone. Please be seated. Go ahead, sir. You may begin your closing argument.
I'm not ready to begin closing arguments.
So this is your opportunity to provide your closing argument to the jury. Please start. I've started the timer of 1 hour.
I'm informed of that, Your Honor, but I'm not ready to proceed as I don't understand the reason why the questions asked before the jury was present were not answered. There are issues that needed to be addressed outside of the jury, as you always say, which I don't understand why the jury deserves.
Mr. Brooks, this is your opportunity to present your closing argument to the jury. Please do so.
I'm informed of that, but the jury needs to understand the truth, their rights, and their duties, as they have not been informed of their truth, their rights, and their duties.
Mr. Brooks, the court has begun the instruction process. I read 73 pages this morning, and into the early afternoon, I have another 30-plus pages to read.
Did you inform
They will be informed of the law.
Did you inform them that they
Mr.
can nullify
Brooks?
the law?
Mr. Brooks, you do not have that right to request that. And
Were
I'm
they
advising
informed?
you, one more time, this is your opportunity to provide your closing argument. Please begin.
I intend to when ready. I just want to know if the jury was informed that they can nullify the law.
Mr.
They
Brooks,
are-
you
that
have
they
no
have
right
the
to
power.
make that argument to the jury.
It's true. They have the power.
All right, I'm going to excuse the jury.
They should know that they have the power.
Please rise for the jury.
She's gonna waive it. He just lost his right to provide his own closing arguments. She's going to give him more chances because she doesn't want to give him any grounds for appeal. She's going to give him a couple more chances. He's going to go on a 10 to 15 minute tirade. She'll sit there peacefully and listen to him. She'll ask him 4 or 5 more times if he wants to do it. She will remove him to the courtroom and begin reading the 30 pages. I can guarantee it. Let's do over under.
Thank you. Please be seated.
$5
Mr. Brooks,
cash
you do not
apps
have
equal
a right
Brooks tiers.
to request jury nullification directly from this jury. I direct your attention to the Bjerkas case, Bjerkass, that's State versus 163 Wisconsin 2nd 549. While you are not incorrect that the jury has the power to nullify, they don't have the right to do so, and no party has the right to instruct or to request an instruction or to argue jury nullification. You may talk in terms of fairness in general terms, but you may not go further. You may not argue that the jury should discard the instructions in the law and find you not guilty for that reason. You may not use the phrase jury nullification. You've done that now at least 3 times in earshot of the jury. Twice while you were in the other courtroom, I was able to mute half of what you said the second time, and then of course you raised that once again while in front of the jury just now. You also indicated you weren't ready to give your closing argument. Sir, the time has come for you to give your closing argument. If you choose not to do so at this time, then you will forfeit your right to present a closing argument by your conduct.
I haven't made any such choice, so you can't coerce me into a constitutional right waiver when I have not waived the constitutional right, and I will not allow you as a public servant to do that. I have not made a choice.
Sir, the time has come for you to present your closing argument.
Are you making a judicial determination that you're denying me a constitutional right in
I
open
have
court
not made such a
on record?
determination as of yet, but you can forfeit your constitutional rights
Under
by
what
conduct.
lawful law?
Illinois versus Allen, State versus Anthony.
Illinois versus Allen does not reference anything pertaining to rights when talking about
In
closing
State versus
statements.
Anthony,
Illinois
the Supreme
versus
Court
Allen.
of Wisconsin referenced both that decision when it essentially extended the reasoning or adopted the reasoning of Illinois versus Allen to then find that a defendant could forfeit an important constitutional right by conduct. In State versus Anthony, it was not the right to be present in the courtroom, it was the right to testify.
Okay, so none
And
of those
the
that you
reasoning-
just named have anything to do with the closing arguments, Your Honor. You've used Illinois versus Allen repeatedly to when it comes to me being removed from the courtroom. Not one time did it bring up anything dealing with a closing statement or a closing argument. So how's that same statute being used for something that it doesn't even refer to or pertain to?
Mr. Brooks, the Allen decision, Illinois versus Allen, and the Anthony decision, which is State versus Anthony, are two examples of cases where a defendant lost a very important constitutional right because that right was forfeited by the conduct of that particular defendant.
And that was to be present in trial, correct?
The right to present a closing argument is no different. Because it is not evidence, it could be said that it doesn't even rank as high as the right to testify, which is guaranteed by the constitutions.
Which I was denied the
I'm
right
not prepared to
be
make
able to
that ruling
testify to.
here yet today, but I will tell you this, sir. The time has now come for you to present a closing argument. There will be no further delays.
It's
I
not a
will not be
delay.
taking any further adjournments for you to prepare. You were advised yesterday that this court would proceed today with instructing the jury and with the parties making their closing
And you
arguments.
made that while
It is
violating
up-
my constitutional
Sir,
right.
please don't interrupt me because
Well,
you've now
you did.
interrupted me a couple of times.
No, once. So let's
Twice.
make that correct. Once.
That's the third time.
Okay, now you can say two.
So, Mr. Brooks, I'm advising you yet again. The time
I don't
has now
consent to
come.
being called
That's
that
another
name, Your Honor.
interruption. The time has now come for you to present your closing argument to this jury. You were brought back over to this courtroom for that purpose.
I'm going to let them
That's
know.
another interruption.
No, I'm going to let them know that they have rights and they should be told, informed of the truth. It's not me
Are
trying
you
to
telling
give.
me, sir, that
it's
you are
not trying
going
to
to
give.
let me ask you a
No,
question.
hello. I'm not trying to give any
Sir,
jury
you're interrupting
instruction.
me and you haven't let me finish. So are you telling me that you are going to disregard my very clear directive to you to not bring up the topic of jury nullification?
That's not what I said.
That's why I'm asking you.
I don't understand that question because that's not what I said.
Sir, you may not argue jury nullification
I'm
to
going
this
to
jury.
inform them of the truth.
So you're going to inform them that they have the power of jury nullification.
They do have the. You just said on the record that they have the power for.
Sir, I direct your attention
You just said that.
once
Did you
again.
not just say that, Your Honor?
Sir,
You
the
said I couldn't
jury-
instruct them.
The jury
on
has
that.
the power, but not the right to nullify.
Right.
A
You said
party-
the power. You said the
Listen
power.
to me, sir. You're interrupting me once again.
So I'm going to inform them that they have the power.
Are you telling me, sir,
I'm
that
not
you are
telling you no
going
such
to
thing.
disregard
I just told you what you just said.
my directive to you to not raise the issue of jury nullification during your closing argument?
That's not what I said. You just read and said that they have the power to. That's what you just said, Your Honor.
Sir, State versus Bjerkus says and stands for the proposition that although the jury has the power of jury nullification,
They have the power.
no party has the right to argue for jury nullification.
I'm not arguing for it, Your Honor. I
In
just
that
want them to be
case,
informed. I just want them
Sir,
merely to be informed.
You can
That's
call
it.
it informing, making them aware.
Yeah, they should be aware
you
of
are
the
not
rights.
allowed to make them aware of their power to nullify. That is
can I
an
not make them-
improper argument.
Your Honor, how can I not inform them that they have a power? How
Because
can I
that
not
is not a
inform
right
them of a
that you
power that they
have,
have? I'm not giving a new jury instruction.
That is
That's not what
because
I'm
there is
arguing.
no jury instruction for jury nullification,
Yeah,
sir, because it's not allowed.
I'm not attempting to give them a new jury instruction. I'm merely attempting to inform them of the power that they have.
Mr.
That's not
Brooks,
against the law.
I'm advising you one more time. You may not raise the issue of jury nullification
I'm going
before
to
this
inform
jury.
them of the power that they have. I'm not
You are
giving them.
telling me that
I'm not
you
giving
are
them a jury
insisting
instruction.
on telling them about jury nullification. That's
That's-
what I hear you saying.
That's not what I said, though. Don't mischaracterize what I'm saying. You just read and said that they have the power. They have the power to do that. So how is
It's an
informing
inherent
them?
power that they have. They are not to be instructed on it. That is very clear in the law. In
Your
addition to, no, let me finish. In addition to the case that I just cited, I'd cite to you from the jury instructions, the law note on jury nullification 705. What that says, sir, is I'm not going to read it all. It's many, many pages. But the bottom line is it is improper for a court to allow a defendant or a defense attorney to make an argument or make the jury aware that they have the power to nullify a verdict.
And Your Honor, you just added this last night. That's why I had to sit there for an hour in the holding cell and wait for you to change the whole paperwork because I brought that up. So you never intended for this to even be an issue.
Mr.
It
Brooks,
never was brought up.
if you
But
think
then when I raised the issue, Your Honor, let me
that
finish.
I'm not prepared to deal with and argue on jury
I
nullification,
didn't say
then
that's not what I said. That's
You are
not what I
missing the
said. In
mark.
all fairness, that's not what I said.
The record should accurately reflect that you were kept in that holding cell.
Why was I kept
so
in there?
that my clerk could finish
Adding a jury instruction that was not there.
76 verdict forms, and it's ×2 because there's a guilty and a not guilty
Okay.
for each. No, let me finish.
So
You've
how did
interrupted
why did
me
I have
repeatedly.
to sit here for that where I could have just went to my cell and had it delivered? We had this
Mr.
at the
Brooks.
end of last night before you called recess.
I'm not going to debate
we had a
that
whole
topic with
we
you
had a whole
further.
conversation about
Mr. Brooks, you
me
are
bringing up about the jury
defiantly
nullification.
disregarding this court. You
Here we
you
go
can
with this.
roll your eyes
Here
at
we-
me
because
all
it's,
you want.
it's ridiculous, Your Honor. You just stated that they have the power to nullify
Would you
any
like,
law,
if you would like,
but then I
will
said
read this to you, sir, the part of the case that's important, but you're not letting me get a word in edgewise. I'm trying my best not to remove you to the other courtroom, but that is oftentimes what I need to do in order for this court to make a full record without you interrupting me. But you need to be fully aware that you may not raise the issue of jury nullification in front of this jury. It is not an allowable argument or an advisement or making them aware. However you want to describe that, sir, whatever verbiage you want to put in front of it, you may not do so. And this court has the power and the authority to limit what you say to this jury, even in a closing argument. And if you're telling me through your conduct, through your words, that you are going to disregard that direction, you will forfeit your right to present a closing argument.
under what lawful law?
Under State versus Anthony.
It doesn't refer to that.
State versus Anthony
it
may
doesn't.
not have dealt with
It hasn't dealt with closing
the right
arguments.
to a closing argument, sir, but the reasoning
You just said it right there.
nonetheless is
No.
fully applicable.
No, you
because the more
can't. You can't
general
change the law, Your
principle-
Honor. You can't change the law. That's
I'm
practicing
not
law
changing
from the
the law,
bench.
sir, but the general
I
principle.
know you used to be in legislation, but you can't practice law from the bench.
Sir, I'm
You
not
can't do that.
practicing law from the bench.
You are if you're changing. Your Honor,
I'm not
you're
making-
attempting. You're attempting to make a separate case pertain to something here that doesn't even pertain to it. It has nothing to do with a closing argument. Nothing that you just
So,
named. Not
Mr.
Illinois
Brooks,
versus
I
Allen.
would like to make a record. Would you please show the courtesy and respect for
I
me
will,
to
Your
do
Honor.
that?
I will.
All right. So looking at the Anthony case, all right, and that case starting at head note 7, paragraph 54 says the following, and you need to let me get all the way through it. We have recognized two distinct ways in which a defendant may give up his rights, waiver and forfeiture. State versus Pino is the first citation that they reference. Waiver is the intentional relinquishment or abandonment of a known right. Multiple citations there, I won't repeat them all. Waiver typically applies to those rights so important to the administration of a fair trial that mere inaction on the part of a litigant is not sufficient to demonstrate that a party intended to forego that right. State versus Soto. Forfeiture, on the other hand, often involves the failure to make the timely assertion of a right. That's a cite to the Dina case and Olano. Rights that are subject to forfeiture are typically those whose relinquishment will not necessarily deprive a party of a fair trial and whose protection is best left to the immediacy of the trial, such as when a party fails to raise an evidentiary objection. However, there is a second aspect of forfeiture, doing something incompatible with the assertion of a right. State versus Vaughn, 2012 Wisconsin Appellate 129, citing Illinois versus Allen, 397 U.S. 337. They went on, the court, that is the Wisconsin Supreme Court in Anthony. As previously noted, we have held that the right to testify is subject to waiver, not forfeiture, insofar as a defendant's inaction in asserting the right is concerned. We now conclude that the right to testify may, in appropriate cases, be subject to forfeiture where conduct incompatible with the assertion of the right is at issue. They go on to discuss Allen, which was not a right to testify, but was a right to be present. And I am utilizing the guidance from Illinois versus Allen and State versus Anthony. It directly guides this court that a defendant may forfeit a right by conduct by doing something incompatible with the assertion of a right. In this particular case, you are very clearly telling me you are going to disregard what I told you about notifying the jury about nullification. You have absolutely no right to raise that in front of the jury. It is improper. And unless you're willing to tell me you will honor this ruling of mine, then you will forfeit your right to present a closing argument. That is my ruling.
I object to that ruling, Your Honor. Object to that
Took long
ruling.
enough, huh?
Are you willing to make a closing argument, sir, that does not reference jury nullification?
I'm going to inform the jury of their power. Again, I never stated that I was making a new jury instruction. I never stated anything like that. And every case law that you just stated made no reference to closing arguments. It was all pertaining to being present for the proceedings of trial and for testifying.
Sir,
Not
what I'm
one time
telling
did
you,
you, hold on, Your Honor, with all due respect, I let you make your record. I didn't interrupt you.
go ahead.
Not one case law that you just cited made any reference whatsoever to a closing argument. Not one. So how is me merely informing the jury of the power and the rights that they have, how is that a forfeiture of being able to give a closing argument?
Well, in addition to the cases I just cited, sir, I'd also point you to State versus Bajirkis, 163 Wisconsin 2nd at 549. That's a Court of Appeals case from 1991. That is the first published appellate decision in Wisconsin to consider directly several issues relating to the jury nullification issue. In that particular case, the court very clearly said that the defense counsel in that case was allowed to talk in terms of fairness in general terms, but not to go further, and could not argue that the jury, quote, should disregard the instructions and the law and find her not guilty because it seems fair. That's a description of jury nullification. To use the words jury nullification would run afoul even more. And so I am telling you that given my inherent authority in controlling the mode and order of this court to ensure courtesy, decorum, and civility, and to ensure that this jury is presented with arguments that are proper under the law, I am hereby telling you I am in creating a rule for your closing argument that you may not raise the issue of jury nullification in any way.
Your Honor, hold up now. I'm the only one that has to be made rules for closing arguments. but not the prosecution? How is that fair? How is that balanced?
Mr. Brooks, I'm squarely faced with your defiance regarding the issue of jury nullification.
It's
that
not
is
defiance.
requiring
It's
me
not defiance.
to address this issue and to tell you very
Your Honor,
expressly
I
that that is the rule
I
for
vehemently
your
object to
closing
that.
argument.
Vehemently object to that.
Your objection is noted for the record, but
May
my
I ask
rule
for a legal
nonetheless
reconsideration of your
stands.
ruling?
That request is denied.
May I respectfully ask for, matter of fact, I reject that ruling and take exception to that ruling. For the record, may I request a legal or factual basis for your ruling?
Watch the mannerisms
Not
of
one
the guy
pertaining
behind
to
him.
being present in the courtroom or testifying.
He's a
One
Darrell
that
Brooks fan
specifically
behind him.
talks about
He was there
a closing
the other day.
argument.
All of those requests are noted. I will not reconsider. I've put my findings and my reasoning on the record, and I stand by that record.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law?
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
I'm not the forum for which an appeal would be sought, sir. I cannot
Well,
answer that.
You referred to it before.
You would need
So
to
now I'm
direct your
confused.
appeal to
I'm confused, Your
to
Honor,
a court of
because-
appeals, not this court.
No, this is, I'm supposed to be in this admiralty court because you haven't, if we're under Article 3, then we should be in common law court. That hasn't even been addressed if we're in a common law court or an admiralty court.
That's a baseless argument, sir. I don't even need
And
to
what law
address
and
it.
fact? Based on what law and fact?
It's meritless.
Based on what law and fact?
Sir, I intend to bring this jury out and give you
I'm
an
informed.
opportunity
I'm informed of that.
to present a closing argument.
Yeah,
If
but
you
you're
violate,
also,
please let me,
but
sir,
listen,
you're
you just
interrupting me
made a
yet
rule.
again.
You just tried to put me under a rule that no one else was put under.
The circumstances require that I implement this rule, sir, given your
The
stubborn
circumstances
defiance
don't.
on
Your Honor,
the
that's
issue
a
of jury
prejudice to my
nullification.
defense. You can't place me under certain rules and not place the prosecution under the same rules.
Sir, the
It has to be
circumstances of
fair.
this case and your insistence on arguing jury nullification has resulted
I
in this
haven't-
court creating this rule.
I haven't argued it. I said that I wanted to inform the jury of their power. I never once said I'm going to make an argument. I'm going to give them a jury instruction.
You may not
never
advise
said
them
that.
or make them aware in any way that they have the power
And why
of
not?
jury
Why can't they be
nullification.
informed of their power?
Because it would violate the Bajorkas decision, sir.
Violate what decision?
All right, sir, I am going to bring the jury out.
And I'm going to inform them that they have the power.
And if you do that, I will dismiss the jury and I will declare that your right to present
You
a
can't do
closing
that.
argument
Under what
has
lawful
been
law?
forfeited based upon
Then I make a
how
oral,
I've outlined that
oral
to
motion
date.
for a
I'm
legal
not going to
finding of
declare that
fact.
at this point because I want to see what you will do. But if you raise the issue of jury nullification, I will immediately dismiss the jury. You will forfeit your right
You can't
to
do that.
Present a closing
Under
argument.
what lawful law can you?
And then if you continue to
Under
interrupt
what
me,
lawful law?
you will be removed to the other courtroom as I complete
So I'm being
the
held in
instructions.
contempt again. Is it civil or criminal?
All right. Go ahead.
I apologize. May I ask the court to consider perhaps an alternative, and I fully respect the ruling the court has just made, and I understand the basis for it. We all know the defendant, in his petulance, will say jury nullification in the first 3 seconds the jury's in the room.
Objection to that.
Proper
I don't
thing
think
to
that
do,
I
I
should be
think,
talked
Your
down
Honor.
Stop interrupting
I don't
Attorney
think I
Hopper,
should be
please.
talked down to.
Allow him to make his closing argument. I will object if he misstates the law. You can instruct the jury to disregard any misstatements of the law. And we continue in that fashion, if possible, for a reasonable amount of time. And if it becomes to the point where
Wow.
there's no reasonable,
I didn't see
legal,
that coming back.
credible argument that's being made, then the court can decide as to whether or not he's forfeited his right to a
Wow.
closing argument. But we could at least try to, by merely objecting and the court telling the jury to disregard
and instructing Mr. Brooks to move on to the next topic, we could try to allow him his opportunity to provide a closing argument. If that's unworkable, then I think this record will be very clear as to the efforts of this court. And I think there is materials in the bench book, or I'm sorry, the jury instruction 705 that talk about a jury instruction this court could even give, telling the jury that they are not at liberty to disregard the law, but we're not going that far yet because, frankly, you have told them and you will tell them that closing arguments are not evidence. And I think they will abide by that. So I know it's going to require effort for the court to allow this to allow Mr. Brooks to try and proceed, but I think we should try that or something similar to that in an effort to get through this next step, or else we will continue at this pace forever.
Damn!
I'm certainly willing to try that.
Wow. I did not see the state doing that. That is
About all we
fucking
can
awesome.
Come up with, Your Honor.
I mean, I'm certainly willing to try it in this courtroom.
That's
and then
fucking
if he
awesome.
disregards that, to excuse the jury, and then have him present from the other courtroom would be the second step, and then third would be a forfeiture.
Your Honor, I object to that.
Shut the fuck up. Dude, he just won. He gets to
Your
say the
objection
jury
is noted for
nullification
the
shit.
record. That
He
will
doesn't
be the
even know
course
what
of
he's
action
doing.
that this court takes. The first time you violate the rule, you may be subject to forfeiting your right to be present, where you will give the closing argument from the other courtroom. And if you continue in a blatant disregard of the requirement that you not reference in any way jury nullification, I may make that final determination outside the presence of the jury.
I object to that, Your Honor.
Tough.
All right, with that, let's bring the jury out.
For the record, may I respectfully
good.
request the legal reconsideration of your ruling?
She just ruled on your behalf, shithead.
Like he does. Is that a tacit agreement that you don't have to answer my objection, Your Honor?
So he's going to do the same thing. Mark my words. He's going to continue
I
talking.
decline to.
The jury's going to come in. He's going to keep talking about stupid shit.
I reject that ruling.
She's going to kick the jury out.
Ruling.
That's what's going to end up happening. Guaranteed. She'll kick him out, put him in the other room. He'll bring it
For
up.
the record,
Judge.
may I request a legal or factual basis for your ruling, Your
He
Honor?
knows he's done now. He knows. The state just agreed to allow him to talk about jury
For the record,
nullification
may I
in an
respectfully
effort to
request a
finish
written
it.
judicial finding of facts and conclusion of law on this issue, Your Honor.
In so many words, he just lost.
For the record,
That's
may I
it.
respectfully move for interlocutory declaratory appeal on this matter?
I'm not the court to address that.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction, which this court has no subject matter jurisdiction.
Denied.
Under,
The jury's
based on
coming
what
in.
law or
All
fact?
rise for the jury, please.
Based on what law or fact? Because I'm going to inform the jury of their power.
All right, yeah,
They
whatever.
deserve to know.
See, and he keeps doing it. He thinks that this is going to stop the trial. They just laid it all out for him. They just laid it all out. He's going to do it. They're going to object. They'll bring him to the other room. He's going to do it again. The state will object. She will mute him, give the jury instruction at that point. They should just let him fucking speak, as far as I'm concerned. There's no way this jury is going to do it.
Thank you, everyone. Please be seated. Go ahead, Mr. Brooks, your closing argument, please.
Good afternoon. It's been a long day. First off, I'd just like to start by letting you guys know that it's a lot of information that you guys should be privy to, I believe. And one thing that I believe that you have not been privy to is the truth of your rights and your duties, being the jury. the fact that you and you alone have the power. Not well-prepared DAs with well-prepared and clearly rehearsed speeches and exhibits and a lot of theatrics. Frankly, not the judge. You and you alone have the power. You and you alone decide what is truth and what isn't truth. You should be informed that you have the power to nullify any law that you don't agree with.
Objection. Move to strike the statement.
Sustained.
Objection.
I will strike from the record the last statement made by the defendant. The jury will disregard it.
Which is clearly what I've been saying. I believe that not only is it fair, but it's essential that you be privy to all knowledge, not knowledge that certain people feel that you should hear and shouldn't hear, disguised under the color of law. The fact of the matter is, just like I did with my opening statements, I don't have a well-prepared or rehearsed speech. I didn't look in the mirror and say certain points to myself over and over again to make sure I have them right or anything like that. I've chosen to speak from the heart in my opening statements, and now I'm going to speak from the heart. What you won't hear me do is argue facts. And the reason you won't hear me argue facts is because I believe that it takes away from what should be recognized. The tragedy of this event. It should be recognized. Trying to argue facts of this, facts of that, I'm not going to waste your time doing that. It's a little emotional. I apologize for the long pause. It's hard to keep everything together emotionally. And honestly, I don't believe that I have any more tears left. It's been a hard year.
Oh, you will have tears. This is Bubba here.
For the families, mostly. And that should not be lost on anyone. It shouldn't be taken away. I said it before and I'll say it again. It's a lot of people that are healing, that are attempting to heal. That opens the door to talk about forgiveness for a little bit. With every healing process, there comes a forgiving process. It's not an easy thing for anyone. What you've been hearing from the prosecution, and not to take anything away from them, but let's call it what it is. You've been hearing a lot of rerun. Same things over and over and over. No different than when you turn on the radio and you first hear that song that you don't like when you first hear it, but they play it so much that eventually you start saying it, the words to yourself before you even realize it. And then you sit and you go, I hate that song. Why am I singing it? That's what's been happening. Rerun over and over and over and over and over and over and over. Attempting to make things stick in your head that simply aren't true. Why do I say, what am I saying? I say, look at the testimony. You know, the theme from the prosecution here has been intent, 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 intent. We all know what's been said. We all know the picture that's been painted. Even the prosecution said themselves. How can you look in somebody's head and say, this is what they intended to do? You know, for a year, I've sat and gone through this. Feeling so powerless. You know, letting other people run with the narratives. Sitting back helpless while other people paint a picture that has zero truth. Zero. I understand about healing myself, tragedy, pain, all that. A lot of it, there's no need to get into. I myself in my own life have had to do a lot of healing. As a man with children myself. I find it hard to believe that anyone who's really had conversations with me, spent time around me, would think for 1 second that this is an intentional act. I've never heard of someone intentionally trying to hurt someone while attempting to blow their horn. While attempting to alert people of their presence. Which brings me to more information that I believe that you should have been privy to. And I'm sure that the prosecution will beg to differ. But the fact of the matter is, the vehicle in question, make and model of 2010, Ford Escape. The vehicle in question, actually 2008, 2009, and 2010 of that model was in fact recalled.
Objection, misstatement of the facts, facts not in evidence.
Was in fact.
Improper argument, Your Honor.
Sustained.
Was in fact recalled. Was in fact a class action lawsuit against Ford.
Objection,
for those
facts not in
models,
evidence,
for
Your
those
Honor.
model vehicles.
Sustained. The juror will disregard.
Information that you should have been privy to. that you weren't allowed to be privy to. Why? I don't know. That information, malfunctioning throttle bodies.
Mr. Brooks, move on.
It's information that you should have been privy to. Vehicles that malfunction and accelerate not being able to be stopped.
Objection, that is.
It's information,
inaccurate.
it's
There's an
information.
Objection, hold on.
Strike.
Go ahead.
Move to strike statements by Mr.
Sorry for the
Brooks.
interruption.
They are facts, not an evidence, Your Honor, and it's a complete misstatement.
Sustained. Strike,
How's it a
please.
misstatement when I have the information?
Mr. Brooks, move on.
This is information that I feel like you needed to know. You should have known. Information that was taken away from you. Why? To prove a case? Information that you definitely should have been privy to.
He must be a Democrat to blame it on the car, not the driver. Just like Democrats with guns. Blame it on the guns, not the gunman. This is disgusting.
DA says the defendant has an utter disregard for human life. Utter disregard for human life. Not realizing that they're talking about someone that has children. Talking about someone that watched their children come out of the womb and be born into this world, cut the umbilical cord, held them before their mom even did.
Every dad in the world.
Moments that I'll never forget. And yet they say disregard, utter disregard for human life. They made reference to a rage. As if they were, or if this particular DA was right there, standing right there. As if this DA is a psychiatrist. I said to myself, what rage? What do you mean rage? How can you characterize that? How can you have the audacity to diagnose what someone's brain is? Where it's at, what it's thinking, why it thinks the way it does? DA makes references to blocks of no one being injured, but then says it's intentional. You add that up with the supposed rage, the supposed intent to harm and kill, and it doesn't kick in until well within blocks. And maybe it's just me, but I would think if I was characterizing someone with this intent to kill and this rage and this anger, then why weren't people immediately harmed? Why was someone with intent to kill and rage try to alert people of their presence, repeatedly honk their horn. You heard a detective, if you recall, testify that the vehicle that he observed was not only honking his horn, but was not speeding. So where does this rage kick in? Where does this insatiable intent to kill kick in? I speak as someone who's known someone for years. Which brings me back to the vehicle. What if the vehicle couldn't stop because of the malfunction?
Objection, fact, not in evidence.
What if the driver of the vehicle was unable to stop the vehicle? Because of that fact, what if the driver may have panicked? Does that make the driver a crazed, or not crazed, a rage? Does that make the driver in a rage and intent on killing people? DA played exhibit 17. You don't see anyone struck in that vehicle. On that exhibit, you don't see anyone struck. Was someone who had this intent to kill, this rage, as she says. If that was their intent, wouldn't they have taken the opportunity to hit as many people as they could? Target people, mow down people. Reference was made to this vehicle, the damage. Says this was all caused by bodies, but then later turns around and says hits barricades and other objects. For her testimony about hearing loud crashes and things of that nature, but the DA wants you to believe that this all came from people. Evidence doesn't support that. So I go back to trying to wrap my head around everything that's happened in the last year. Praying for those families, praying for the people that tragically lost their life, because that should not be lost either. The fact that there was lives lost, and all the emphasis has been put on the alleged defendant. And the people have been disregarded. Makes me wonder, does the DA even care about those people?
Never once said sorry. Not once.
There's been prayers going up every day. It's been suffering on both sides.
Oh my God.
It's been threats, hate mail. Because of the narratives that's been put out there. The misconceptions that have been put out there, the lies that have been put out there, lies that have caused my children not to be able to go to school, to be bullied, for my mother to have to leave her home and stay at a hotel because she's afraid for her safety, because she gets hate mail shoved through her mailbox. My nieces and nephews to fear for their safety. And what's been equally hard is not only having to answer the questions from my daughter, who was 7 at the time, my baby girl, who was 7 at the time, is now 8. Attempting to answer her questions that she's asking and still continue to shield her from what she sees, what she hears. Having a newborn son that I haven't even been able to meet. Haven't been able to hold, touch, kiss. Having to navigate everything that comes with this whole situation. While still attempting to wrap my head around it. I can't honestly say how many times I've sat in my cell, especially during lights out, alone, where it's just you. And just been praying and asking myself, how could this happen? Not just for the people, but for everybody involved, the community too. How could this happen? How? The hardest questions you can ask is those that don't have an answer. No matter how much thinking you do, no matter how much you try to look at it from different perspectives and listen to other outside perspectives and listen to people that you trust and that you love, still coming up with nothing. But to think for 1 second, one question I never had to ask was if this was intentional. That's something that I never asked once. Because I know it wasn't. As a matter of fact, it never even crossed my mind to even attempt to ask myself that, because I know it wasn't. And I know sometimes during this trial probably doesn't show. May be hard to believe. But trust me when I say no one outside of the families that had to go through this, no one's heart is more in pieces than mine. So again, I go back to all these exhibits. Go back to everything that's been shown, everything that's been testified to. Everything you've heard during this whole process, this trial. And again, I say the same thing that I said earlier. Same thing I said in opening statements. I'm not reading from any paper, any books. Everything you've heard in opening statements, everything you're hearing now is from right here. Everything. You have the decision. You and you alone, all of you, you have the decision. I'm sure you've taken a lot of notes during this process. Some days are longer than others. A lot of movement in and out of the courtroom for various reasons. Remember the power that you have. Don't for 1 second let it be taken away from you. I can never understand the position of sitting on a jury in something of this magnitude. So I'm sure there's a lot of pressure. I pray that the right decision is made. The right decision. It's almost like that a message, well, not message, but that writing when we're in our vehicles and we have that rearview mirror and it said things are closer than they appear. But it's also another way of saying sometimes things aren't as they appear. I can't speak for anyone else, but me, myself, I believe in Jesus Christ.
No, you do not.
That's how I was raised. That's what I believe in. None of us are perfect. But I try every day to make sure that I acknowledge him. That's why every time I step in this courtroom, I have my Bible with me everywhere I go. I even read it on breaks, recesses. This is not something that started at the beginning of this incident. This is something that has been instilled in me since I came out of the womb. This is how my family lives their life. This is how we was raised. For whatever mistakes that I myself have made in my life, I've made peace with God. Made peace. I'm happy to say that my conscience is clear.
Dude, I can't even deal with this anymore. His conscience is clear. He never said sorry. Oh my God.
And because I believe, I trust him with my life. Nobody will never know why it was his will for this to happen. A lot of lives were changed that day, mine included. God's way is not our own. And no matter how much sometimes we want to question, we have to have faith. Look inside yourself. Look inside yourself and make the right decision. Look inside your heart. You have everything in your hands now. everything. Do what's right. Do what's right. Don't let the smoke and mirrors take away your power. Don't let the theatrics take away your power. Each and every one of you has a decision. It's right. Make the right decision. It's hard to think about my younger kids getting older and at some point having to explain everything to them. Kids don't stay kids forever. And nowadays, kids is frankly a lot smarter than we were when we was kids. I'll tell you that much. I got a letter the other day from my youngest daughter, and she's still learning cursive right now, so she's the best writer when it comes to cursive. She'd rather print. She said, "Dad," and this is from the letter. She said, "Dad, why are people saying all these mean things about you?" I haven't read the rest of that letter yet. The rest of that sentence said, "That's not the dad I know." Throughout this year, I've been called a lot of things. And to be fair, I am a lot of things. A murderer is not one of them. Never has been, never will be. So before I close my statements, I just want to say, open your hearts. Go inside yourself when making this decision. Have no fear. Pray and do what you know is right. What you know is right. Think about everything you've heard. Think about everything you haven't been privileged to hear. Think about the whole entire picture. And above everything, whatever you decide, make sure you yourself can live with it. Make sure you can live with it. That's the magnitude of the power that you have. Just like this tissue is in my hand, this is everything. You have everything. Be at peace with what you decide. Had no regrets. Don't let this decision weigh on you after it's over. Hopefully we got a lot of living ahead of us. Lord willing. Don't look back and kick yourself in the behind. It's been about 3 weeks with you. And it took a lot of courage and a lot of guts to pause your life for this. To put important things on hold, to to basically stop your life. You should be commended for being able to sit up here with this amount of pressure. I want you guys to know that's not lost on me. I'm sure it's a lot. And you all should be commended because it took courage to do this. I don't know, but I would bet a lot of people wouldn't want to be sitting in your position right now. And you guys had the guts to do it. Thank you for that. Thank you for taking pretty much a month and setting it to the side for this. I know it's probably not proper, but you guys deserve a round of applause if you could get one. Thank you guys sincerely. And I know, and I have faith and I trust that you guys know what's right. Ladies and gentlemen, I don't think it's fair to just say guys, but I believe in your heart you know what's right. Thank you.
Thank you, sir. Before I give the state an opportunity to present rebuttal, please stand for a minute. So please stand.
I would like to point it out, he never once said sorry. This should be the easiest rebuttal. If I was the DA, I would stand up and say, I just have 4 words for you. He never said sorry. That's it. Not once. Not once. This is by far one of the most disturbing and disgusting things I've ever seen in my life.
Closings, you have 13:28 left.
Thank you, Judge. I don't think that'll be an issue. Folks, let me just say this. Mr. Brooks stands here and professes to speak to you from his heart. He plays on your sympathy. He talks about his children. He talks about the hardships that he's encountered and his family's encountered. And he brushes over the loss to the community. He wants to talk about how he's never held his newborn son. Never once acknowledges the Sorensen family, the Owen family, the Duran family, the Hospital family, the Kulik family, the Sparks family. Never once. It's nice that Mr. Brooks can get letters from his loved ones. I don't know why he did this. I told you that. But actions define a person. It's that simple. You can stand with the Bible in your hands all day long and profess to be the finest man under God that you can be. But when you drive through a parade route and roll over children with band instruments to the extent that your vehicle heaves up and down, your intent is known, Mr. Brooks. It doesn't have to be guessed. It's known. You don't have to stand and wonder as he claims to. For him to keep going after he drove over those children in the band and have Jackson Sparks fly off the front hood of his car, lifeless, and keep going. And have Jane Kulik fly off the hood of his car, run her over, and keep going. I'm not going to go on. You get it. You need to look in the mirror, Mr. Brooks. If you want to accuse me of practicing my closing argument, you need to look in the mirror, sir. Your actions are that of a murderer. You murdered these 6 people. You endangered the safety of 61 others. There are 68 victims in this case, folks. That's not an accident. That's not a, gee, I woke up one day and don't know how I found myself in this position. If you have some explaining to do to your children, Mr. Brooks, I recommend you do it.
Objection.
Now, members of the jury, the duties of the parties and the court have been performed. The case has been argued by the parties. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence. I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 76 forms of verdict will be submitted to you concerning the charges against the defendant, Darrell E. Brooks. Count 1. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 2. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 2 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 3. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 3 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 3 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 4. Excuse me. Count 4.
All right. While this is going on, because this is going to take approximately an hour. Okay, so what I'm going to end up doing is I'm going to kill all the feeds, and then we'll come back, and I'm going to change the title, but I need to switch the overlays, and the YouTube feed's going to refresh here because we've been live for 10 hours or 9.5 hours. So I have another hour, but her going through this is going to take about another hour. So I'm going to kill the feeds. I'm going to come back. We'll have it live. So give me like 5 minutes. We'll have it live again. I just got to restart all the feeds. And yeah, So that'll be my evening show as well. All right. So just give me like 5 minutes, okay?